Good morning, good morning, good morning, amazing law nerds. We are streaming on a Monday. I know, it's January 26th, 2026, and, well, I'm figuring most of you are probably stuck inside, so if you've got power, I figured it was time to just go ahead and do a stream as we're trying to catch up, because if you caught the Emily Show podcast this week, then you would have caught the tidbit that we learned at the end of what seems like it was a very, very painful day in court on Friday, because at the end of the day on Friday, Judge A gave the lawyers the what's for and the who's what's and the get it together before you get back here. But Fairfax County courts are closed, like courts, I think, just about, well, everywhere that's not the West Coast, because everything is closed. So because we are here, we can get caught up. And on Friday, which is day 7 of court, we are covering day 5 today, but Friday was day 7 of court. At the beginning of the day, they were doing jury instructions, and we heard them talking about jury instructions a few times already. So by the time they got to Friday morning and they were doing the jury instruction conference, they were going over those and talking about what to expect. And the prosecution's like, well, it depends if the defendant's going to testify. And the court's like, is the defendant going to testify? And the defense is like, yep. And everybody went, and then here we go. So my goal is to try to get us caught up before court is back. I don't know when Fairfax County is going to open, but because Friday was such a wild day, we're going to be consolidating that day as much as we can. But today we're going to get through day 5, and then we'll figure it out and go from there. But based on the conditions here in Middle Tennessee, I'm not leaving my house anytime soon. So as long as we have power and internet, we're still here. If you haven't caught the Emily Show podcast from this week, you can go catch up with that. And for everyone who's impacted by, well, how much more can we be impacted by? How you doing? I mean, sure, Stormageddon. So for all of you impacted by the ice and the snow and the power outages and the rest of it, hang in there. I know it's much. I woke up this morning and it was like, good morning. It's 9 degrees, which is not normal for Middle Tennessee. We don't always get that cold. So it just is what it is. But you're going to notice that there is quite a lot of light on my face today. I can't close the curtains in my office because all of the birds are out in front of my office. And that is where Fred and George are sitting today. So the cats have taken over the window to the world. But because there is actually still snow on the ground, you're going to notice that the reflection is much different than normal. But I cannot disappoint the cats. So, when the sun goes away in a little bit, it'll change. But I can't tell Fred and George that they can't sit and watch all of the birds outside the house. So that's what they're doing. They're having the best time. So yep, it just is. And we're rolling with it. We're going to go to court. We're going to catch up on day 5. We are going to be on 1.25 most of the day and hope for the best. So let me know what you're coming in from, what your weather conditions are, what you're drinking. I have a cappuccino that I made, brown sugar. I made brown sugar syrup. It's not impressive. I felt fancy though. You just boil things. But for everyone that's going to ask, this is the Year of the Dragon Cup from Starbucks. None of their cups have been as good since this one. Their Year of the Horse cups are not nearly as cute. So also, what else? For everyone who's excited about football, congratulations. For everyone who's sad about football, I'm so sorry. It'll be better next year. The snacks will always be 10 out of 10. Yeah? All right. Let's roll the intro, and then we need to go to Virginia and go to court. I mean, we never left Virginia. We're snowed in Virginia at this point because, if you're trying to fly into Nashville, that's probably not happening. So yeah, we're going to hang out in Virginia.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
Oh, I muted myself by accident. All right. Emily, your mic. I know, it's a central feature of this courthouse, apparently. We left off in court on trial day 4. We are joining in for trial day 5. The defense had made their motion to dismiss at the end of the day. The court had denied it. They had a weekend break, so I believe in real time. So we are coming back into day 5 after a weekend break for the lawyers and the jurors, and we are beginning the defense case in chief. The prosecution has rested. There were a few things I was surprised by. They didn't really call anyone to do digital forensics at all. They had the co-defendant, Juliana, the au pair, say, yes, these are the messages we sent, and yes, this is the account we set up, and did a lot of that foundation through her, but they didn't go through her phone. They didn't even bring in the defendant's phone. Where was the defendant? And I mean, maybe it's because they knew where the defendant was, and we've got a timeline based on the 911 calls and the video at McDonald's, but for a case that involves, was a fake account created to lure someone to the house, there was a surprising lack of digital forensics. And I worry because the prosecutor has been almost off-puttingly casual. And I'm trying not to be super critical, but this is where I start to feel like back in my day, which I hate, but also here we are. The prosecutor's interactions with the court have been quite casual, and it almost feels that the prosecution is maybe overconfident in the testimony of Juliana. Now, if the jury believes Juliana, the au pair, look, one witness, if believed, is enough to establish any one fact. If the prosecution really wanted to, I don't know why they would, but in theory, they could have tried this case with Juliana, the coroner, because you do have to prove that somebody passed, and maybe one law enforcement officer, maybe, and I think the victim's father. So they could have done it that way. That would have been wild, but they could have done it that way. I just worry that maybe they are super confident in her testimony. And again, if believed, then she is enough to establish any one fact. Where my mind changed a little bit on that was with the victim's father's testimony. The victim's father's testimony was one of those moments in court where I was just like, wow. Victim had a blood disorder. He was not allowed to give the medical terminology for it. I'm not going to guess at that, but he was not allowed to give the medical terminology. And I'm surprised that the prosecution didn't bring in a doctor to do that, but whatever. But the victim had a medical condition and a blood disorder that caused her to bruise exceedingly easily, which probably answers some questions from the coroner's report, and to have a difficult time clotting and not having excessive bleeding, something she had to take precautions about when pregnant and giving birth, something she had to take precautions of when little. And I think the key takeaway from me in that was when her father said she could not be involved in any contact sports. That was something that could cause harm to her, talked about a risk for internal bleeding being devastating for her. So when you look at where I think the defense is going to try to go with, well, no, the victim set up the liaison with Joseph Ryan, the things that were being asked for in those communications do not track with the things that we know about the victim. So I'm real interested to see how that's going to go. And perhaps it was not the blood spatter expert, but perhaps it was truly the victim's father that is going to be the thing in this jury where all the jurors just look at this and go, there is no way this victim is doing the things that you want us to believe that she is doing. It's not believable. And when the jury gets charged with this case, if there's two reasonable explanations, you have to pick the one that points towards not guilty. But is Christine Banfield setting up this encounter with Joseph Ryan a reasonable explanation? And the jury is going to have to ask themselves that. So today, we're getting into the defense case in chief because, oh boy, Saint Neverer 76 the husband wouldn't know that. They talked about the fact that the precautions were taken during her giving birth, and that this was discussed and that the husband was present in that room. So, yeah, I think the husband would know that because it would be something that they would have to be mindful of during not just pregnancy, but during delivery as well. And I imagine it's something that they would talk about. I don't know if there is a genetic component to that, but something they might talk about with regard to their child as well. So I can't fathom that the husband didn't know based on the testimony we've seen. Which makes it real interesting if he was the one setting these things up. Then again, when you try to put sometimes men in the heads of women, they don't always get it right, do they? So we're just going to have to wait and see. And I have talked so long that I think we just need a flight to Virginia to kick off this snowy, icy Monday morning. All right, we are back in the court of Fairfax County, Virginia. Judge Ascarati presiding. Unfortunately, we're not going to see her throw anything at the attorneys, which would be really satisfying. Can you imagine if they gave judges like red flags like they have in sports and they got to just like throw a flag into the well? Emily, no, we're not turning into idiocracy. But could you imagine if the judges were just like pulling the red card like in soccer or like throwing a flag on the field like football? 10 out of, it would be 10 out of 10. It would be 10 out of 10.
Good morning. Good morning.
Good morning.
Do we have any preliminary matters before the jury comes out? Yes. Could you put your microphone on for?
Do we have any preliminary matters? Your mic. Counsel, your microphone.
For me?
I have a motion.
Yes, your motion?
The defense has a motion.
Your Honor, this is a motion to dismiss the trial pursuant to due process for.
You just did that on Friday, but this is not based on lack of evidence. He's basing this on other grounds. What grounds are those, counsel? His grounds are due process. I'm not going to put this up to 1.25 yet while he does this motion, and then we'll go from there.
Requirements of the 14th Amendment of the United States Constitution for the Commonwealth's knowing use of false testimony tainted the trial and must be dismissed pursuant to NAPU versus Illinois. I have the cases, Judge, and I can submit those to you.
Anybody else's brain just go, Apu. Anyone? Anyone else? Just my brain? Motion to dismiss based on the prosecution. The defense is alleging eliciting false testimony.
I've given some to counsel.
Okay.
Unlike a motion to strike where we're talking about the sufficiency of the evidence,
Which was
now
last
the
week.
defense is making a motion to dismiss under NAPU versus Illinois. This is incumbent upon the moment that you realize what the violation is. And as of yesterday, when the Commonwealth closed with no detectives, with no evidence relating to the digital forensics, evidence relating to the catfish, which has been what
the judge's face kind of tells you where she's at with this. I don't disagree that not having digital forensics raises an eyebrow. I don't think it's willful, misleading testimony. But Joe J's face kind of lets us know.
they've said all along. It was at that point when they rested that this became incumbent upon me to make this motion. Usually this motion is made in conjunction with a Brady request that's not complied with. It stands for the proposition that if the government knowingly uses false testimony, the trial is tainted, not just for credibility issues, and must be dismissed. In this case, and actually in Napu, the government failed to correct the testimony of a witness co-defendant who stated he was given nothing in exchange for his testimony when the prosecutor knew he was to receive favorable treatment from the sentencing court. This knowing falsity was enough to taint the trial, requiring reversal.
I mean, that's not the situation
For
here,
this, a
counsel.
bit of background is required. In September, the Commonwealth gave me a list of probably 65 witnesses That was the last filed witness list.
It's a lot of witnesses.
With,
There's a lot of witnesses.
That was probably when Mr. Kling was still on the case. There was no, pursuant to the discovery order, any witness list filed for the Commonwealth. It was only when I reached out that I was able to get a list of some names that they potentially might be using, of which Detective Miller, who's the digital forensic detective, was not on there, nor was Detective Bryant. In fact, there were very few police.
Okay, so if the witnesses aren't on there, it means they don't intend to call them. They don't have to call every witness. And not putting them on the list really indicates that they're not going to call them. Okay.
These witnesses, other than Detective Leach, who we did hear from. As the court notes, you've had this case from the beginning. You've seen the battles for Brady material, which we know were violated, because ultimately what came was concluded to be Brady and was known to the Commonwealth back in November of 2024. In fact, even before that. Speaking specifically as to...
did you get the information in November 2024? Because if you did, then...
The things that were known or should have been known is Detective Miller, for Fairfax County digital forensic expert at the time, did an executive summary that was in the October timeframe. In that, he says that Christine Banfield, he concluded that Christine Banfield never lost control of her devices. And it was...
Well, you have the reports, so you can call the witness, though. If they hadn't given you the report, that would be a problem.
She was reaching out to Mr. Ryan and others on BDSM websites, thus thwarting the theory that...
I stepped in the middle of his sentence. He's saying that Detective Miller wrote an executive summary saying that Christine Banfield never lost control of her devices, and she was the one setting up the encounter with Joseph Ryan.
Christine Banfield never lost control of her devices. And it was she who was reaching out to Mr. Ryan and others on BDSM websites, thus thwarting the theory that the defendant was part of a catfishing scheme to lure Mr. Ryan to the Banfield home to set up a double murder. Detective Miller's report was sent to be peer-reviewed, as the chain of command did not like its findings. That peer review was concluded and they concurred with Detective Miller's report.
I don't know how a digital forensic expert can say who's at the keyboard. And I did a lot of digital cases. I liked paper cases. I liked cases with digital. You know why? Because when you need to bring in a cell phone to testify, it doesn't say, fuck you, bitch, I'm not saying shit. It is what it is. But I have never seen a digital forensic expert say that they knew whose fingers were on the keyboard unless there was like video of the person doing it at the same time. I've never seen that, ever. So I don't know how a digital forensic expert would say whose fingers at the keyboard. Generally, what you see in digital forensic reports are the user of the device. And then how do you determine the user of the device? We saw things like this in the Duggar case, when they were trying to show that Duggar was the one who was at the keyboard. They were showing that he was the only one at work, that the computer had a desktop image or wallpaper image that was his family, that his passcode was his date of birth, and that the passcodes were being entered into his bank account and what the bank account passwords were and things like that. So it's interesting that they are trying to argue whose fingers are on the laptop. Bug Riley said, would Face ID help? Yes, it would, though cases can or phones, I think, can have multiple profiles, but biometrics would help. Like if you had a laptop where you needed your fingerprint to unlock it, it would help indicate that for sure. Same with Face ID. But we're talking about a laptop. We don't even know if the laptop has a passcode on it. I would guess yes. However, we don't know. We haven't heard any of that. So we'll see.
This was known a year before Mr. Banfield's arrest and coincided with Juliana Perez Magalhaes' arrest. During the almost 1 year that Juliana remained in jail, Juliana's counsel requested 2 continuances and never secured a digital forensic scientist.
So
and it's unknown if
that's on her lawyer. Her lawyer who was being paid for by your client's mom.
he knew about Detective Miller's conclusions at the time that he decided to take to advise his client to take the actions that she's taken. When the co-defendant decided to accept the reduced plea for time served, and her mother counseled her to take the plea and blame it all on Brown.
I'm just going to remind the chat in case any of you didn't see any other days. She is not guaranteed time served. Time served is the recommendation the prosecutor said they would give under certain conditions. However, the court can give her more than that. It is not a guaranteed time served, just to assuage any concerns.
Brendan, there was a highly unusual event for Fairfax County wherein the lead prosecutor for this case, Eric Klingen, questioned and interviewed Juliana in the presence of her counsel and some police detectives. In that video interview, she gave a...
So when Juliana was getting ready to take a deal, there was another prosecutor. Also, he says that's unusual for Fairfax County. I also have not seen a proffer for plea deal because cops can't offer a plea deal. It has to come from the prosecutor. The prosecutors are involved in that. I have not seen proffers that don't involve the prosecutors. So, yeah, the prosecutor needs to be there.
Statement in which multiple occasions of reversions did not line up with digital forensics and could not have occurred. Detective Miller was then pressured by the detectives in the case to alter his findings to fit Juliana's story, to which he declined and prepared his summary for the homicide unit.
Well, this
he was
makes
then
sense.
Transferred without a request to the child exploitation unit.
This makes sense why his opening talked about officers being transferred. I'm interested to see where this develops. Very interesting to see where this develops. For those of you coming in, no, the jury's not present during these arguments.
It can be concluded that as of October 2024, the police and the Commonwealth attorneys knew the evidence did not support the catfishing theory. When in October 2025, when she gave her first recant, there were police and prosecutors in there, yet the prosecutor was the one that was questioning. The absolute unprecedented upheaval of the homicide division has been well documented and
Judge A's
is
face
directly
is not
related
impressed.
to this catfishing theory that was pushed upon and also by the unsupported evidence. At the defense motion for bill of particulars in September, the court asked, is this still a viable alternative for the Commonwealth to prove catfishing? And the Commonwealth committed to that. However, as the evidence ends.
Sir, you've said a lot of things that are like seemingly a defense case in chief, but you haven't shown anything that seems to indicate Brady, though. Is the false testimony that you're alleging in the room with us, or are we going to get back to it?
Yesterday, Judge, we have nothing but Juliana Perez Magalhaes. That's, as to the motion to strike, I understand the court's position, but these findings and the evidence to support the finding that the Commonwealth knew or should have known is it within every aspect of this case at this point. This is essentially a lack of candor issue, Judge, with the court, and it's in violation of Virginia State Bar Rule 3, which requires candor with the court. Rule 3.8 requires the Commonwealth be the minimum.
Also, I had to go back and look at the notes. This was actually last week in court Wednesday. I think I said at the beginning it was over the weekend. I thought it was. My brain has conflated the two. But this day of trial, day 5, is from last Wednesday, the 21st. So right as we were getting caught up.
Mr. Justice, not just an advocate.
I'm with Judge
Further,
A.
3.8 requires a prosecutor to withhold indictment if there is no probable cause. At
Yeah,
the time
obviously.
of Mr. Banfield's indictment, the police knew about Detective Miller's findings, and Ms. Perez Magalhaes had not changed her story and accepted the Commonwealth's plea deal.
That's a critical point to me. And I'm curious to see if it's developed more. But at the time that his client, Brendan Banfield, was indicted, Juliana hadn't flipped yet. I have a whole bunch of thoughts about that. But Juliana hadn't flipped yet. And I think that Juliana was perfectly happy to sit in custody with, well, I don't think she was perfectly happy to sit in custody. I think if she was going to be in custody, she was perfectly happy to still be all, baby, I love you, and have his mom pay for her commissary, have his mom put money on her books so she could talk with her family, have his mom help liaise with her family, have their support, still be talking to dude, and have her lawyer paid for. I think shit went sideways when he got arrested, and she, I imagine, I wish we would have gotten some questions about this when she testified. I imagine the second that he got arrested, either her cellies or her mother said, this dude is going to throw you under the bus. And the only way to save yourself is to tell the truth. Because now that he's in custody, all bets are off. As long as he's out of custody, fine. Baby, I love you. Everything's all good. The second he's in custody, all bets are off. All bets are off. And I imagine she had quite a lot of panic over, is he going to go tell them what I did? Because when he's at McDonald's, where is she? With her cell phone and a gun in her pocket. And the 4-year-old. She's on the same street. She's in the cul-de-sac. He's not. She is. She's on the computer chatting with Joseph Ryan. She's the one on the phone with Joseph Ryan. She's using the Signal or Telegram calls. I bet she realized that she was the backup fall guy. So yeah, him getting arrested definitely hastened her plea deals. Nobody asked her about it. But I guarantee you that part of her thought process was, it's him or me. And honestly, I think if she had just said that to the jury once he got arrested, I knew he was going to try to have me go down for it, and it was him or me, and I picked me. I think jurors would understand that thought process. Jurors aren't going to like what she did, but two things can be true. You can dislike everything that she did and still think she was telling the truth. So, curious. Jammy Mama in the chat said he only set up an alibi for himself. Mushroom Mom said, but he paid for the windows. Yep. And there's that big gap in 911 call. Anyway, the timing that he got arrested before she flipped, I think is fairly significant. It didn't come up much in this trial, but I think it's significant.
These ethical requirements have not been met. But more troubling is the presentation of false evidence by the co-defendant.
Oh, what's the...
It is analogous to a prosecutor presenting the testimony.
I disagree with his argument. So he's saying that Juliana just got up there and lied and lied and lied. And it's true. Lawyers can't knowingly present false testimony. But I think the prosecutors believe it went down the way she said it went down.
These ethical requirements have not been met. But more troubling is the presentation of false evidence by the co-defendant. It is analogous to a prosecutor presenting the testimony of a victim in a rape case, knowing the DNA exonerates him, but doesn't present it. This known falsity denies the
Those two things are not the same at all. That's not analogous. That's not analogous at all.
defendant a fair trial. This should be dismissed pursuant to NAPU versus Illinois as violator of the 14th Amendment.
Sir,
And
a
there are
neti
additional
pot would
cases,
also
Judge,
help.
which I have for your review, which are closely aligned with NAPU, which is the seminal case.
Yeah, I'm familiar with those cases. Thank you, Mr. Carroll. If you want to,
Would you?
that's fine. Yes, ma'am.
Thank you.
Thank you.
The closed captioning, picking up all of the bodily functions, is hilarious to me. The all of it.
Your Honor, counsel has highlighted the Commonwealth's witness list containing 65 people, most of whom we did not call. I expect the same to be true of defense, and that is the nature of a case. When we want to make sure that we do not limit ourselves should evidence be required, we list a witness on that witness list, which is provided to the court well in advance of trial. In this matter, we call the witnesses that we believe presented the evidence clearly to the jury. We have presented the physical evidence collected, we've presented the DNA analysis, we've presented the blood evidence, and there is no requirement that we call a lead detective to present a narrative when we in fact have the person who was in the room to present that narrative. In this case, counsel argues that Juliana Perez-Magales presented false testimony. That's a matter for the jury. Counsel simply doesn't like what she said. That doesn't make it false. At this point in time, Judge, I don't believe that there's any.
I'm sorry, counsel. Sometimes those things get conflated in 2026. Yeah, just because you don't like it doesn't mean it's wrong. Yes, counsel. Yes, yes.
Merit to this motion, and we would ask you to deny.
All right. Anything further?
No, Your Honor.
All right. I am familiar with the NAP cases and their prodigy. And the NAP cases are a little different from here because in those cases, they're based on a prosecutor's failure to correct testimony that he knew to be false. That's not what we have in this case. There's no evidence the Commonwealth is using false testimony. It's just the weight of the co-defendant's testimony that does go to the jury. I don't have any Brady violations at trial at this time, and none have been alleged. The Commonwealth has presented their evidence, which has survived a motion to strike.
For those of you asking, Emily, Brady violations, CEG day 3 of the Alec Baldwin trial. Those be the Brady violations, which is generally withholding information from the defense. There's a lot more that goes into it. We went through all the prongs of Brady there, but the court's like, no, the prosecution didn't withhold anything from you. Also, putting 65 witnesses that might testify on a witness list and not calling them is not Brady. That is disclosing more and calling less. So she's like, no, there's been no Brady. There's been no Brady violation here. There were numerous Brady violations in the Rust cases. Numerous. The court's like, no, there's been no Brady violations here. So I think the defense was trying to make fetch happen, saying, but the co-defendant's testimony is a Brady violation, but that doesn't even make sense. So.
But I cannot find any violations of the 14th Amendment. At this time, the co-defendant did provide testimony as to a catfishing theory. The way the Commonwealth puts on their case is up to the Commonwealth. I don't have any evidence or showing that the Commonwealth has used any false statements, testimony that they knew to be false. So therefore, I'm going to deny your motion. Okay.
Thank you.
Yes, sir. Are you going to start with the evidence, the exhibits?
Yes.
Okay, that's fine. Have we gone over them?
Yes, we have, Judge.
Okay, and do you know?
I don't know why the court camera is not focused on Judge A, but yes, it's not you. It's not your eyes. It's not your internet. It's not your device. I don't understand the artistic blur on Judge A at the moment, but here we go. So again, I was wrong earlier. This is from Wednesday last week, and the defense at the end of day 4 had said that he had a bunch of exhibits that he wanted to put in. So we'll see. who said it's giving soap opera blur. Yes. Oh, for show. It's giving soap opera glow. It really is. It's giving the filter that they now shoot Lisa Vanderpump with. That's exactly what, no HD for her.
You have an agreement as to which ones you don't
There are
object to?
several that the Commonwealth would agree may be admitted. There are equally as many that the Commonwealth would object to.
So we'll just go one at a time. Is that the
Probably for the
easiest?
best.
Okay, all right. We ready for the jury then?
Judge, the Commonwealth does have a request.
Okay,
Our expert who testified yesterday, Iris Dalligraph, she has flown home, and we are asking that she be permitted to watch his expert's testimony through the live feed so that she can then, if recalled
if
in
you have a
rebuttal.
rebuttal. Any objection to that?
No.
Okay, no objection, so
Thank
that's
you.
fine. Thank you. All right, we're ready for the jury.
All right, jury in. I'm going to put us at 1.25 speed. And then we will, if we get to bits that are painful, we'll skip over them. We're only doing day 5 today. We'll see what happens with weather and courts tomorrow. I am not confident that Fairfax County will be back in court tomorrow either. So we're going to zoom to bringing the
Defense
jury.
will start their case. I believe Mr. Carroll would like to start with submitting some evidence that was referenced in the Commonwealth's case, but he did not present to evidence, so he wants to put that in evidence now, okay? So we'll go through those exhibits.
Thank you, Your Honor.
It's always, I think, awkward for the jury. This is not my preference. It's awkward for the jury to just sit there where they are admitting a bunch of evidence. Oh, they already decided that Fairfax is closed tomorrow. Thanks, everybody. Well, my supposition was right. Look, I'm assuming that Fairfax is not dissimilar to what we experience here in Middle Tennessee, where this weather will shut us down for like a freaking week. And I expect that we're going to be shut down for a week, but we've had significant impacts to infrastructure here. The only thing that's going to suck is if I'm glad that we're zooming past the snorts. The closed captioning helps us get to where we need to be. I am glad that we will be able to get caught up. The only thing that will be tough, and part of the reason I wasn't going to do this trial gavel to gavel is because I have some stuff coming up with kiddos, but we'll just see what happens. So, Nikki said I'm in a neighboring county and we're closed through Thursday. Yeah, they might end up being out all week, and we'll just see, because I think we're going to be closed down that long as well. I mean, the ice isn't going to clear here with the weather being 4. So, even though it's pretty
That would
when
be
it's
Exhibit 1.
sunny with the ice on the trees,
I'd
it's
move that into evidence.
devastating.
Judge, we don't have a display.
We don't have a screen.
I'm sorry,
You do not have it on our screen.
should be on witness screen. Is it showing now?
No, ma'am, it is not.
Can you see it on your screens over here?
Though I will say,
You can see it in your back screen? There's something wrong with your monitor.
I will say that my neighbors, and we have neighbors in our neighborhood from all over the country and some that are native Nashvillians. One of our neighbors had their leaf blower out because the initial snow we got was very dry and light, and had the leaf blower out and was like just leaf blowing their driveway. And I cackled. Real lady cat. I didn't realize that Katie Van Slyke was in Nolensville. I love Nolensville. I didn't know if she lost power or not, but I was also on full watch. So yes, I am also invested. I am also invested in full watch. Yes, chat. I am watching the same things on the internet you are. I didn't realize she was up in Nolensville, but that's awesome. That's not far from me. All right, let's continue.
Monitor then.
Okay, we'll just step back.
Okay, that's fine, if that works.
What is full watch? Horses. We're talking horses.
can,
Horses having babies.
It might just be a plug, but
I hope they didn't lose power. They might have. I know there's a race.
all right. Okay, any objection to defense 1?
I love how many of you
Judge,
are on
there's no
full
objection
watch.
to defense 1 through 9.
Okay, all right, so defense 1 is in evidence.
Your Honor, I'd ask that that be published to the jury.
It is.
Okay.
Chat, I tell you, we're in the same spots on the internet, Chad. We are.
Your Honor, sorry.
I told you. Do you guys remember the story about how geeked I was the day that I went by? We have a very large animal vet that is on my way to Starbucks number 1. There are a few Starbucks in my area, but Starbucks number 1 is my preferred Starbucks. I love the team at that Starbucks. So by Starbucks number 1, and the Budweiser Clydesdales were at the large animal vet and out in the paddocks. I lost my mind. Not only gorgeous, massive horses, but they had their whole like trailer, which for those of you in the DCI world, the horse trailer for the Clydesdales, like next level, like a DCI trailer XX. It was crazy. I absolutely loved it. But yes, we can talk horses another day. We can talk lots of horses. We can talk all of the horses. All right. Continuing on. I lost my mind over the Clydesdales. Lost my mind. So cool. All right. We have one of the letters on the screen to answer the questions many of you have had in the chat, which is based on all of the defendants that we've seen, who has the best handwriting? You know, we've got Corey Richens, we've got Sarah Boone, and now we have Juliana's handwriting because they are admitting her handwritten letters into evidence. So you can see the highlighted portion, but the jury will have the entirety of it. Honestly, when this goes to jury watch, there will inevitably be people being like, what takes this jury so long? It's so clear in my mind. This is what's going to take the jury so long. This is what's going to take the jury so long. They got to see snippets of these letters, but don't you want to know more? This.
Is counsel intending that the jury read each of the 73 letters?
Oh, God.
That, Mr. Carroll.
Okay.
They'll have them back when they deliberate.
He did intend that he was going to show them and let them read all 73 letters. Oh, God. And the court just said, we don't have time for that. That would have been terrible.
And this is defendants 2?
Defendants 2.
All right, no objection.
Yeah, I'm going to put this at 1.5. I'm going to put this at 1.5 for the 73 letters. But Emily, couldn't they just have done this outside the presence of the jury? Yeah. I wonder if the defense's witnesses aren't there yet. We're at 1.5.
From the Commonwealth? Is that
Defendants 3, Your Honor.
3? No objection from the Commonwealth? All right.
They do not have to do this way.
Exhibit 4.
All right, no objection from the Commonwealth?
I'm just wanting to see what the Commonwealth objects to, if anything. Do we see that we are going one by one to show it and mark it? No, they didn't have to do this.
Exhibit 5.
This could
All
have
right,
been
no objection from the Commonwealth?
outside the presence of the jury.
Exhibit 6.
Again, no objection in evidence?
Exhibit 7.
Again, no objection?
Babe, I feel so sad today. Wait, no. Babe, I feel so sad. Today was a hard day. Also, for any of you that had questions about Juliana's challenges or not challenges with English being her second language, we've got some really grammatically correct letters. So again, the jury is going to be reading these going, look, I have no concerns about whether she understood what was going on here. I have no concerns. Babe, I feel so sad. Today was a hard day. I thought I had court, and even knowing my chances to go home is little, I still expected to hear something. I'm sorry I'm not there to spend Thanksgiving with you guys. I want to believe I'll be there for Christmas and New Year's. Wrong. I really hope so. I already cried a lot in here today. I just feel desperate to go home. I want to be with you again. Or if that is not possible, I don't want to live this. I don't want to keep living, keep going. I would rather get myself sick or something worse to happen to me than living without you. And I mean it. I've been thinking a lot about it. It hurts me a lot seeing the days, weeks, months pass and I'm still here and I can't see or be with you. I can't talk to my family in Brazil. That's terrifying, the days here. I just want this to be over one way or another. Remember, the highlighted is all that he read here. It's terrifying when they, I think that says lock us in our cells for no reason. I mean, there's generally a reason. They just don't always tell you what it is, for nothing. And I can't talk with you guys, or I can't talk with you at all. I'll never understand why they treat us like this. Okay. We're not doing anything to them. Being here is already a punishment. So why lock us in? Yeah. Being in custody sucks. Don't shoot people.
No objection from the Commonwealth?
I'm granting a motion sua sponte to zoom through this because they are on number 8. And we have 73 of these to go through. We have Juliana and Brendan at the top with a little heart on this one from April 14th. Love you. Look, they got their little. She's going to start doodling Juliana Banfield in her notebooks here. April 14th, 2024. I know what I had said in the last letter. I know how I feel about you, about us. I am really grateful for everything you've been doing for me, for us. Baby, I love you. Baby, I love you. Let's see.
I believe that was it for the agreed exhibits.
Right, 16, if you could pull it up.
All right. Now they're going to get into the exhibits where there's a little bit of a fight. I'm curious how that's going to go. We'll see.
What will the objection be for 16?
Same objection, Judge.
Okay.
This appears to be 2 pages of a longer letter. While this one does not identify how many pages were originally contained, the last sentence on the second page is cut short. So there is clearly additional information that was not included by defense.
If you could go.
So your objection's completeness. So the objection from the prosecution is completeness. I also, Chad, I want his letters back. The speaking objections also make me crazy.
All the way down, Mr. Carroll.
Yeah, the jury's sitting there while all this is happening.
All right, so I'll sustain the objection again if you can find the rest of it. That's fine. And then 17.
So we're
And
on
Judge,
17. The
Commonwealth
objections are
would not object
completeness.
to 17 through 41. I'm sorry, 17 through 42.
Oh, thank
So
God.
can we just enter 17 through 42 in evidence instead of showing it briefly?
That's fine. I wasn't.
Judge A is like, yeah, this is not how this is normally done. It's exceedingly time consuming and it's horribly boring for the jury. These are all the letters that the jury didn't get to see because the defense did not admit them into evidence during the prosecution's case in chief when they showed them to Juliana when she was testifying on cross-examination. They were only shown on Juliana's screen and the counsel's screen. They weren't shown to the jury. And the court's like, can we just mark and admit 17 through 42, please?
That's fine by me, but I just want to make sure you're comfortable with it. But they'll have
I'm
all of
comfortable
these.
with it. Yeah, I'm
Okay,
comfortable with
perfect.
that.
All right, 17 through, I'm sorry, what number?
42.
All right, so 17 through 42 in evidence.
And
And then if you could pull up
43.
43. Okay, what's the objection to 43?
Judge, this is a letter that purports to be from a third party to
Okay.
a witness. This is hearsay. It is not admissible. That
Okay.
person has not been called to testify.
All right, any response to that?
it's not offered for the truth of the matter, Judge. It's
Then
offered
what
for the
it's-
subject matter,
Your Honor, it's not offered for the truth. Then how's it relevant?
I guess.
Then Judge, I would object as not relevant.
I'll sustain the objection as to hearsay. Okay, that's 43. And then 44, do you have an objection?
Yes, Judge.
Counsel, do you have a response? Buffering.
No, I'm sorry. 44, no objection. 45, no objection. 46, no objection. Our next objection doesn't hit till 51. So
Okay.
through 50, no objection.
All right, 44, 45, 46, 47, 48, 49, and 50 in evidence. If you could
Yes,
put
the jury's
51.
sitting here going, this could have been
And
an
Judge, the
email.
objection is that 51 and 53 are duplicates. If he could elect which one he would.
Oh, they're the same?
Yeah, Judge, and
Okay,
I was
which
going to
one?
identify that as well.
Sure, which one would you like, 51 or 53?
Let's go with 51 and
All right, we'll put
scratch 53.
51 and withdraw 53.
No objection then.
This all should have been done outside the presence of the jury.
To 52,
Okay,
54
okay.
through 56. Our next objection is
I
57.
do like counsel's
All right.
pants.
So 55.
I still have an
and
objection as to
56
lack of
also, and
suit,
54,
but I like
evidence
pants.
57. That's the one from the producer, correct?
Correct.
So
Hearsay.
assuming objection is hearsay.
Correct.
Judge, I'm offering it not for the truth of the matter, but for the timing of the matter.
I'll sustain the objection as to hearsay 57.
Your Honor, I'm offering it as for timing. Okay, so truth of the matter as to the date. It's still hearsay.
All right. She already testified to it. They still have that information. 58
No objection. 59, no objection. 60, objection. Third party to.
from her mom. Okay,
Correct.
you can pull up 60. So
Hearsay.
58 and 59 are in evidence.
Yes, the jury's presence. No, they don't need to be there.
60, Your Honor?
Yes, the objection is hearsay.
Hearsay.
Yes.
Once again, it's the timing of it that I'm looking for, but I understand.
Okay, I'll sustain the objection as to 60. We have 61.
Objection.
I think it's a motion
It
to
is.
continue trial. Okay, what's the objection? I mean, that's a court record, but what's the objection?
Judge, it's not a court record in this case.
That's true.
And it contains a number of opinions of counsel
Okay,
that I do not believe have been testified
All right.
to. So hearsay.
all right.
I think it's a judicial document that the court can take notice of.
The
It
court
also
can
shows
take
the
notice of,
timing
but the
what it
jury
is
doesn't
that,
get it.
in terms of the timing of when this motion is being said, it's weeks before her pending trial.
She testified to that.
She testified
You
to.
don't
We
need
have
the
evidence that
motion.
This does contain hearsay, so I'll sustain the objection to 61.
My in-ears are stuck on my
52 is a
chair.
picture.
Objection. It is actually a video. It's the recorded call and is hearsay.
Okay, all
It's-
right.
it's-
So don't,
I'm sorry.
go ahead.
You may open it up.
No, I don't need you to open it up. I recall. You had just showed the picture. I didn't allow the video at the time, if I remember correctly.
Right. And
I'm sorry, Your Honor.
Yeah, no, I had just had a picture of it at the time of the testimony. I didn't allow the video at the time,
Correct.
the audio.
Correct.
The jury's
It's an
sitting
audio
there.
file, yes.
And this is an audio file of her negotiating with a producer relating to Hulu, Netflix.
All right. I'm
It's
going to
still
sustain the
hearsay.
objection then. Thank you. 63.
No objection, Your Honor. Next objection would be to 70.
All right, so
Prosecutors
63,
organized with their
64,
objections.
65, 66, 67, 68, 69, and if we can go to 70, I think that's a conversation.
And
What's that
Judge,
conversation?
the objection here is to relevance. I'm not sure. It's such a brief portion of.
You guys have a ton of great questions about the procedure of all of this. The prosecution must be, or the jury must be terribly annoyed. The defense did not move to admit these during the cross-examination of Juliana. Juliana testified about some of these things, about the letters, about the conversations, about her side. So it's not hearsay because she's making in-court statements. But the letters that she was shown, some of those letters don't come in. Some of those letters do. So that's what they're doing now. And the defense wanted to do it this way. The defense said, I want to admit these in first for the beginning of my case, instead of saying, Your Honor, at the end of the day, we can go through and admit these letters and then tell the jury that the letters, the communications of Juliana Magales, items number to number, have been admitted into evidence and will be available for you to review when you deliberate. That's all. That's all.
A conversation, and it doesn't appear to have.
If you have a way to close that for me, Mr. Carroll, I'd appreciate it.
But the
I think that
jury's
closes the whole
hearing
PowerPoint.
this.
Do
They're
that.
not seeing it, but they're hearing this. And I'm sped up and they're sitting here doing this.
What was the time frame of the conversation? Do you recall or do you have it?
Judge, I can pull it up.
Boy.
Judge, I don't know why that's popping up. This is the court's computer.
I think you have to sign into your account on that computer, but that's.
So Judge, the chat begins on January 9th. It is purportedly between Christine's phone and an unidentified user. And it talks about having had fun that day with Valerie.
Okay, and that's when the co-defendant testified that that was a conversation she had with Christine, correct? And your objection is relevance?
My objection is relevance. I'm not sure where this has to
All
do.
right, how is this conversation relevant?
The January 9th is an important date, as the testimony is brought out. It's the date when the email was set up for the connection with all of the devices.
All right, I'll overrule the objection. 70 is in evidence.
That's the only one he's gotten so far
And then
that they've objected to.
71.
Objection, Your Honor. Those are portions of a document. Best evidence would be the objection. It needs to be the
entire
entirety
document.
of the document.
All right, are you able to get the entire document
So
for January? I think
completeness,
it's January
essentially.
21st, 2023.
We have admitted it into evidence.
Okay. So you already have the entire document.
This document, they argued about when the defense went to bring it in, and it was kept out. The court sustained that objection when the defense went to bring this in originally, and the prosecution said, no, this is a snippet of an exhibit that's already in. They need to just say page 2 of prosecution and then give the number. So, Lila asked, what's the wristband on his arm? It would be his tracking and identification with a barcode, much like they track you at hospitals. Different custody facilities have different ways of keeping track of who's who and going where. And so kind of like a hospital wristband, but for jail. So, Dr. B's coming to put more birdseed out for the cats. So, well, birdseed for the birds that the cats can watch. You know what I mean?
Documented
Correct.
evidence.
It has been
All right, so do we
admitted.
need this then, Mr. Carroll? This is just parts of it,
These were the FetLife communications, Judge.
right? Which they already have in evidence. I can't remember what number their evidence. Do you have the number?
I do, Judge. 77 through 79.
He's going to knock all the...
Is the entirety of what is
Correct.
parts on this? Okay.
If that's, I'll withdraw that.
All right, we'll withdraw 71. That takes us to 80.
Is counsel not offering
think-
72, 73, 74,
I
75?
think we're offering to 71, Judge.
All I have is to 71. You're not doing 80, 80A, B?
The info's already in front of the jury because this is all stuff that Juliana testified to, and the jury's not seeing it as they are going through this.
C, D?
I don't know
Not
why
at this
we're
point, Judge.
I don't know why we're here
That's all I have. then.
doing this.
Okay. All right, yes, sir. Then your first witness?
Judge,
There's better ways.
I would call Officer Beckner.
Officer Beckner.
All right, defense witness 1.
You might want to check the plugs and see. if
Yeah,
they're-
so it actually clicked on initially. There was a view of that computer's screen.
It might just be a loose wire.
Often it is a loose wire, Your Honor. I'm just not sure where counsel's loose wires are at the moment. Casually, Kiki, the jury was in for all of
Just
that.
consult.
Yes, yes. Are we good?
Yep.
Okay, good.
The jury was in for all of that.
We got it. Nope, other way. Just, there you go. I don't think there are any questions.
And now they are fighting with the technology, which is delightful for everyone to observe.
Once I get this video, I'm going to ask you to identify.
And the defense witness 1 is Officer Beckner, who was called during the prosecution's case in chief. Red Sonja said, oh my God, are they going to call AV in next? I think the court would be like, you got to do that on your own, counsel. Which is just, it was brutal. So we are more than 30 minutes into court in real time. So that was the first 30 minutes of the jury's morning. Well, aside from the time that the defense was arguing.
Okay.
Sir, could you state your name for the record?
Zachary Beckner.
Okay, thank you.
We're still at 1.25. I'm leaving it there. So he's being recalled. I'm not wading through this. We're going to zoom until there's a question.
This is going to be a continuation.
All right, so
beyond
this, what would you mark it as your exhibit then?
that. I think we're at
Oh my God. We're already having issues with the exhibits. This is your first question to your first witness.
Sorry, I do know.
Do you, sorry.
I'm just sorry, is this a video that's already in evidence, or is this video that you are,
This is, so there's, Judge, I'll just tell you, the Commonwealth moved in its first 6 minutes
okay.
of this video, and this is going to be a continuation.
All right, so
beyond.
this, what would you mark it as your exhibit then?
That's
think we're
not
at 80.
true, counsel. The prosecution already said that they moved in the entire video and they showed the jury the first 6 minutes. The entire video is in evidence. They just showed the first 6 minutes. They didn't splice it.
Before, are we?
We are, let's see. 82, if you want to go in order.
Let's go in order, yes.
Okay,
thank you.
82. Okay, thank you.
Sir, I'm going to ask you to look at that picture and tell the ladies and gentlemen of the jury if you can identify what you see there.
So his body cam, this is his body cam. It appears to be his body cam.
What, if anything, are you doing as you go in?
From this, I'm about to enter the house.
Your Honor, he's identified the video. Can we publish this to the jury?
You want to admit it into evidence?
Yes.
Is it under seal?
I think
All those body cams show the victims. All of them are going to be under seal, but it's already in evidence.
I think it is
Okay.
because of the graphic nature of
All
it.
right, so 82, any objection, 82 under seal?
Okay.
All right, 82 in evidence, under seal.
Okay.
Anybody else downstairs? Where's the shopper?
So they're going to play the body cam again. Okay. We are not going to see what they are watching. We are going to hear it. The jury is going to see it. The first at least 6 minutes of this we've already heard, so I'm not going to slow it down until we get to the part that we haven't heard yet, because we've already heard it. Morgana, this is a great question. Why recall this witness and have to direct when you had the opportunity to cross him? Any ideas if this is part of a bigger strategy? They want to show the rest of the body cam footage. It might be because it might be strategy. It might be timing. It might just be that they want to remind the jury of it closer in time to when the defendant testifies. So it might be because they want to highlight certain things in the body cam that they don't want to do on cross. It might be because they have witnesses that they can't get to and they needed to pad some time. There's a lot of reasons they might choose to do it. They're allowed to do that. But now we're going to see the body cam footage again and probably the entirety. So I'm going to leave it at 1.25 now.
Just us? Hold down, somebody hold down. Hey, hold down.
They're saying one of the patients is outside now.
So somebody's outside.
And we've heard this part before.
Anybody else outside? Who else is outside? Anybody over here? Here, stay here, ma'am. Here. Who is the shooter? Who shot who?
I got a blowout kit if you need it.
Bring it up. Is there anyone else in the house who needs kids?
Some of these answers from Juliana, I don't remember hearing. So I'm going to just put the body cam at normal speed. They asked Juliana who shot who, and she said Brendan did. She doesn't say anything about her.
Those guns. Ma'am, I need you outside now.
What do you
Normal
need?
speed.
Medic's in there now.
Scene's cold to medic.
The closed captions were not accurate in that. They are trying to get medics.
He grabbed my arm. Go ahead. He grabbed my arm when I just heard that coming. Okay.
Sir, at this point, had you engaged in any duties at what you're seeing right now in the video?
I appreciate the defense is breaking it up to ask questions. I don't know if that was defendant Brendan Banfield saying he grabbed my arm. So I don't know. That's what it sounded like. Somebody was saying he grabbed my arm. I don't know if that was Banfield telling them what happened before he shot.
Could you clarify what you mean by
What
duties, sir?
were you doing? What were you asked to do? What did you take it upon yourself to do?
We were trying to locate a chest seal in the medical kits that we carry in our cruisers.
I'm
And
speeding the
that's something that you
testimony
had
up.
with you?
That's what the black bag is that I sat down on that bed.
Don't do that. I don't know when you shot it. Who's that chest concealed? I need it on the back right now.
It would have been better to clarify that he grabbed my arm and what was being talked about, but okay.
You got stabbed by him, so.
I'm going to keep moderating the speed just to
Watch him.
zoom probably slows me down, but
Guys, chest seal. Now we're looking for it, buddy. We're looking for it. Get balls out. Up this way. Upstairs. Hey, kiss, seal over and I'll get it right now. Just stay right there. Stay right there. There's another one behind me. Hey, open this up for Baumler. Yeah. I got the other one for him. Okay, go. Wait, check the guy behind me. Yeah. He's breathing, so. We got one guy up here, gunshot wound, one female, multiple stab wounds. Can someone do this for me?
I don't have anything.
Up this way. He's in the bathroom, up here.
I don't have a pulse on him.
He's down in there. Multiple stab wounds on that.
I don't have a pulse on him.
they're talking about victim Joe Ryan.
I'm not entirely certain, sir.
Check.
Chest.
Okay. Hold this down. Let's work on her, okay?
The defendant has seen these videos like 4 times in court already, and now today he is having a different response to it. Worth noting because this has been played during the prosecution's case. The video is being showed in court to the jury, Brittany, not to the audience, so the jury can see it.
Yeah, whatever you have.
The jury can see it. The jury can see it. The defendant can see it. The court can see it, but not the audience. Though, if the audience is sitting behind counsel table, they might be able to see part of it on counsel table. But yeah, it's being shown to the jury, just not up on the projector because it's sealed.
I don't know.
You shot in the head?
Oh, no. Shot in the chest.
It's a lot of blood. It looks like it's probably from a lung.
That is a lot of blood.
I don't even know what to do.
Just leave it. Where is it?
I felt for that. I felt for that cop when he testified.
Yep. Since we got this kind of way from meds, can you talk with him?
I don't have a pulse. Medics expediting or what?
A couple of you have asked about how Christine's phone was all the way downstairs in the bar cart drawer. Juliana said that they put it there. Juliana testified that they took her phone and went and put it down in the drawer.
Where are they at?
I can go home. Guys. Hey, do a pulse on that.
No, not at all. What do you need?
Good. Multiple stab wounds on her. Start going. There we go. Who's most violent? You guys know? She is. All right. Multiple stab wounds to the neck. Thanks. Where is he?
To the right, we have a pulse, multiple stab wounds. To the left, you see the other gunshot. All right. Who's still breathing?
They are still trying to triage, which we've heard before.
Don't know if it's one on the side. Okay, she's still breathing. We can feel blood moving.
They're talking about, it sounds like in that, they're talking about her.
Yeah, we're gonna get her. Okay. He's gonna be way over there. Yeah, this.
And that's about Joe Ryan.
He's breathing. That's why we're moving. Grab him, take him downstairs. I'll get her.
I will just note that this didn't occur to me the last time we heard some of this testimony, but the defendant's story, it seems to be, or the defendant's version of events from the defense opening statement is that Joseph Ryan stabbed Christine Banfield. And then when Brendan Banfield got back from the McDonald's, shot Joseph Ryan in the course of that. Juliana seemed to testify that what you hear in that hang up 911 call is that Joseph Ryan had already been shot, and you can hear him in the background. When law enforcement arrives, Joseph Ryan is apparently DOA to them. Christine Banfield is not. They are talking about the fact that they feel blood moving She is breathing. He mentions nothing about them needing to work harder to stop the bleeding, first of all. And if she was stabbed before Joseph Ryan was shot, the order of them passing away raises some questions in my mind too, given how many times she was stabbed and how significant her injuries were, and given that she has a bleeding disorder. So if she is stabbed before he shoots Joseph Ryan, how is Joseph Ryan the one who's DOA and not also Christine Banfield? That is one of my questions. So, question.
Yeah. Oh, are you hurt? Stand by. Sorry. Okay. Here we are. Nope, there's no pulse on him. Nothing? Okay.
No pulse on him.
I think that guy's gonna be definitely DOA. I mean, we can, I think that might be obvious over there. Here. This is my way. I don't know.
Oh,
What do you want to do? You want to grab that and go?
this is his house, that's his wife. Don't know who this is.
She's done. All right, that's fine. I don't know. You want to get a rhythm on that? Yeah. You want to show? I got the monitor. It's right there behind you. You have it? Okay. All right. So where is he? Grab the guy out there. Get it down. All right. This is not Baumler's.
Reximoto, I agree. Joseph Ryan was fatally shot in the chest. They said, I think, not immediately fatal when the coroner testified. They said the injuries to Christine Banfield were also, I think she said, rapidly fatal. Same with Joseph Ryan, that they were not immediately fatal, but would be rapidly fatal. So there is a timing issue here for me. We have heard this part of
We have a knife right there.
We have heard this part of these body cams before. For those of you who are like, what are we talking about in the chat with Raven? We had a bit of a side quest about horses that a lot of us have been watching to see when they are going to have their foals during Snowmageddon.
We got a knife here.
Yeah.
Is there kids down there? Zach? Kids around the way. Kids are outside. We're gonna clear the rest of the house.
Okay. Someone's gotta go with them.
Okay.
You guys want me to go with them?
If you want to go with it, that's fine. Zach, stay here.
All right.
You're with me on which end of the house. What are we doing here? He's just saying, we're gonna make sure no one else is hurt in the house. Okay, all right. We're gonna get them down there.
Sir, that's the video that you previously watched, the Commonwealth's case, correct? Up to the 6 minute mark?
Yes, sir.
Okay, was your body camera continuing beyond that?
Yes, sir.
Okay, and approximately how long did you, were you escorting Mr. Banfield that day?
Correct. I escorted him out of the house to the ambulance, rode in the ambulance with him to the hospital.
Your Honor, that clip was identical to what the Commonwealth did. I have the longer clip, and I'm just going to switch that out right now so we can go from this point and continue.
I mean, the Commonwealth said they admitted the full videos. Maybe they didn't, but they said they were admitting the full videos and they chose to show 6 minutes. He says he's going to switch videos. Sure. And we will listen to the rest of the video.
So 82 should just be your second part.
Yes, yes.
Okay. So we'll keep what we just watched will stay as the Commonwealth's exhibit. And then now 82 will just be what you're going to play from here on out.
Yeah, from 6:42 on.
And you'll have a separate file. You have a separate file for that? For
Yes,
me? Okay.
I just have to.
Okay, so 82 will just be that separate file. Then.
Okay.
Cinnamon Reed said, I thought
assume
Ryan
there's
was
no
also
objection
shot
to
in the
the
head. He
continuing the
was,
body cam?
though
No, ma'am.
they indicated that was based on the way he was shot, that was a slower fatality and that he would have lost eyesight in at least one eye, but he could have still been mobile with the shot in the head. The shot in the head was not immediately fatal. And we heard that during the coroner's testimony, and the blood spatter expert for the or the blood pattern expert for the prosecutions.
And just for
Witness.
clarification, what we just watched was Commonwealth 6.
Number 6?
Yes.
Okay, so that will stay at Commonwealth 6, and then whatever we're about to play now will be 82, and I assume there's no objection to the rest of the body cam?
Correct.
Okay. So 82 will be in evidence.
Oh boy.
Under
This
seal.
is,
It's because he just connected it.
this is. I'm glad we have Zoom room, everybody. All right, back to the rest of the defense exhibit. If this is feeling clunky and unorganized to you, imagine being the jury sitting through this in real time, day after day. I would also be frustrated. All right, what, if anything, will we learn from this?
Sir, do you recognize that as being continuation of the video?
Yes, sir.
Okay, thank you.
So she's gonna go up to President obviously, that's the closest one to that. He's obviously gonna be away on
Hey, can you check him out?
Yeah, I got more units here, but we'll check him out. He's starting to break down. Stay sorry, I'll just walk through, okay? What did you say, you say? He's gonna walk. Okay. We're gonna have to get him out of here.
Yeah, I know.
Can you give him a second? Don't touch anything else.
I'm on.
We did see this part of this body cam, or we heard this part of this body cam from other officers' perspectives, because we heard them planning to get, we just didn't see this officer's part of this body cam, because there's like 5 or 6 overlapping body cams where they're trying to figure out how to get Banfield out of the primary bedroom, out to the ambulance, etc.
Let me change my gloves up. We can get him out of here. A knife's there, guns are on the bed.
He gives beauty for ashes.
We're gonna take him.
The victims were not in the bathroom. Banfield was in the bathroom.
Yeah, just give him a second.
Law enforcement told him to get in the bathroom and stay there so he wasn't walking around in the crime scene. They told him to go get in that area.
I gotta put him on the monitor. Yeah, go for it. Is she what that? So the fire department, they take over at this point? We're kind of just here. Is she breathing? So again, they're down there. What I want to do is get
Just
you
watch what you're kicking, please.
All right. Does that work?
I know what you got to do. I'm just.
If you can't walk, we can wait a minute.
And for those of you that are going to ask, yes, chocolate croissant today.
Now, was that you saying, watch what you're kicking?
Yes, sir.
Okay, and was that directed toward anyone
From
in the
Wild
room
Green.
there?
It was directed towards the firefighter that you saw with the face covering on, the mask.
The one who came by you to your right?
Correct.
Okay, and was he tending to the scene over near Joe Ryan?
Correct.
You can tell how fast things are moving at the scene based on the fact that it sounds like I have actually slowed down the speech of defense attorney, because all the first responders are in first responder time on the body cam, which makes it very hard to speed up. And then when we get back to real time with the defense attorney, it sounds like molasses.
He was hooking up to leads.
Okay, and was there distortion of how it looked before he?
Objection leading.
All right, I'll sustain as to leading if you want to rephrase.
When you said,
It sounds like he's going to do more than say, we're just at this part of this video, aren't we? So I'm going to put him at 1.25.
stop kicking, what were you referring to?
He had kicked some blankets out of the way.
Okay. Do you remember the colors of those blankets?
I believe they were purple.
Purple? Okay. Were they the only blankets or towels that were in that area?
I don't remember, sir.
Okay. You just remember him kicking?
Correct.
Okay. Do you remember if he...
Counsel, be on his body cam, just roll the tape. Did you see him kick anything else? I don't know. Is it on the body cam? Just roll the tape.
kicked anything else in the crime scene?
Not that I'm aware of, no, sir.
He stopped after you?
After I told him to.
Okay, thank you.
Yeah, I'm just giving you some fresh air right now as well, okay? So we can get you outside. You got both on? Can you help him? Just be with him?
Yep.
I put this at normal speed.
Now, you're holding Mr. Banfield, my client, at that time. What was the reason for you to hold him?
He was unsteady on his feet, sir.
Okay, did you hear him say anything or relating to his ability to walk?
At that point in time, no, sir.
No, sir?
No, sir.
Oh, okay. But you, sometime later on in this video?
Correct.
Okay, thank you.
Roll the tape.
Say, President Vienna.
Easy.
I'm sorry, say it again.
So you in Vienna?
My office is in Vienna, correct? Did you call my office?
No.
I need to call my manager at some point.
It's the least of our worries right now, man.
We're just gonna get you in a cruiser outside in the air where you can.
Is the defendant asking about calling his manager? Well, law enforcement is saying, look, man, that's the least of my worries right now. Is that the defendant?
You're okay, okay?
I have questions.
You're not hurt? I don't think so.
We'll check him out when we get him over to the car.
Because it's definitely not law enforcement needing to call their manager. Everyone knows where they are.
Watch out, watch out.
Go up into the grass? Yeah.
What's wrong?
I don't know, maybe just nervous.
I'm turning this down because the beeping is horrific. It's whatever large thing is backing up. It's probably more first responders, but they're asking defendant what's wrong with your leg.
Okay.
I'm going to be calling medic 436 to Reston Hospital.
That is loud. Oh, I agree with you. A lot of you are saying, you know, his department issued weapon might be part of it. Agreed. But they're trying to get his wife to the hospital.
Take some deep breaths.
And they're telling him to take deep breaths. I'm going to fast forward some of this. They're telling him you need to sit down, take deep breaths.
Sit down somewhere. Is there a way to get an update? Right now.
They're handling everything from here.
Somebody asked for an update.
He doesn't think
That
so.
makes sense.
We haven't had a chance to really do a full inspection quite yet. If you guys want to check him out. He's just a little unsteady on his feet, though. All right, let's do that then.
I think it's fair that the defense wants to show his demeanor after this incident
We're gonna go ahead and check this gentleman out in the back of the ambulance.
and wants to show how he's responding to it, because their argument is going to be, see, he's rattled. I don't know if that negates that he planned it, but fair enough. A lot of you are asking, have you heard the defendant say, like, where is my daughter? In one of the body cams, and I don't remember which one it was during the prosecution's case in chief, one of the officers tells him she's outside with the au pair. It's very early on in those body cams when they're putting him into the bathtub, but it is in there quickly that they tell her where the daughter and Juliana are. So he did. It was just much earlier on.
Officer Beckner, had my client complained of any physical ailments other than having difficulty walking?
Just whatever he said was going on with his right leg.
Okay.
That was it.
And when you said you were going to go check him out, was there anything that caused you alarm that caused you to want to have him checked out?
I just wanted to make sure he was okay.
Okay, thank you.
I'm turning that down. And you just heard him again say, where's my daughter?
She's out there with them, so.
I think it's the first time we heard it on this body cam, but where's my daughter? She's out there with them.
Is there anybody else in the house other than your daughter and the other female?
So she's an au pair, Manny.
Okay.
He lives with us.
But it's just the two of them, correct?
Yeah.
Okay.
And my daughter.
Just 1 sec, we're gonna hit around this other door here, all right?
again, the jury will be able to see how the defendant's responding in this. We can't.
Priest, you can. Is anything bothering you right now?
I feel unsteady.
Okay. Were you hit with anything? A knife? Anything?
No, I took the knife. I took the knife from him.
Okay. All right.
How did you take the knife from him? I'm guessing after he was shot then.
So you're not hurt anywhere. Is that not your blood, correct?
I think it's.
All right. You want to slip this jacket off for me so we can evaluate you real quick? I'm going to have you kick your other foot up for me.
Yes, you can get it off. Yeah.
Channel creator, yes, the jury can see this. It's sealed because of the showing the victims. So the entire exhibit's sealed. And we are listening to the entirety of the body cam.
Okay. Pressure already.
Both to be set up in Stablebrook Way and Dover Third Court.
Officer Beckner, do you know who took possession of the jacket when it was taken off of him?
Officer Hugh.
Officer Hugh?
Yes, sir.
Okay, thank you.
Did Officer Hugh just like roll it in a ball and stick it in a bag and throw it in the back of a truck, or nah? I'm guessing the answer is nah.
I'm just going to take your watch off for now, all right?
That's fine.
So I can see. I give it to the officer standing behind you.
Maureen asked about
You know?
Banfield's prints DNA on the knife. There were no prints taken from the knife because there was so much blood on the knife, is my understanding of why they did not fingerprint the knife. And the DNA as to Banfield came back inconclusive, unless it was the fingerprints that came back inconclusive. I would have to go back and look at my notes. But as to Banfield and the knife, it was inconclusive. He was not included nor excluded. However, he tells law enforcement, I took the knife from him. So, you know, if it was on the knife, what the defense would say is, well, yeah, he took the knife after he shot the guy. So I don't know if it would matter that much one way or the other, because he admits interacting with that knife.
Holding her neck.
Okay.
Do we have any crossings that need to be covered?
511 Bravo, I've got one up at House Tavern
Taking her
in
to the
front of
hospital right now.
Grainsville.
They're not going to have much of an update. They're going to take her to rest in the hospital, okay? Yeah. All right, I don't see any wounds on you.
He said he wasn't injured.
Just going to check you out. Would you like to run up to the hospital?
Can I be with her?
They're going to work on her when they get there. You wouldn't be able to see her immediately anyway. If you do choose to go.
Yes, I would.
They offered him a ride to the hospital. Do you need a ride to the hospital?
We'll take you up there for evaluation then, okay?
He asked, will I be able to be with her? They said yes.
What's going to happen to my daughter?
That I'm not sure. That's a
As
question
of
for the
right now, I
officers.
believe she's sitting with one of our officers until we figure out what all is going on.
Take it back.
Taking that last crossing.
She's also with your au pair. She's not completely
Hey,
alone.
Doherty, it's going to be Drainsville at 8:50 to 9:20, right there in front of the Kiss and Ride.
Yeah, there were no injuries on defendant at all. He had a lot of blood on him, but there were no injuries on him.
Let's get squeezed real tight.
Nisha, you didn't miss much. Lawyers
We'll take all that
being
off.
disorganized,
Take it off there. Okay.
and most of a body cam we've already seen.
So just to confirm, nothing's bothering you right now, right? Physically, you weren't injured at all.
Did anything hurt you at all, man? They're trying.
It sounds like the defendant is starting to cry, not in court, in the body cam, which is probably why they wanted the jury to see it, to see that he had emotion, an emotional response.
Trying to find out
Okay.
so we can make sure we get you help too.
Yeah, more doors going on here. You guys.
We're gonna need his
No, you're good. You're good. Take the hands down.
That's fine.
If not,
You're not gonna be able to have him in the hospital anyway.
Fine.
yeah, let me have the wiper.
I have cuffs.
Okay.
What department are you with?
Department of Treasury, Internal Revenue Services.
Okay. It's okay. Those can stay for right now. That's fine.
Zach?
Yeah.
So before you roll, let me make sure they decon what you have on you, okay?
Okay. I don't think I've got anything directly on me, but hey, Derek.
Yeah.
I've got Mags and his watch. If you want to hold on to this.
What was that?
I've got Mags and his watch. I'm gonna go with them to the hospital. Yes, department.
A bag.
I don't have an answer to that right now. I wish I did, but I don't. I'm sure they'll give you an update as soon as they can.
I mean, I'm also of the mind, well, the jury can see the defendant's demeanor and the defendant or the jury can judge his demeanor. Him planning this and then the actual execution of the thing might well be enough to cause a genuine stress and emotional response. What's causing that response might not be grief, but it really just depends. So, the jury will get to decide that demeanor.
The question is, would you like to go with us or would you like to go with the police?
It doesn't matter. If I can be with them, that's what.
This is what one of the medics have, one of the bags the medics have.
Okay.
What is he looking for? Just a
I'm
plastic
assuming so,
bag.
Zach. Did we,
A what? Plastic bag.
just right now, did we search them?
No, I haven't searched them yet.
Here, when you stand up.
Sorry, man, it's fine.
I have.
You're good. Sorry.
I know.
That's fine. Yep.
I'll leave his badge on him.
Brother, you know the procedure, we apologize.
It's fine.
Shakia, he had a department issued weapon, so he had, it seems like some type of duty belt that he had his service weapon on because he had a hip holster, and then he had mags for his service weapon on it.
Okay. Personal.
And
So-
you're with the Treasury. Okay.
Jackie asked, why can't we watch the video? It's sealed.
Anything on that side, Terry?
Yeah,
he's going.
It's a sealed exhibit, so we can only hear it.
He's Treasury Special Agent.
Officer, is there a policy about searching someone who goes in an ambulance, or what were the circumstances that caused that search?
We were just trying to confirm he didn't have any further weapons on him, sir.
Okay, after he told the fireman that he had the mags.
Yeah, you don't want to put him in an ambulance if he has weapons.
I believe that's what he said to him.
Okay.
Zach, gonna go.
Yeah, I'll ride with him. That's fine.
My badge and wallet.
I think
is in my jacket.
Your badge clipped on your brother?
Alexis has two off-duty IRS agents often carry their service weapon. I don't think I know anyone in law enforcement that doesn't carry even if they're off-duty, though they normally do not carry their service weapon if they're off-duty. I don't know if he was going into work that day because the nanny was going to go to the zoo. I don't know if he was going to tell them that he was going into work. I have no idea. It was a weekday. I don't know. So I don't know.
We're going to leave it on you, okay?
All right, my credentials.
Okay.
Yeah, that's fine. Just go ahead. You can sit back down. You're all right.
I'm gonna follow him down.
Okay.
I'll follow you down to the hospital.
Okay.
You're gonna be in the ambulance?
Yeah, that's fine. Unless Zach
Where would
keeps
you-
my iPad right there. Yeah.
Zach, you got gloves on? Put his, here. Put his stuff in here.
Monuments of speculation. The IRS, not all IRS agents carry, but IRS does
I'll follow you guys
have
down too, so. All right.
sworn officers that carry.
Whoever's driving my car, it was actually.
We'll have to figure that out later.
Sir, was yours the Glock 19 with the TLR?
Mine has the light, yeah.
With the light on? Okay.
But not
my other
everybody
gun-
who works with the
My
IRS
other gun
carries.
is my personal weapon.
Oh, that's the 43X?
Yeah.
So both those are yours?
Both of them are mine.
Okay, the ones that we saw on the bed, correct?
Correct.
Okay, thank you, sir.
I was thinking about it. No, that's all.
Where do you guys need me at?
It doesn't matter to me. You can probably sit in the captain's chair right there if you're going to ride with us.
He's gonna go.
I'll ride with
Okay.
you.
Just for evaluation. Yeah.
Okay, sure, yeah, good idea. Okay, BLS, good,
Yeah.
absolutely.
If you guys don't need anything else?
No.
So it sounds like they're taking him by
Okay, yeah, command terminated, so I'm out of here.
FBI ice cream
All
truck
right, and
thing.
we're gonna roll over.
They're taking him with the ambulance. FBI ice cream truck in the chat said, medical retired fed here. We always carried our service weapon everywhere we went, everything we did. Fair. And feds, I imagine, don't have to worry about jurisdiction the same way like local does, which might be the difference in you can have your service weapon everywhere because you're kind of in jurisdiction just about everywhere. With local, it can get a little stickier with jurisdiction, so I appreciate it. I did not work with the feds nearly as much as I worked with local. Some, but not as much.
Arrest in the hospital then.
Okay, sounds good.
All right, we're good, Zach. 2 to arrest. All right.
So they're going to transport him.
Yeah.
Are we good to go or?
Yeah. To my knowledge, I'll just check real quick.
920 Bravo.
What's his first name?
DREMT.
Hey, are we good to transport him to the hospital?
Last name?
The beeps are so loud.
DANFIELD.
What's your date of birth?
Ashley said, so he's a tax cop. Is that a thing? Yes,
Hey,
the IRS has
LT or
investigators.
Gibbons, are we good to transport to the hospital?
Just like any agency that does investigations. The IRS does have investigators that investigate and work on their cases. We can talk about that more in depth another day.
Liver blood, hypertension, any cardiac issues.
The beeping of the body cam is a lot.
Taking medications for anything?
They're talking to the defendant.
Any allergies, any medications to know?
A number of you are saying that parts of this is available on YouTube. I'm just sticking with what's in the trial. The court said that the whole document was sealed. I don't know if stuff was released prior to trial or what have you, but I'm going with what the court said. So I'm not going to go look for it. If it is, it is, but we're just rolling through the court feed.
How old were you? Happy birthday. Call the hospital, let them know we're coming, okay?
Though it does sound like they are transporting him, and I think if there is not them chatting, we can zoom through the transport. It's a very low conversation. That sounds like transport to me. That all sounds like transport. They said 10 minutes.
I don't see why it would be.
All right. And now they're having conversation.
I don't know, man, to be honest with you. I don't see why it would be an issue, but I'll hold off right now. All right. All right. They are, it sounds like still transporting. They know you're coming. I imagine they're talking about the hospital. They're saying they know your wife is there. Ready for you to get there. All right. They are still in the back of the ambulance. We are going to zoom. All right. As they start to talk about the victim again. It sounds like the defendant said, "Did you know about my daughter?" That's what I think he said. It's very low. As of right now, she's still over there. From what I understand, sir, she's there with the other officers that are still on scene. Are they going to tell her? I mean, as of right now, there's really no other information to explain to her. I don't think they're going to tell her anything. It's kind of a delicate matter, and I don't think anybody wants to upset her currently.
She's only 4.
Yes, sir. I understand that. Well, there's the body cam. There's the body cam beep buzz vis-a-vis the machines in the ambulance. And you can hear the defendant. You can still hear the defendant.
Exact copy of one.
Go ahead.
Hey, the gentleman that you're with, do me a favor, once you get all this information, give me a call with that, please.
They're asking for his information. Correct. I don't have my phones on me. They're telling him, call when you get to the hospital. All right. Now they're going to get his info. Appreciate it, brother. All right. While it sounds fascinating to listen to the back of the ambulance as they ask the defendant questions, we'll see how much we can hear. That's correct. You're with the IRS, correct? Yes. Sir, your voice sounds completely steady. A very... No! Canceled device. Oh, Lord. My devices are talking to me. His voice... You're with the IRS, correct? Yes. Just... You know. Your voice doesn't sound pinched at all, sir. Some of you in the chat are asking if he's in the ambulance with his wife. No. She was transported before him. All right, back in the back of the ambulance. We're going to zoom past some of that. If the defendant starts, breathing dramatically again, we'll see. All right, more driving. Fantastic. We're going to zoom past all of it. As the law enforcement does what they need to do, I'm going to see if I can actually zoom this up to when they get to the hospital, because I don't think we need to sit through all of the driving. And the defense counsel snorting.
Closed. Yes.
Okay. We're still burning. Just a heads up. Body cams are still on.
Okay. No, that's okay.
Just yell at me. I'll get out of your way. Hard to hear.
What's that one? They said he wants to be evaluated, so okay, no problem.
All right. There is clearly a part that we missed, because now the defendant is having all kinds of responses in court. Hold on. All right. Let me back up, because it looks like they got to the hospital and the doctors came in. I
I over zoomed. Apologies. So apologies for the hyper zoom.
We'll head out because we're here, okay?
All right, there we go.
I'll have you step back out this side door that we came in.
Yes.
Go, sir. Step down there.
That's loud.
Just wait right here for us. We're trying to find out what room.
Well, we can definitely tell we're at the hospital.
That's you. Can I see her? No, not yet.
Any voters on channel 3 or 5?
Just take a seat on the bed for me.
You just said that she didn't.
I didn't hear what he said, so.
The cot and stuff probably needs to be switched out.
Can you have someone check with him again?
Okay. What is the nature of the incident?
Check what?
The status of his wife, ma'am.
Hi, sir. My name is Gina. I'm one of the doctors here. Your wife has died.
Well, that is the doctor's. Can we check on the status of his wife? Yes, sir. I'm one of the doctors here. Your wife has died. So that is him being told that when they get to the hospital that his wife has passed. And then the doctor says, "I'm so sorry," at the very end of that. And defendant is back to wiping his face in court.
She's still at the scene, sir. She's with the other officers.
He asked about his daughter. It sounded like.
Would you guys be able to ask someone else to bring some tissues? That's a nurse.
And you can hear the defendant on the video. You can see the defendant in court reacting to watching the video. A lot of you have thoughts and feelings about how the doctor delivered the news. ER docs tend to be pretty direct and deal with delivering the news that somebody has passed pretty regularly as part of their workday. It does not surprise me that Doc was just like, "Oh, this is the news I need to deliver. I'm sorry," and then back to their workday. But the defendant is responding to that. It is a very factual, neutral delivery of information. I think that probably tracks across most ERs.
We're still burning. Just a heads up. Body cams are still on.
Okay.
And then he's telling the hospital staff that they're being recorded.
Just yell at me. I'll get out of your way.
What's that one?
They said he wants to be evaluated, so I'm going to.
Okay, no problem.
Oh, the hospital noises.
Were you there at the time?
Yes.
So somebody is talking to the defendant. It sounds like.
You were there at the time. So is there any part that I can help? I can explain what happened when she arrived here, but you were there and it sounds like there was a lot of blood loss.
Yes.
And so I think that she died of blood loss. Her airway was actually okay. I'll call the medical examiner, of course, and we'll do an autopsy and make sure we know for
Yes.
certain. But
I was trying to apply pressure.
yeah.
And I don't know if this is a different medical professional that he's having a conversation with. But you can hear him saying, I was starting to apply pressure, or I was trying to apply pressure, and saying, whoever the medical professional is speaking to him, saying, I think she died of blood loss. Her airway was okay. They're going to do an autopsy.
I mean, those were enormous wounds, and it's not.
There were so many.
Yes, and the neck is not compressible, so it's not possible really to stop all the blood loss. And her airway, it seems like, was in the midline okay. She was able to be intubated. Everything that was possible to be done was done for her right away. You did a wonderful, you did everything that was possible. It's not a survivable injury.
And telling him, we were able to intubate her. We did everything we could. You did everything you could. There's nothing you could have done because of how catastrophic the injuries were.
Is someone with her daughter? Is her daughter?
Yeah, we still have officers at the scene with her.
Okay. Just want to make sure that she's safe.
Yeah, she's safe. Yes, ma'am.
She's on before.
Yes, sir.
They are talking about his daughter.
It's for him. And did you get hurt, sir?
I think so.
Are you certain? Did the person come after you at all? Did they hit you or?
I'm curious what his answers are.
At one point, but
I think he put his arm on me at one point.
I don't think I'm hurt.
Yeah, sure. You have tissues here. You want to wash your hands?
Oh.
Feel better after that.
Interesting. The nurse said, you want to wash your hands. We have tissues here. You want to wash your hands. So not suggested first by law enforcement. I don't know if it'll matter all that much at the end of the day that he was allowed to wash his hands or not allowed to wash his hands. I think it's frustrating. However, given the circumstance and everything going on, am I shocked that it happened? No. Is it perfect? No. Could the cop have said no? Sure. They could have. But given everything that they saw, he said he had the gun. He said he touched the knife. I don't know. I think a lot of people probably would have done the same thing, saying I felt bad for him. Not ideal, but it doesn't surprise me. And you can hear him washing his hands.
Officer, is this the situation that the Commonwealth asked you about when you were originally on the stand?
About him washing his hands?
Washing the hands.
Correct.
Yes. And you weren't advised by anybody in your chain of command to not allow washing hands or anything like that?
At that point in time, no, sir.
I mean, after that, they said, don't do that again. But Monuments of Speculation said so much for gunshot residue. He said that he shot the gun. So I don't know if GSR would have really mattered all that much. He said he shot the gun. He said he touched the knife. He said he touched the victims. But yeah, I'm not surprised that they said to him, ideally, please don't in the future let them wash their hands. But in this case, he's going to have the victim's blood on him, and he already said why. So is it perfect? No. But is it, in this case, is it devastating? I don't think so.
Sorry.
At that point in time, no, sir.
Okay.
Yeah, they've since told you that that's not ideal. I don't doubt that. It sounds like he's washing his hands. And when this officer testified the first time and said, I felt bad for him, I get it.
Okay.
My name's Maureen. I'm the first victim that you're today. I'm so sorry for your loss.
My wife is a nurse.
I can't hear who identified themselves over the hand washing.
You wanted to be checked out medically, right?
Sure.
And I have a bracelet with your name on it. Brendan Banfield.
Yes.
I'm just gonna put this on here. Would you like me to call our chaplain? Would that be possible?
Yes, please.
Yeah. It doesn't sound like you guys letting, the person struck him once, but, no injuries that we need to do imaging or anything like that for.
Verify that his right leg's okay. He's been having some, said it's been feeling weird.
Okay. Since this morning or before?
No, since this morning. I think.
I'm not sure whose family they're showing in court. I assume it is one of the family because the camera panned to them sitting in court. I'm not sure whose family.
And then,
I think I'm just.
would you be able to sit down for just a second? I'm just gonna check your vital signs. I'm sure it's
Can I have a tissue?
And Christine's dad could have been at the courtroom at this point. I don't think he was subject to recall, but
Would you like me to get
it could be his parents as well.
scrubs to change into?
They're going to give him scrubs to change into, and then law enforcement can take his clothes.
You got it. Okay. So I'm just gonna, you're gonna feel a squeeze on your left arm. I'm just gonna get blood pressure real quick, okay? I'm gonna check your oxygen level over here. So what's been going on with your right leg since this happened? You feel like it's hard?
I don't, it's like I'm having spasms right here.
I see, okay. And where did the person hit you?
And I only remember my arm.
Okay. Okay, once you're changing into the scrubs, I'll just look you over there. But I see that you're walking and bearing weight. It's, if anything, it's a bruise, or like he said, you have a muscle spasm because of the stress. I'm gonna borrow your fingers. Kind of a little bit.
Well, you can tell that they're taking his blood pressure, can't you?
You wanna get on, you can get more.
Is that the end of it? Yeah. Okay, you already switched out the linen and stuff on the cot, is that okay, or?
I guess.
Oh, all the hospital noises. It's really hard to hear any conversation they are having over the all of the noises in the background. But like so bad that it is difficult for closed captioning to even pick up, but they are doing the evaluation on him.
Officer, is that Officer Baumler that was with you?
Yes, sir.
Okay.
So at some point he would have changed into scrubs. They would have been able to take his clothes into evidence. We saw that during the prosecution's case in chief. I am Ken Ross. Asked, are we going to hear from the defendant today? No, we are covering day 5 of court. Fairfax County courts are closed today. Fairfax County courts are closed tomorrow. So he has some time to think about it. I'm going to see if we can zoom a little bit until they, there we go, start talking again.
Your daughter and a pair have been taken to headquarters, so they're both accounted for. They're okay, sir. Yep.
I'm gonna have to step out. I have to go get bags, phone, and all that.
It's all right there.
When he changes.
Yep.
So I'm gonna see if I have any paper bags.
All right.
They're going to go look for evidence bags.
At this point, we can't let you do that because we still have to investigate exactly what happened. Once the detective shows up and kind of talks to you, that's when we can let things, they'll kind of explain a little bit more in depth. We're not going to ask you any questions about what happened, but what we do have to do is
get your clothes.
Sure. Take photos of you in the clothes that you have on, so before you change in the hospital gown, and then we are going to have to take your clothes as well. I understand. For that evidence, so we're going to do it, and there's no easy way to do it, but kind of the easiest way possible.
Yeah, we're not leaving the room while you change, sir. We have to document everything from this point forward. We let you wash your hands. That's where the courtesy is going to really, well, that's where that's going to stop. And for now, we're going to need to take photos and what have you. You're not going to be alone in this room to change.
I'm just going to have to go get my county phone so we can get everything documented, and then basically it should be deciding for the detective out to kind of come and ask you what exactly happened, because we're not going to have you go on numerous times.
I need to move my heater, so I'm going to move my heater real quick. Oh, that's loud. So I'm going to grab my heater real quick.
No, I got it.
The cats are very interested in the birds outside.
My wife's parents are on their way to my house some point today.
I wanted to hear what he said. My wife's parents are on their way to my house.
My wife's parents are on their way to my house some point today.
My wife's parents are on their way to the house at some point today. Did you call them? when would he have time to call them? Or were they coming over because they were doing like cake and stuff? Because it is the defendant's birthday. Were they coming over for the birthday? Okay.
Like Officer Baumler told you, man, as soon as we're able to, we'll let you make phone calls.
Yeah.
Oh. Right. It sounds like he's trying to make a phone call and he's like, but my wife's parents are coming over at some point today. Okay, well, you're not getting to make any phone calls at this point.
Okay. I know they are coming, but I don't know what time.
Okay. I understand.
Sir, your voice didn't even waver in that sentence before you're back to boo-hooing. His voice didn't have not even a tremble. Okay. It's the voice that gets me, not the rest of it, but the voices quiver with emotion and throats get tight when you are crying.
Hi, sir.
You said someone needs to take pictures?
Yes, sir.
Before I get changed?
That is not what I meant to do with the screen. Apologies. I
Phone.
need to fix my heater.
Back in my cruiser.
I figured I didn't know if you guys need a brown bag.
I think he's getting one, but if you have one, that would be helpful. Just bear with us for just a second.
Just pulling my nose.
Yes, sir. I understand. The ER staff has brown bags if you can't find one.
All right.
Because we have to individually bag it.
I mean, they didn't even suggest a grocery bag. I don't even know what to do with that. But yeah, somebody's got a brown bag somewhere, I'm sure.
Yeah.
Is Valerie at least with Juliana?
I believe so, yes, sir. I don't see why they would have them separated at this time.
So asking about his daughter being with
Hey,
Juliana.
boss. Can you see if they can bring me a couple brown bags, the paper bags?
Okay.
Thank you. Thank you.
I'll have some water.
There's a lot of background noise in the 911 call. Or not the 911 call, this body cam.
Perhaps it's going to be coming this way soon, so we don't do it on the phone, but if not, accent caption is going to be the way to go.
Okay, bro.
We need one.
Gotcha.
Yeah. So,
I gotcha.
see what happens.
Okay. I'm going to zoom some of this. They are going to have him change, take his clothes, put them in the bags that they were looking for.
Coming out, and they'll be the ones to take all the photos and all that instead of us doing it on our phones. So that way, they're on the way now, so they should be here in the next couple minutes.
I understand.
Yeah. Do you need like a bottle of water or something?
I think someone's got it.
Okay. Just going to inform. You have any other questions for us? I might be able to answer right now, man.
So crime scene or detectives are going to come out and take the photos instead of us taking photos on the phone. It's probably a good call. And then we're going to go from there. Do you need any water? What else?
Do we know who the person is?
I don't think he's been identified yet.
Ned,
I can honestly say that.
Ned asked, why are they playing this again? The prosecution only played the first 6 minutes of this. The defense is choosing to play all of it for the jury to see how the defendant reacted, to see what's going on with the hand washing. I'm sure they will make some arguments about it when they get to closing, but they're showing the jury the whole thing.
We would not know that information. And at this point, even if we did, we probably couldn't get that information to you. That'd be the detectives that would let you know that.
Really, this is going to be an EDP call.
10-4, 331 Bravo, can you start?
My name is Betty. I'm a patient advocate, also chaplain, guest services.
I didn't hear the whole name, but patient advocate and services from the hospital.
Yeah, is there anything I can do for you right now?
It might have been chaplain. Was it chaplain services? That would make sense.
We say it was my wife.
Say a prayer for your wife, perhaps.
He asked if they could say a prayer for his wife.
What is it?
Christine.
Christine?
Yes.
No, we have cracks and detectives who take photos and they'll be on a few minutes.
She's got some.
Thank you.
Do you have a specific faith community?
I think she asked, do you have a specific faith?
Gracious and loving God, come before you today in great distress. And Lord, we ask that you be with Christine and with her husband here. We ask that you surround her with your love, that she might feel that and know that you are with her. Lord, we ask that you heal as only you can. We don't always understand your healing ways, but just ask that you be with her. And be with her husband now.
Sir, you are going to need more than Jesus with this trial.
Surround him with your love. Let him feel the warmth of that love. To carry him through not only today, but days and weeks to come. Lord, for a family of friends who can support them this time. Please let them open their hearts and arms and provide that loving support that is so much needed. And this we ask in your name. Amen. We say the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread. Forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, forever and ever.
The defense has the right to play the entirety of the body cam. The jury may not feel greatly empathetic to the defendant, or they may. It depends on where they're at with the evidence in this case. But the defense is going to play the entire body cam, and the defendant continues to rub his face. So, yeah, it could definitely backfire on the defense having, the defendant praying with the chaplain if they believe what Juliana said led up to him being at the hospital. It could absolutely just piss them off. It depends.
And I'm here all day.
And the chaplain patient advocate is just doing their job, right? The chaplain advocate has no idea what
There
happened.
should be a few boxes of them around here for him now.
You have a lot to process.
The chaplain said you have a lot to process. Yep. That's accurate. Really hard to hear.
As I say, I'm here all day.
And the chaplain telling him, I'm here all day. The jury can see them interacting, I'm sure.
Thank you, ma'am.
I think he said, thank you, ma'am. Or law enforcement did. It might have been the cop that said it.
Mr. Banfield? Yes. Hi, my name is Mike Cangiano. I'm one of the detectives.
And now the detectives have arrived. Remember, they wanted to photograph him before they let him change. The hospital said, we will give you scrubs, and then they're going to have him change. Those clothes are going to be taken into evidence. And the detective came in.
My colleague, Detective Bryant back there.
Different response to that.
Detective Hampton. I'm so sorry to meet you under these circumstances.
And sir, is that the entirety of your body worn camera from that day?
Yes, sir.
Okay. And so did you manually?
Well, detectives are
shut it
there
off
at that
when the
point.
Detectives came in?
Correct.
Okay. And then uploaded it into the system?
Yes, sir.
Okay. Thank you. I don't have any further questions.
So what was the point of that witness, law nerds? Well, to show the jury the rest of the body cam and maybe argue, see, the prosecution didn't want to show you the part where he was crying. See, the prosecution didn't want you to see how sad he was. See, the prosecution didn't want you to see all this. They only showed you 6 minutes of it. So the entirety of the body cam, and then the detectives arrived. All right. That's the end of direct examination. Let's see if there's any cross.
Any cross examination?
Put this at 1.25 for cross. What, if any, cross?
Good morning. How are you?
Good morning, ma'am.
Just a couple of questions.
The court reporter and I feel the exact same way. What the fuck are those sirens? What is happening? Ma'am! Yikes! That was fucking painful.
Initially, when we
Look at Judge A's face. Judge A is just like, Judge A, I am I don't know, what is a good analogy? I am a referee for the NFL, and I do not understand why all of a sudden I am reffing a peewee flag football game. But what the fuck is happening? Because Judge A's face by day 5 is, what are we doing? Oh man. We feel you, Judge A.
Started this video. We started with the portion that the Commonwealth had previously played for you, where you entered and you responded that you were at that point in time working on trying to get a chest seal on Mr. Ryan. Is that correct?
We were trying to locate a chest seal for the female at the scene.
Okay. Were you the first officer to approach Joseph Ryan?
That day, I believe so, ma'am.
Okay. And did you place a chest seal on Joseph Ryan?
Eventually, yes, ma'am.
Okay. You didn't observe any blood coming from Joseph Ryan's chest wound, did you?
Not until after I did CPR.
And his hands were folded over that wound, is that correct?
They were across his chest.
All right. When you made it to the hospital with Mr. Banfield, he was not treated for any injuries to his leg, was he?
No, ma'am.
Or any other part of his body?
No, ma'am.
Okay, thank you. No other questions.
Any redirect? All right, is he still subject to recall, or is he done?
Are we done?
Is he subject to recall, or?
No, ma'am, thank you.
All right, you're free to go. Thank you.
Thank you, ma'am.
All right,
Done.
ladies and gentlemen, we'll go ahead and take our 15-minute recess.
And the court's like, they are done and so am I. So what was the cross-examination? Joseph Ryan's hands were across his body where that injury was. Fantastic. The jury's going to go out. They're going to take their 15-minute break. We're going to zoom past all of that and get to the defense's next witness and see how that goes.
All right, just before the jury comes back, I just had a question I had Shannon. On that video 82, it starts, there doesn't seem to be anything that needs to be under seal because it starts with him facing the bathroom and they walk out.
Oh, so then the judge unseals video 82. Well, that makes more sense. So they get through all the testimony. The first 6 minutes are where the victims are, and then the rest of the defense exhibit, the court's like, I don't think we need to have it under seal. Well, that makes sense. If that had been done before, we would have seen it when they played it for the jury, but that was done after the fact, so here we are.
I don't believe anything would need to be under seal.
I mean, we can review the very beginning, but you're just going to have just that
Yes.
exhibit for
Yeah,
81.
we're going to make sure that it's
Just
where we started.
Where you started. Okay, all right, so we won't have that under seal, okay? And we can just confirm when we get it. Yes, all right, perfect. All right, are we ready for the jury then?
So the judge unsealed
Yes, sir.
it after it was played in court. That makes sense. Andy said, EDB, I got my first wild grain box just before the storm. Excellent timing. I had a margarita pizza last night. They are so good. Dr. B really likes the margarita pizza. Jury's coming back in.
Baumler?
Yes.
Okay.
All right, next witness. That sounded like Officer Baumler, which makes me go bomb-bomb-bomb-bomb-bombardier. All right.
Case under penalty of law. Thank you.
Defense witness number 2.
Good morning, Officer Baumler.
Good morning.
Hello, Officer
I'm going to play
Baumler.
a clip for you, and I want you to identify it first, all right, before we play the whole thing.
Oh,
right?
Yes, sir.
boy.
We can't see anything on the
It's
screen.
not showing.
We might skip the body cam. I'm going to see what part of the body cam he's going to ask him about. But if it's from the beginning, if it's from the top, watch it drop. This is like the 5th time. No.
I think we may have solved it.
Yes, you have.
Looking at that picture before you, sir, Can you identify this video?
Yes, that's my body cam video.
Okay, and this is from February 24th?
Correct, 2023.
From time to time, I'll stop and ask questions, but otherwise I'm just gonna have you watch, not the entire one. Yours goes almost an hour like the previous officer, correct?
I believe so.
Okay, we're gonna be quite a bit shorter.
You want to mark it?
Are you?
Mark it as Defense Exhibit 83.
Okay. And is you asking to admit it into evidence?
Yes, we are, Your Honor.
All right, any objection?
Cumulative. It's cumulative.
Judge, I don't believe so. We indicated he's going to jump around this one.
It's cumulative.
Sure.
But do you object to the admissibility of?
Yeah.
Okay, so that can be an evidence. Is it?
Yes.
I don't know what it is, so does it need to be under seal?
Yes, it does.
Okay, so the body cam under seal in evidence 83. Okay.
Another.
There's a 34-year-old female that got stabbed by someone and then he shot him. He doesn't know the person that he shot, but he's on the ground. 50 Bravo.
I mean, I guess we haven't heard them radio traffic lights and siren, and then we're going to skip after we get to him arriving on the scene because we're not doing another hour of the exact same body cam footage. But lights and sirens are new. That's, I guess, the first time we've heard the radio chatter. It's like full wee-woo mode. I actually appreciated that they added the lower toned sirens for those of us that don't hear as well in the in the higher registers. I think I appreciate it. I always hear the lower tones on the sirens much better when I'm driving. So, it's definitely cumulative, but it's not cumulative within the defense case. The prosecution showed multiple body cams. The defense is allowed to too. Okay. I don't know who he's talking to. He's like, move it. Pull over for the lights and sirens, everybody. It does sound like he's talking to the traffic. There you go. Lights and sirens, move the fuck over. Move over.
Go ahead. If they're inside or outside or where they actually are. 10-4.
Officer Baumler, that's the radio traffic relating to this incident that you're responding to?
Yes.
And you're gathering information as you hear that radio traffic?
Yes.
Okay, thank you.
I'm turning it down as much as I can. Chad, I also talk to traffic all the time.
Got it on the shoulder, boys.
Emily, you're just amused at him yelling at traffic? Yes. Fantastic. It was snowing. They're going to go through, it seems, all of the the closed captioning says, God, you people. I can imagine the frustration. It's like they are lights and sirens very early in the morning to a multiple victim stabbing shooting. Of course, they are sitting there being like, get out of the way. I want to hear what they hear from the radio traffic real quick.
The patient is unconscious. Apparently she was stabbed in the neck. She's upstairs in the bedroom.
Sorry.
And the subject that was shot is in the bedroom downstairs.
Oh, interesting. So they, from the radio traffic, from the 911 call, they think that the person shot is downstairs, that the person stabbed is upstairs, which is, we know, not correct. Interesting. I think he asked, do we know who's the shooter? It's definitely not music, closed captioning. Okay.
Whatever units have shields, make sure they tuck on the radios. We know he has. Tank, we don't have time for a shield.
I want to know if we're going to figure out why medical wasn't there. It sounds like you now have a convergence of multiple law enforcement vehicles, but I'm curious if we find out why it took the ambulances so long to get there, because law enforcement was on the scene for quite a while before paramedics showed up. I'm just curious at this point. Oh, Chrissy, I know that medical waits for police to clear the scene, but medical wasn't there. They weren't on site. They weren't waiting. So it took them a while to get there because law enforcement had cleared the scene and was rendering aid for minutes and minutes before paramedics showed up.
Guys, you gotta go a little faster now.
So apparently the caller doesn't know the subject, and the caller's trying to help the female with the...
Now, at this point, is what you're hearing on the radio the only thing that you know about this?
Correct.
Okay, so there was nothing prior to you starting up your car and going?
So typically what happens is when we get sent a dispatch, it does come to our computer. However, when scenes like this happen, we try to get them as quickly as possible. So most of that information comes over the radio, yes.
Okay, thank you.
You gotta go. Drive a lot faster and better.
On 5 Bravo, Fairfax down is due to the wind.
What wind?
Law enforcement's like, what are you talking about? Which is not a funny situation. I can hear their frustration. I imagine that's the life flight, and they are just sitting there going, but what wind? What do you mean it's down? What wind? I feel for their frustration. However, we do know that the wind in the atmosphere, the wind higher up in the atmosphere and the wind at the ground level are not always the same when you're talking about helicopters. Yes, I agree with all of you. The wind in the air, not the same, but the cops are, I get where they're at too. They're just like,
go, Zach.
Come on. So I guess that Zach is in the, when I said it sounded like there was a convergence of two cars, I guess that Zach was in the patrol vehicle ahead of them. Apparently they're not proud of Zach's driving. But them trying to get to the scene being like, damn it, Zach, what are you doing? It's just a very stressful way to start a work day. But Zach, they're not happy with your driving, my guy, which is, I imagine, the last witness, right? Because the last witness's first name is Zachary. So I imagine that the Zachary Beckner is, damn it, Zach. Come on, Zach. Oh, all right. Continuing on with, it sounds like they're there. After they were like, damn it, Zach.
Go, Zach.
Sounds like they're pulling up in the cul-de-sac.
And just so we're clear, the body camera begins on what prompt?
So it can be activated one of a few ways. In this situation, it activates when the emergency equipment goes on, or you can activate it by pushing it twice.
Okay. And in this still, you're at the residence?
I'm just arriving, yes.
Okay. Thank you.
Them and Zach.
Yeah, you got one? Where's the shooter? Huh?
Shooter's helping the woman right now from 3 years. He doesn't know the man that he shot.
Which house?
1330.
Bravo, there's 4 of us at the door. 10-4.
All right.
Yep.
Other units are there.
Well, I got voices inside. Let's do something quick.
And that's picking up where we have heard multiple times, you know, these officers trying to figure out exactly what they're walking into and what they're going to do. We've heard this body cam a significant amount of times. So I'm going to try to zoom us past the like 5th replaying. It sounds like they are asking some questions. So I'm going to stop and see if the defense is asking questions of this.
Sir, you accompanied
Slowly.
Officer Beckner to the ambulance and all those sorts of things.
So in that situation, I believe what you're trying to ask is, was I in the ambulance with him? Can you clarify?
Well, so at some point, and we just watched Officer Beckner's video. I just want to make sure you went out of the house at the same time he did. Is that correct?
That is not correct, no.
Okay. Did there come a time where you met up with him at the ambulance?
Yes.
Okay. And then your body worn camera was essentially the same after that?
Yes.
In terms of the hospital and all those sorts of things? Okay. Your Honor, that's the 12 minute, 36 seconds. That's defense exhibit number 83.
Okay, so you'll crop it for me to 1236?
Yes.
Okay, to 1236. All right, thank you. It's in evidence up to 1236 then.
I don't have any further questions for the
All
officer.
right, cross-examination.
Chad, I know all of you are asking me, Emily, what is the point of this? The defense wanted to have the first 12 minutes of a different body cam with a different angle. Maybe there's something that's more clear to see on this officer's body cam than the others. We can't juxtapose this body cam with the 4 other body cams covering the same period of time because we can't see these because it covers the victims being discovered at the scene. Let's see if there's any cross.
Good morning, officer.
Good morning.
I am immediately reminded that we're not at 1.25 speed and hating that we're not. So back at 1.25.
Afternoon. I apologize.
Kamika, they were just driving, but then they went into the house. Once he said, we got to decide to do something quick, I skipped the rest of it because we've heard from the officer saying, I hear voices inside. We got to do something quick. We have seen that play out or listened to it play out on 4 different body cams. So I skipped all of it because we're trying to catch up in real time. I skipped it. When I said we didn't have time for gavel-to-gavel coverage of this case, I meant it. So there are some things we're going to skip, which is not our usual when we're in real time doing gavel-to-gavel.
You entered the room. Mr. Banfield was on his knees next to Christine Banfield. Is that correct?
Yes.
Okay. But Mr. Banfield wasn't using that blue towel we see to staunch the bleeding from her neck. Is that correct?
Objection to leading. Judge.
Oh, it's cross-examination.
Cross-examination.
You did not just object to leading during cross-examination. Defense, just because you don't lead on cross-examination, sir. It's a good question on cross. You arrived, defendant was kneeling down at the victim, but was not using a towel to staunch the bleeding. He's not trying to stop the bleeding. That information has a lot more weight and context for me after seeing the victim's father testify. A lot more context.
Correct?
Yes.
Okay. But Mr. Banfield wasn't using that blue towel we see to staunch the bleeding from her neck. Is that correct?
Objection to leading, Judge.
It's cross-examination.
Cross-examination.
I do not believe he was, no.
The prosecutor and the judge both saying it's cross-examination. Mm-hmm.
Okay, and he wasn't using the nearby blankets, correct?
Correct.
Okay, and he wasn't using the sheets?
Correct.
Okay, thank you. Nothing further.
All right, redirect.
So the defendant wasn't doing anything to try to stop the victim's bleeding. Nothing further. Good cross.
Okay, is this witness subject to recall?
Yeah.
She's subject. Okay, you're free to go. Thank you.
Thank you, ma'am.
All right, your next witness.
All right.
Your Honor, I have a video that Ms. Sands and I have talked about
Why? Why? What? A video of what? A video of what? A video of what? Amy with Hay said,
Judge, I think the witness that we need for this.
I have to say, not only am I on full watch, but also 40 chapters deep into Iron Flame thanks to EDB. See, we're on the same page. What does the defense need now? Boo-boo, what do you need? What? I have a video.
This video is not here right now,
Okay.
so we'll just move on.
Next witness.
My next witness is LeeAnn Singley.
All right.
I have a video, but that witness is not here. Okay, counsel, why do I need to know that? Just call your next witness. Witness number
You swear
3
or
is
affirm to testify
LeeAnn.
truthfully in this case under penalty of law.
We're at 1.25. Defense witness number 3, LeeAnn, I think it said Singley. I enjoyed the Empyrean series. Then again, just like apparently I can be persuaded into a trial, but by the simple, but Emily, it's Judge A. I can also be persuaded into a book with things like, but Emily, dragons.
Bear with me, Ms. Singley.
No. Emily, are you just fast forwarding until closed captioning says something's happening in court? Yes.
Ma'am, can you please state your name, spelling your name for the court reporter?
Sure. My name is LeeAnn Singley. First name is L-E-E, capital A-N-N. Last name is Singley, S-I-N-G-L-E-Y.
And what is your particular professional discipline?
I'm a forensic scientist.
Okay, and what areas of forensic science do you specialize in?
So currently I work mostly in bloodstain pattern analysis.
Okay, and can you tell the ladies and gentlemen of the jury about your background and your training in bloodstain pattern analysis?
Sure. I guess I'll start.
Ma'am, we love your background training and experience. I imagine you are eminently well qualified to do the things that you are doing, just like the prosecution's expert. And for that, we are going to skip through your background training and experience from, it looks like, the University of Florida and the Pennsylvania State Police Crime Lab. And she has been doing this for 39 years, according to closed captioning. They generally get that right. Started her education in bloodstain analysis in 1993. Fantastic. We love that. Any titles or groups or board certifications? Fantastic. Part of the forensic science discipline? Fantastic. We love the background training and experience. You have testified as an expert. Great. Let's see. All right. Into the evidence.
If you double click on the file name right there, you have. There we go. No, you have the same problem.
Oh dear.
Judge, this is the court's PowerPoint that's coming up. I don't know. Zoom. Ma'am, did you have an occasion to review items in this case?
I did.
And
I would expect that she did.
Items of evidence relating to this case?
Oh, why do you need to ask that
I
twice?
received photographs, so I didn't actually have the physical evidence, but I did review photographs and videos and things of that nature that would expose me to what was evidence, turned out to be evidence in this case.
Did counsel say, will you look at this photograph? Yes? Yes, Chad, I am at
Your Honor,
1.25.
I think I'm going to have to switch the computer just because of that PowerPoint thing that pops up. Can I have a 5-minute recess?
No.
Did you see the witness's face? Chad, if you're listening in the background, come on back. I'm going to put this back to normal speed. Can I have a 5-minute recess? No. And the witness is like, what? This is the defense's witness 3. And the judge is like, no, you can't. I'm gonna slow that down and play it again.
Computer, just because of that PowerPoint thing that pops up. Can I have a 5-minute recess?
No.
That was a swift response. And the witness was like, oh boy, ma'am, you have no idea what happened before you got here. Judge Hay is just like, no, the fuck you can't. No, the fuck you can't. Counsel, you have wasted so much time this fine morning of court. So the witness is like, what are we doing? I am going to put this back at 1.25 speed and keep zooming past.
Were you able to see a picture on your screen?
I can.
Did you have an opportunity to...
We're back at 1.25 speed, but the judge is like, no.
Review this item as part of the evidence that you reviewed?
I'm sorry. Judge, have we identified the photograph?
No, I think it's defense 80, at least that's what it was marked yesterday.
83, I believe, Judge. Is that-
80.
80? Okay.
Yes.
Ma'am, I'm going to have you look at what has been marked as Defense Exhibit 80. Have you seen that?
I've seen photographs of this item before, yes.
Okay, and what is it that you notice when you look at this item right here?
It's a knife. It looks like to be stainless steel, like a chef's style knife, and there appears to be transfer bloodstains or some irregular shaped bloodstains along the knife and the blade.
Now, in talking about bloodstains,
and we saw this knife
is there
in other days of
uniform
trials.
Terminology, or were there attempts to have uniform terminology as to what bloodstains are and varying other descriptive terms?
You mean the actual terms we use when we're writing reports? Yes, the organization that I mentioned to you earlier has set down standard terminology that we would use in the course of writing reports or training or even just discussing bloodstain pattern analysis. And so that has been published.
And or is that how you find, do you find that the terminology is uniform amongst bloodstain pattern analysis?
The goal, that is the goal, that it would cause uniformity. And it has definitely helped since that terminology has been utilized or has been written and published. To say that everyone is using it correctly or abiding by that terminology, I can't say that for sure, but I can definitely say that it has, the ends have sort of,
they have endeavored.
The end result has been what we had hoped it would be, and that is to cause the uniformity of that terminology across the discipline.
I appreciate that the expert answers quite well. I've got it sped up to 1.25. So the expert is answering in a much easier flow of normal speech. The defense attorney's questions are so slow. They are so slow. But I imagine where we're going with terminology is going to be a battle of the experts, right? Because at the beginning of this day, and for those of you just coming in, don't bother rewinding it. For the beginning of this day, the prosecution asked if their blood pattern expert could watch this blood pattern expert's testimony, because it seems we might have a disagreement of the experts.
Did you have an occasion to also analyze or look at other aspects of evidence, like the forensic science reports and things like that?
Yes, when I do a bloodstain pattern analysis, the discipline itself is the study of the size, the shape, the distribution, location, appearance of bloodstains. But in the course of the bloodstain pattern analysis, we also have to include or consider what we call task relevant information. So information that is relevant to the bloodstain pattern analysis, not necessarily extraneous information, but those things would be like the autopsy report or medical reports if the individual wasn't deceased, or the DNA reports or other forensic laboratory reports that will help to actually include or exclude classifications and ultimate interpretations at the end.
Now, ma'am, if you look at the picture, there's a specific circle relating to an area of that knife that you've just identified.
Just for the record, you had marked that as 80A yesterday. The one with the circle.
80A. Yes, yes, thank you.
That's what you
Identified as Defense Exhibit 80A. Do you see that?
This was an issue throughout the cross-examination of Juliana, where every time the defense said something, the court reminded him to mark it. We are watching day 5, which would have been Wednesday. You can understand why by the end of the day, Friday, the court was like, get it together. So this is the lead up to Friday where the court is just like, stop it. It is not well organized. It is just not well organized.
I do.
And do you recall any analysis that you reviewed relating to that particular area of this knife?
Counsel, what analysis did you review regarding the knife?
Yeah, this is the area of the knife that is at the base of the blade where the handle meets up, and it is one of the areas that was sampled for DNA analysis.
What did you review?
And did you observe any findings relating to that?
Yes, this area of the knife had DNA. The DNA of Christine Banfield and Joseph Ryan could not be eliminated from that sample.
And were there any others that were excluded from that sample?
I believe Brendan Banfield and Juliana were eliminated.
Okay.
Right. From the
And
DNA.
is that what you're referring to? The next page.
What's the
yes, sir.
report?
Okay. And
Are
that's,
you going to say what it
Yeah.
is? Are you going to say what the report is? What are we all talking about? What report? And it sounds like the prosecution has an objection.
Object. This is not.
Well, I mean, he hasn't entered anything into evidence yet, but,
Understood.
and I don't know what this would be marked as.
Okay. ADB
You already have it.
or AD?
You have ADB, ADC, ADD, 82, 83.
Uh-huh.
I'll go ADE.
Sure. Sure. Mm-hmm.
All right, he hasn't entered into evidence yet. He's just showing the witness.
And what do you see this is, ma'am?
It's the results of the bloodstain, the DNA
This is
report
DNA.
that addressed this area of the knife.
Okay. And that's a report that you reviewed in your analysis?
I did.
And this is a portion to highlight that particular statement?
Yes.
Okay.
The prosecution already called everyone to testify at like a full day of the DNA reports.
And ma'am, is this also from the report?
Are you going to mark this something?
ADF? Did you have a chance to review that?
Yes.
Okay. And is this also a report that you reviewed, a portion of it?
Yes.
Okay. And what does that tell you?
Again, it's indicating that Christine Banfield.
Your Honor, I would object to the witness reading from a report that has not been admitted into evidence and is not the complete
Okay, I'll
report.
sustain that
That's
objection.
fine. That's fine. Judge.
Apparently, the "that's fine" is contagious in court because now we have the defense responding to the objections and the court sustaining the objections with, "That's fine. That's fine. That's fine." Do you know, it's giving dog in a burning room meme where the dog's just sitting there being like, "That's fine. This is fine. This is fine." The DNA evidence came in through testimony. The reports don't come in. That's fine. That's fine. And the defense made a lot of headway keeping things out for the prosecution. I imagine that the prosecutor is going to return the favor as we get into the expert because there's going to be a lot of objections, I feel. Oh boy.
And ma'am, did you have occasion to review the Office of the Medical Examiner's report relating to Joe Ryan?
I did.
Okay. And what, if anything, did you observe in your analysis relating to the pictures from the Office of the Medical Examiner?
Well, I looked at the photographs of Joe Ryan at the autopsy examination, and in part of that, I was able to review the injuries that he sustained.
Okay. Now, the topic of self-wounding came up with this graph yesterday. Is self-wounding something that is often found in knife injuries?
Your Honor, objection is to leading.
Well, I'll sustain as leading if you want to rephrase.
Okay. What, if anything,
Objection. Leading. Sustained as to leading. If you would like to rephrase, what, if anything? What, if anything, is not a cure-all? Elaine? What is happening? Okay. Well, we have just slipped into the Twilight Zone. I don't know, chat. I don't know. I don't know. Cue golden earring. We just... Okay. Okay. There's the what, if anything.
Do you find as an expert in knife-related wounds?
So in knife-related activities,
Also note that counsel said, what do you observe in knife-related wounds? That they're cutting wounds? He's trying to get back to the issue of slippage, but I don't know if we'll get there.
Investigations that involve sharp instruments, so knifings, things like that, of those nature. We often see the assailant, it's not uncommon for the assailant to self-wound during those. In fact, when I'm training individuals, it's one of the things I train law enforcement investigators to ensure that they look to areas of the crime scene that may be far further away from the victim's bodies to find an isolated blood drop or things like that. So we know this to happen, and it can happen in various mechanisms during the activity that's going on in terms of the criminal investigation.
So like if you cut your thumb and then had to go to CVS and get like bandages and stuff, but if you didn't have bandages and you just put gauze and like taped it up like that type of wound.
It's not an uncommon occurrence.
Okay. Were you able to note where the injuries were in your examination for Joe Ryan?
It was on his left thumb, I believe.
Anything? Did you observe anything else?
I think it was a puncture. It was listed as a puncture wound.
Now,
so Joe Ryan had a left thumb puncture wound. That explains why the other experts said that they did not think it was a slippage wound, because that would not be a puncture wound. That explains why the other experts said, no, this is not a slippage wound. And no, we don't have anything on the record to show what handedness Joe Ryan was, if he was right or left-handed.
Is that the puncture wound that you're talking about?
I'm sorry, I can put it back on.
Sorry. This would be ADF?
It was ADB yesterday.
Oh, shit.
ADB.
Okay.
So this photo here that you have now.
This is ADB.
The wound was listed as a central cut puncture of the palmar aspect of the left thumb, and that is what's being depicted here.
Okay. And if ADF, Judge, would that be the next in line?
You have one mark AEC, which I had put down as finger of Joseph Ryan, and I'm not sure if that's the same picture that you used yesterday when you're showing the other expert.
I'm not certain either, Judge. What's the next one? ADB?
Fucking hell.
Well, we'll do ADC. I mean, we can make this ADC. That's
ADC,
fine. You haven't
yes.
entered it in evidence yet, so ADC.
And ma'am, is this a picture that you've observed?
Sir, if your client is convicted, some appellate attorney somewhere is going to just be screaming into the void about what a mess this record is. Because the record has been just so unclear. And as defense counsel, you need the record to be clear for whatever appellate attorneys are going to have to work on it. It's just a mess. It's just a mess.
Observed in your analysis of the documentation relating to this case?
Yes, these are part of the autopsy photographs.
And is that the same injury that you've previously discussed and identified?
It's on the left. Yes, it's in the same location.
And what is that picture of, ma'am?
It's another photo of a different orientation of the thumb.
Okay, so the same injury?
What do you
It appears to be, yes.
What do you want to mark that as?
ADD?
You have a D, you have an E, and you have an F.
ADG?
Okay.
Okay.
Now, ma'am, in your review of the body, so let's just go through. What did you review Or did your review include body worn camera?
It did.
Okay.
Which
Were
question do you
able
want her to answer?
Review body worn camera to determine if there were any injuries to Brendan Banfield's hands?
Yes.
Okay. What if anything, did you find?
Well, I reviewed the video, the body cam video that took him into the ambulance, and they specifically looked at his hands for injuries, and the I guess it was an EMT, whoever was in the ambulance with him, it indicated there were no injuries.
Okay. Now,
Okay. I don't know if that's new, though, from the prosecution's case in chief. And yes, we are at 1.25.
Take a look at the screen. This is the full Office of the Chief Medical Examiner report. Have you had an opportunity to review
There's
that?
nothing on the screen. There's nothing on the screen.
I'm just going to zoom until we get back to questions. I'm sure the jury is ready to rage quit. Sir? The witness is just sitting on the stand blinking. We're still not
Did you show up on your screen?
It was when he was there.
Yeah, I know. I think I'm touched the wrong thing.
Defense says I think I touched the wrong thing. I'm on 1.25 speed. And let's see if it's up now.
Do you recognize that?
This is the DNA report.
Okay.
Okay. And I'm going to scroll down.
You weren't talking about the DNA
Is this the
report.
area down here where the cursor is that you previously reviewed?
Yes.
Okay. And that
You weren't asking about the DNA report. Okay.
informed your conclusions as to the blood stain near the handle and the handle juncture?
Yes.
And ma'am,
And
can you see this on your screen?
I can.
Okay, and you've reviewed this. This is the report of June 9th, 2023 of the Office of the Chief Medical Examiner?
Yes.
And I'm just going to scroll down.
And
Is that what informed you as to the exhibit previously?
Yes, this is an area that describes additional injuries.
Okay.
okay.
Now, did you have an opportunity to review a report from DLI, a private laboratory?
I did.
Okay, and in that report, can you tell the ladies and gentlemen of the jury, what was the sample that they were providing?
So in the DLI report, there was a sample that they that was
DNA
collected
report.
by them on the area of Joe Ryan's jeans. That was the waistband, I think interior and exterior waistband zipper, and I believe the button area. But the significance of their sampling was that in their report, they stated that the sample was taken avoiding staining, meaning that they were not trying to collect staining. They were trying to avoid stained areas of that part of the jeans.
Okay, and what would you say about avoiding the staining and still having a laboratory analysis? What are they looking for?
Typically, they're looking for a DNA source that's not coming from staining. So touch DNA, or sometimes they'll do it just to determine.
What does it mean if it says they're avoiding staining? Well, it means that they're trying to avoid the staining. Okay.
Who the wearer is of an item of clothing, or sometimes they'll do it just to see if somebody touched that area, that they're curious if they can find the DNA from that individual.
Okay, and do you recall the results of that report?
I believe the results of that area that included DNA sources from Christine Banfield and Joseph Ryan, but Brendan and I believe Juliana were both eliminated.
Okay, so let me kind of shift gears here about bloodstain pattern analysis and what
No. Don't shift gears if you're going to shift back, counsel. Just if you just go by topics, it's easier for the jury to understand and it's easier for the witness to understand. So if you just prepare topic by topic, it would be easier.
Without doing it in a case.
You mean my general methodology of how I do an approach? So when I get a case now, and currently I get a case, I want to know as little information about the case as possible. So I try to limit whoever is requesting it from me to just the information that I need to know in terms of the bloodstain. So typically that might be like how many individuals were injured, or if there was more than one deceased, more than one bleeder, what their injuries might have been, things of that nature. And then I will get whatever materials are provided to me. I start looking through the photographs, determining what I can say or maybe not say about certain pattern types. We call that the characterization. We characterize them, as I mentioned, through the size, the shape, the distribution, location of the stains. We look to see how they might correlate with each other. And then we begin or attempt to list a classification or classify them in what might have caused them. So earlier I talked about those characteristics, and I think it's important to understand that bloodstain pattern analysis is answering a very different question than DNA analysis. DNA is answering the who, the BPA, the bloodstain pattern analysis attempts to answer the how. So how the bloodstains got to a location. So once I've done that initial preliminary classifications or some idea of what I believe this might be coming from, I'll then incorporate in things like the autopsy report, DNA analysis, that will help us to refine that classification, maybe eliminate some things that I might have kept in the running in terms of a classification. Then at the end, we discuss what those classifications mean in terms of the DNA and what we might be able to interpret in terms of individual events or things that happened at a particular crime scene.
Now, can you see the picture that's on the screen there?
Fluid flows towards the earth because of gravity.
I would identify that as Defense Exhibit 84.
I believe it's already the Commonwealth's Exhibit 173, is that correct?
So Judge, the original picture was admitted as Commonwealth's 173.
Okay.
His manipulation of the picture to show the cropping side by side with the original is not.
Okay, so, all right, so what number did you want to
I think 84 was the next one.
Yes, okay.
Ma'am, can you describe what you're seeing there on the screen?
Yes, this is the left forearm of Joseph Ryan and bloodstains that were on that left forearm.
Okay. And did you create this side-by-side comparison?
I did.
And what was the intention of that? What were you trying to show?
Just it gives an overall of the arm. You kind of see it in that perspective. And then just I put a square around the area that I cropped so that you could kind of see it, how it related to the arm in total.
Okay. Your Honor, can I move that in as Defense Exhibit 84 and publish it to the jury?
Any objection? No objection. All right, 84 in evidence.
Can you describe what you're looking at for the ladies and gentlemen of the jury and what it is that you do in analyzing something like this?
So first, let's start with what I do when I'm analyzing something like this. Again, I know I'm sounding repetitive, but I look at things like the size, the shape, the distribution, location, and certainly take into consideration the target surface. We know that has a profound effect on what we see. So we have to think about that when we're looking at things like size and shape, because it can change depending on what the target surface is. This target surface was a bit unique in the sense that it was a forearm that had quite a bit of hair on it. So it provided a different surface than, say, a flat table or even carpet. It tended to have an influence on what we were seeing.
Now, what is it that what is it that you can say about this stain pattern?
So I just described what I saw here, which was a linear series, so a series of some irregularly shaped drops or stains that were located on this arm. I did not use the word drop. I used a series of irregularly shaped smaller stains, because if you look at it closely, the stains themselves are almost three-dimensional in shape, because they in areas were clinging to the hair on the arm. So it distorted what we can see in terms of its true shape and true, like even the size of it. There's no measurement in here, so we really don't have a true size.
Okay, and so in determining what exactly this stain is, you would want measurement?
Well-
You would check out what the surface is?
Yeah, I mean, we don't always have measurements. Sometimes they're not there, and we can use things in the area that can sort of inform what our size might be. But I don't have a true size. I did call them smaller because they appeared smaller compared to things around it in the area. But yeah, I mean, certainly the more information you have, the more data we can use to then make a classification.
Based on the information that you had relating to these stains, is it possible to make a classification?
I did not make a classification, and it's this target surface did not lend to classifying these stains to a specific mechanism.
Now,
Okay.
let's switch gears a little bit.
So, because the arm is more dynamic because of arm hair, she did not want to categorize it in a particular way because of the surface. Okay. With regard to the victim's arm, we heard, I think, more about his hip, some about his arm, but more about his hip. Though the other expert did say some of that was like smudging and transfer. So,
In terms of how blood falls on things, can you opine as to what kind of pattern would be created if someone put blood onto a surface?
Put blood on how? How are you? I mean, touching a surface? If it
Holding blood and dropping it?
put blood onto a surface. Sir? This is the defense's expert. I guess I expected that there would be an organized direct examination for this expert, and maybe my expectations were improper. But the prosecution has said this case is about, yes, listen to Juliana, but also it's about the blood. You have an expert who is supposed to counteract the state's expert, and yet it's really difficult to follow.
If an individual had, say, blood in their hands that had enough volume for it to release, like if it were to just drop to the ground, we would call that a splash pattern. So it would be a large volume of blood that is falling due to gravity. It's not, you'd have to be careful to not include their hands swinging, because if their hands swing in that process, now you have cast off, which is blood being released from an object in motion. If it's just merely falling onto the surface, then you would get a splash pattern. That usually will then have sort of a parent area of where the volume of the blood is. And then because that parent area was created with blood sort of collapsing into itself, it'll create satellite spatters around that area.
Okay, and have you worked with those kinds of patterns?
Yes, I mean, I make up mock crime scenes for my training, so I've created them myself by doing that.
Now, is it plausible?
Tell me more about creating your own crime scenes. I'm just really curious about that.
For someone to scoop up blood and carry it to a deposit somewhere?
I'm sorry.
Objection, leading.
All right, I'll sustain as to leading.
He can phrase it like a hypothetical, though, but the prosecution's not going to give him any room to wiggle at all. Oh boy.
What, if anything?
Not a cure-all, counsel.
Well, first of all, let's just talk about how would one scoop blood?
Huh?
I don't know how you would do that.
The witness's face is like, what do you mean?
Scoop it up from something like, and it's a fluid. I think it'd be difficult. It's not like you can, like you have a dustpan that you could, you know what I mean? When I think of scooping in that nature, I just think in terms of if I had spilled something on my floor in the kitchen, I wouldn't be able to pick it up with my hands, if that's what you're asking.
Though if you put your hands together under a faucet, you can. Okay, I'm gonna just. Okay.
Okay. If does the surface that the blood is on, does that? I mean, you're saying you don't know how it can be scooped, but does the surface matter?
Yes, I mean, yeah, I mean, if you have the blood on something that's porous and absorbent, then there would be less blood that you'd be able to even scoop, if you will. If you know what I mean, there would be less blood. You wouldn't be able to access it because it would be soaking in to an absorbent surface.
Okay. Have you ever experienced in blood?
So counsel is trying to get to the testimony of Juliana. Remember, Juliana, the co-defendant, testified that Banfield essentially scooped blood from victim Christine and dropped it onto victim Joseph Ryan. So got blood on his hands and then dripped it. But Christine's words were scooped. And I think at that point we all went, scooped? Okay. So that was the word that Juliana used. Okay.
Stain pattern analysis of someone scooping blood and pouring it in another place?
No.
What would be the difficulties of that if that were to have happened?
Well, I think getting it into your hands to begin with would be a challenge, and then transferring it.
Your Honor, I would object at this time. Calls for speculation. She's just testified that she's not.
She's an expert. She can testify as to hypotheticals, but we'll see where it goes.
Had any experience with any scooping of blood. So I'm not.
Speculation.
I think her expertise in blood spatter analysis gives her an opportunity to opine as to how it could be done if it was.
I'll sustain that. For that question, I'll sustain the objection if you want to.
He needs to phrase it as a hypothetical.
I'll rephrase.
Hypothetical. A lot of you have asked about efficient counsel, inefficient counsel. It's probably a good time this trial to remind everyone that the style or the organization of the attorney is nowhere near the bar for ineffective assistance of counsel. That bar sits on the floor, basically, with an attorney that fell asleep at counsel table, never made an objection, didn't read the court file, didn't ask any questions ever, didn't have a strategy with their client, forgot to make essential motions like a motion to dismiss. The difficulty with defense counsel is difficulty, but he is putting on witnesses. He is objecting. He successfully kept out some of the things that prosecution wanted to get into. Yes, he did later then open the door himself and it came back round, but he is engaged and doing the work in this case. So no, that we're not even close to that bar. It's stylistically challenging.
Is it possible to pick it up?
Pick it up on, yeah. I mean, I think it's difficult. I think the difficulty here is, of course, you can touch blood and it picks up onto your fingers, right? Like if you, as a transfer stain. I think the fact that it's a fluid, the challenge is that if you're trying to collect and keep it in the confines of your hand, the first part is getting it into your hands, and the second part is not having it seep back through your fingers, out of your hands. Does that make sense? So like the only thing I can use to describe it is when I'm making a mock crime scene, sometimes we'll put blood in our hands and make like an impact pattern from it. And just putting small amounts in the hand, it's difficult to contain it in the hand, even in doing that, right? So that's about the closest I can get to having an experience of what it's like to actually, and that's when we pour it into our hand from, a cup.
I mean, did you see the victim's injuries in this case, though? I understand that you're talking about pouring it and that there's volume, but there would be volume if the defendant had stabbed the victim. There would also be volume there.
I know this sounds a little, we do this because we use real blood when we do training. So I know what it's like to have blood in the hand and trying to work with it in that way. It's a challenge.
Okay. So just to follow through with your example, what is it that you're trying to show when you would do these trainings?
So all I'm doing is or me or my trainer will put it in there because we're going to ultimately smack it to create an impact pattern. And by putting it in your hand, you're able to place your.
However, staging fake crime scenes does sound like an interesting aspect to the job. Rebecca wants to know, says, why are we even talking about scooping blood? It's the language that Juliana used to describe how Brendan got blood from Christine and dripped it with his fingers onto victim Ryan. So Juliana described scooping it. She might have, when she said scooping, I pictured cupping with the hands. That's what I pictured, cupping it and then dripping it onto victim Ryan. And we saw the prosecution spend quite a bit of time on the drops to victim Ryan's hip that looks like victim Ryan is laying on the ground, and then that drop hit his hip and then continued to drip towards the floor, back towards his back, not like dripped on his leg down towards his feet where he was standing up. The prosecution's going to argue down the road that were victim Ryan standing up and stabbing Christine, then her blood would be dripping on him as if he was standing up, not as if he was laying on the ground. So this is all going to rebut the testimony of Juliana and rebut the prosecution's expert. Though we saw the pictures of those blood drops on victim Ryan, and as to the blood drops to the hip, it's pretty clear where those are going. So as she is explaining it, she's also explaining that they do put blood into the hand and do things with it when they are staging crime scenes. So again, saying, yes, it's possible, it's just difficult. I'm interested in what Cross says. So we'll
hand in a mock crime scene to kind of mimic where somebody might have been beaten or something like that. So we're using it as a training tool for that purpose. It was just an example of the challenge of keeping it contained within the palm of your hand.
Okay. Now, going back to your review of the evidence in this case for purposes of blood stain pattern analysis, did you see anything that indicated that Joe Ryan not being involved in the stabbing?
Objection leading.
Yes, I'm sorry. Objection leading.
All right, I'll sustain as to leading.
Okay. What indications, what if anything, do you look at to determine if someone's involved or not involved in an incident dealing with stabbing?
I didn't want him to mention it all. We're just back to the what if anything. He's trying to ask an ultimate question of, do you see anything in this crime scene that indicates that Joe Ryan was not involved in the stabbing or was involved in the stabbing, or anything that excludes him or includes him in being involved in the stabbing of Christine Banfield? It's just clunky how we're getting there. As you can see by the witness's face.
I think maybe I would like to answer it in the methodology of how I look at a bloodstained case. Once I've evaluated the pattern types and come to some classifications and come to some interpretations of how they might relate to each other, I might be asked, or sometimes I'll even have information, like I might have had in this case, to look at it and think of it in terms of statements that were made, or that we had information from the body cams that I had when I was looking at that. So when I do that, I can kind of evaluate the evidence to see if there's anything that sort of doesn't seem to align with one way or another, or some things that not necessarily that do, but more.
One way or another, you say? I'm gonna get you. I'm gonna get. Okay. We're back from one way or another. Emily, rein it in. I can't. Even at 1.25, it's hard to follow.
More looking for the things that might raise, quote, the red flag, like kind of go, oh, this doesn't seem to align with that. Maybe I need to do some more exploration or find out more information about that. So that's what I did in this case.
Okay, and did you? And it sounds to me like you're looking for things that rule someone out and things that stay with the possibility of being one of the people there.
Yes.
Okay. In your pattern analysis, bloodstain pattern analysis, did you find anything that would exclude Joseph Ryan as being involved in the stabbing?
Objection calls for a final conclusion. Goes to D.
If you want to approach.
Yes, please.
So they're going to approach. I think this is where the prosecution ran into some issues with their expert regarding what Judge A and where Judge A draws the line of asking the expert for an ultimate conclusion. The jury are the finders of fact. And where the line is different for each judge and each court, depending on the case law in that jurisdiction. but the prosecution wasn't allowed to get there with their expert. It'll be interesting to see what the court does here.
Ma'am, you had an opportunity to listen to Ms. Graff yesterday, correct?
Yes.
Now, in terms of your discipline of bloodstain pattern
Looks like he's trying to go about it a different way because he's not getting back into the same question he asked.
analysis, is it your experience that everything can be labeled based upon an analysis?
Judge, objection is leading.
What, if anything,
I'll sustain objection. Go ahead.
yes, what, if anything, is your experience as to labeling every aspect of spots, even if they're not tested?
I'm not sure what you mean by labeling. You mean classifying them?
Classifying, sorry. That's,
I'm sorry, say it again. So what is my experience regarding whether you can classify everything
Yes.
in a crime scene? Oh, no, many times we can't classify certain stain patterns because of some of the things I already mentioned. It could be the target surface, the amount of stains that we have, the other data that isn't just available for us to form that classification. So that's not uncommon. And we can't really classify every single bloodstain. We don't attempt to. In many cases, we could be doing it a long time if we tried to identify or even address every bloodstain that's at a crime scene.
okay. And in listening to the
that's fair.
testimony yesterday, did you have any agreement
Ma'am, she's wrong, right? Can you tell us why she's wrong?
or disagreement with what she said about certain bloodstains?
There were certain bloodstains that I did not provide a classification for that she did.
Okay. And are there any in particular that you're speaking of?
Well, the forearm stains was one area. The 4 irregularly shaped stains that are on the forearm, she provided a classification for as being drip stains, and I did not.
Okay. And why did you not provide a classification?
Again, as I stated, the target surface here really distorted or what we were able to see to get that sort of well-formed circular stain that you would be looking for to be able to say that it's a drip stain from the exclusion of all other mechanisms. Because once you've classified it as a certain mechanism, you've excluded everything else. I didn't feel there was enough information here for me to do that. And this target surface, it would be inappropriate, I believe, to do that because the target surface was not ideal for being able to do that.
Now, if you didn't have enough information, would it be possible after the fact, which is what
Objection.
The problem is that the jury has these photos and the jury has eyes and common sense. And so without being able to look at what she's talking about, if the jury looks at the photo and is like, that's obviously dripped on there, they're just going to discount what she says. So the defense has to be careful if it's something that the eye of the jury can look at and be like, that looks dripped. Because especially when you get to the drips on victim Ryan's hip, if you try to argue that those didn't happen while he was laying down, I think it's really difficult to try to convince a jury that the thing that they saw is inaccurate because it's very obviously dripping down towards the victim's back. So it depends on what these look like, but she's not saying the other expert is necessarily wrong. She is saying, I wouldn't have categorized it that way because the surface is not ideal for a categorization. And so I would not categorize it. So her categorizing it, I disagree with. Okay.
Mr. Leading.
All right, I'll sustain leading. Is this a good time to take our lunch break?
Yes, sir.
Okay, all right, ladies and gentlemen, let's go ahead and take our lunch break for an hour. Please do not discuss the testimony discuss the case with anybody, and don't do any outside research, okay? Thank you.
So they are going to lunch. So they are going to lunch. The court is like, help us, please. That's hi, George. No, you're just zooming right to where the birds are. I don't even know if you guys were able to see him jump up here.
All right. And ma'am, since you're testifying, you can't discuss your testimony.
I just want to hear if the
It's time
court says
include
anything to the
okay?
jury.
All right, that's fine. So we'll come back at 2:05. You're going to make sure all your technology is ready for the afternoon. Include your exhibit numbers, please.
I was
I wanted to hear if the judge was going to say anything to the defense. Her face says enough.
The defense team, okay?
Okay.
All right, that's fine. So we'll come back at 2:05. You're going to make sure all your technology is ready for the afternoon.
I'm
To
gonna-
include your exhibit numbers, please.
I was actually going to just talk to your clerk and make sure that I had all of the.
All right, to make sure
This
you
meal.
get it straight. And
Yes.
you don't have to be a hero. I do take paper documents if necessary. You know that.
Hey, counsel, just do it old fashioned. Just print it out, buddy. Just print it out. Don't be a hero. If you are in trial, I understand how many documents it can be, but the exhibits that you are going to use that are critical for you, you should have a binder with them printed out.
Judge, I just can't do that. I'm a technology guy now.
What was that answer, counsel?
Paper documents if necessary. You know that.
Judge, I just can't do that. I'm a technology guy now.
He's already said. So you're saying, okay, 2:05, okay?
Thank you.
All right.
But Your Honor, I'm a technology guy now. No, sir, you are not. Not Courthouse Becky said, you sit on a throne of lies. Wow. Well, we are at the lunch break of day 5 of the Banfield trial, the first few witnesses of the defendant's case. And I don't know if I would say I was optimistic that defense counsel would be prepared or more prepared for his witnesses than he was for the cross-examination of the co-defendant. But whatever little hope I had is been thoroughly quashed at this point. And the first day of the defense case has been clunky at best. He brought in 2 law enforcement officers to show the entirety of their body cam footage, to include the body cam footage of the defendant in the ambulance and then at the hospital when he was told that his wife passed away, and interacting after that up until the time the detectives started to interact with him at the hospital. So the jury got to watch the entirety of that body cam and then a second body cam of another officer responding to the scene and then getting to the scene. And then the defense's first expert, their blood pattern stain expert, and they are hitting some of the same objections that the defense hit the prosecution with on what their expert can testify to and can't testify to. So far, we have gotten to the blood on victim Joseph Ryan's arm. This expert is saying that she would not have qualified those or categorized those or classified those, whichever one of those words she used, as drips, because the surface of the arm is more dynamic because arms have hair, and the dynamic surface makes it hard or impossible to categorize the blood on the victim's arm as drops, meaning they were falling through the air as opposed to some other way, and disagrees with the prosecution expert analysis and classification of those items. And that's really about all we've gotten through with this expert. The defense also took some of the jury's time first thing in the morning to go through 80 exhibits and admit those into evidence. There were numerous prosecution objections. I think all but one of the prosecution objections to defense exhibits was sustained. Yes, that could have been done outside the presence of the jury. No, the defense did not choose to do it that way. So while they are at the lunch break, I'm going to take a moment to use the restroom, and optimistically we can just smooth sail on the rest of the day. All of you in the chat are going, Emily, you know that it was not, in fact, smooth sailing the rest of the day. Because I don't think it's going to get better. And if you watched the Emily Show podcast already today, you know that by the end of the day on Friday, Judge A has had a week full of this and is incredibly frustrated. So by the end of the day on Friday, the court is telling the attorneys to take the break with the storm and courts being closed to literally get it together while she is looking at defense counsel. And we are starting to see the build up to that because we are covering now day 5 of trial, which is last Wednesday, the 21st. And it seems that Friday was a very clunky day. But today's been a clunky day. So we'll see how far we get, but we have had some really smooth lawyering with some hiccups here and there. I don't think we've seen anything quite like this. It just is, it's difficult. And you can see the court's frustration. The difficult thing for the defense attorney is that if we are this frustrated in 1.25 speed with being able to fast forward through parts, the jury is just sitting there going, what is happening? Just what is happening? So I guess the question now is, what, if anything, will the defense be doing after lunch? Why, what, if anything, seems to be the preferred term of phrase in Fairfax County. And when is the defense attorney just going to say, I'm trying, Your Honor? Because it seems that that's inevitable at this point. And I guess we'll see that when it happens. So for those of you that are new here, hi, welcome. Good to see you. This is what we do here. For those of you asking about what's going on in Fairfax County Court today, nothing. They are closed for snow today and tomorrow. So if they're going to be back open Wednesday, we might be able to consolidate everything into today and tomorrow. If they are not going to be back up and running Wednesday, maybe we'll do that last day on Wednesday. It's just going to depend what's happening in court for the week. And we will see based on how Fairfax County gets it together. So for those of you that are new, if you do not have the LeeAnn app, I will let you know when critical things happen in trial. In this case, we are waiting to see when the defendant is going to testify because the defense counsel indicates that he will be. So we're trying to catch up in real time so we can watch that. It's going to get interesting with my travels, how that's going to go. So fingers crossed, everybody, fingers crossed. But we will see it when we see it together. LeeAnn app is free on iOS and Android at leeannapp.com. I'm going to hit the court break music. You will hear me indicate when I get back with the chimes, and we will send out an app notification when we're back. And then we will send out an app notification when we switch witnesses after this witness, because if you guys are just hit me on the summary, we put our case briefs up on the Emily Show channel every day. So if you just want a summary of these witnesses, it'll be up there when I summarize it. But right now the summary is just like, counsel, what are we doing? But for real though, what are we doing? So I'm going to run to the restroom. I'm going to grab some snackins for lunch and then we'll be back. So 10, 15 minutes. I'm going to keep it quick. But my kiddos are also home. So I'm going to say hello to them. And that's that. We're just going to see what they're doing. So I will see you guys in just a minute and we will let you know in the app when we are back. All right, Law Nerds, hang tight. Go get a snack. Go get a snack and go get something to drink. Hydration is key. We'll see you in a minute. Are you ready, Chad? I know, me too. All right. Are we ready to go back to court? Oh, as my voice is going to fight with me the second we're ready to go back. Cute. But I feel like I am well prepared. I made some popcorn. I grabbed a Dr. Pepper. We're ready to go. We got some snacks because we're going to try to zoom. We're going to try to zoom through the rest of this court day. Got to check in with the kiddos. The backyard looks absolutely wild, just covered in ice as the sun is coming out. I'm not optimistic for how that's going to go because everything is starting to melt just a little bit and it's going to be like 3 degrees this evening. So fun times. But it is what it is. So right now, Cynthia's son, great question. Right now, who's winning for the cat's attention? The birds or the kids? The birds. Right now, the birds are winning. Today, the birds are winning because the windows to the side of me, the cats are sitting each on one side of one pane and are just watching the birds all over the yard. So that's what we're doing. All right. Are we ready? Are we ready to go back to court? I mean, are we reluctantly ready? We're like, I mean, yes, but do we have to? But yes, because I need to know what the defense is proving in their case. But also, it's a challenge, you guys. It's a challenge. It really is. It really is. It's a lot. It is. It's a lot in this case. All right, we're gonna get the sound back on in court.
Listen to
the defense has their blood pattern and stain analyst on the stand. Let's go.
Ms. Groff's testimony yesterday, correct?
Yes.
Did you hear her discussion of the position of Joe Ryan and the blood, whatever?
Oh, he's trying to get back to what he didn't
Ryan.
get before lunch.
Do you remember that discussion?
Immediately trying to get back to it.
Specific to his arm? Is that what you're referring
Specific
to?
to his position on the ground.
Yes, I did hear her talk about that.
Did you agree with that?
That the blood stains would indicate that he was lying on the ground?
Yes.
No.
And what can you point to in your expertise that would have you arrive at that conclusion?
Well, so I guess starting with, I believe that she mentioned that the stains that were the 4 linear stains that I did not classify, she classified them. So that's where the first divergence was. So then that classification is what led her to say that he would have been in a position lying on the ground when they were deposited, if I recall correctly.
So you don't disagree with his position then? You disagree with the categorization of the blood droplets on the arm. But what about the hip? So you disagree with, okay.
So the first part is that as I mentioned before lunch, the target surface didn't lend to classification to start with, and to go on to then determine what that classification would mean in terms of his positioning is the part where it starts by the fact that I didn't believe that a classification could be made. Then to go on further to say what that classification would mean would be why I would disagree.
Okay. And were there...
Oh, chat, you're right. I wasn't...
Was there evidence that...
I am at normal speed. I'm putting it back at 1.25.
You observed that would have support different conclusions than that, other than not being able to classify?
So maybe the best way to describe this is to have you understand what a drip stain is in terms of blood stain pattern analysis.
What? You've already said you disagree with the way it was classified. And you disagree with the way it was classified. Therefore, from that classification, you would not make a conclusion because you disagree with the classification, therefore no conclusion.
A drip stain is a stain that is formed by gravity alone. So it's not just a circular stain you see on the surface. It's a circular stain that arrived by a passive formed by gravity. So it's not something that happened that's circular from another mechanism, but it just happened to hit the ground at perpendicular, making it circular. It is formed only through gravity alone. So the fact that I didn't classify it as anything,
so it was not
the first part. But then on top of that, if you have just the fact that something is circular does not make it a drip stain. It's one of the features you can look at, but it doesn't mean that it's a drip stain. So there are other mechanisms that when the blood is going through the air, say from an impact, say somebody was being beaten with a hammer. When the blood goes through the air, it goes in a parabolic arc. And if it doesn't hit anything in that trajectory, it will eventually fall to the ground. And when it hits the ground, it's going to look circular. But if it hits the wall on the vertical surface, it's going to look circular there too, because
what about the windows?
Anywhere it hits a perpendicular, it will look circular. But we look at the size of them to kind of help to inform whether it could just be a drip stain, something that just was because somebody was standing over something and dripping blood, or if it was because of another mechanism. So because we didn't have a lot of these features, there was no classification done because the size helps too.
So it could be flying through the air in different ways. So what you're saying is you can't tell if it was flying through the air because it was dripped or because it was like shake it off, or there's multiple ways. So you agree it was going through the air. You just don't agree which way it was going through the air. Okay, fair. Okay, fair. There are multiple ways it could have been going through the air, but it would still have gone through the air then.
To inform that. And then the shape itself and the fact that we had this target surface to eliminate any of those other mechanisms, to only say that these are coming from drip stains and coming from above was part of the problem. Going further, if they were drip stains, it doesn't mean that because his arm was this way that he was down on the ground. It just means that the arm was in a position horizontal to where the passive drop was coming. Because people move around, your arm can be in, your body can be in different positions when you do that. So
if you're walking with your arm like this, perpendicular, then you could be standing up with your arm perpendicular versus laying down with your arm perpendicular. When we're just looking at the arm, I think that's fair. I think there's more than just the arm, but I think that's fair.
Orientation of your body and where that is in relation to where the blood is coming from is going to be how it will look like on that surface. But it's hard to then say, oh, the person was in this position just because there's something circular here that I think is a drip stain, and therefore because it's coming from above, he has to be on the ground laying down.
And if you were, as you've indicated in your previous testimony, that you would need more information, what more would you need other than what you just said?
What about the
in order
hip?
to even make the determination?
Judge, objection calls for speculation.
You mean
what about the clothes?
Sorry.
Objection calls for speculation.
I mean, she's an expert. She is allowed to, in fact, speculate. That's why they are experts. They're allowed to opine.
Just asking her what other tools.
Overruled, that's right.
Yeah, I think, I mentioned earlier, same answers as I would be looking at the size, shape, distribution, location, appearance. Those are the features that I look for and determine that this is a drip stain to the exclusion of all other mechanisms. I would want to look for something that would look perfectly circular, that I could see scalloping all around the edges or spining around the edges, or it's perfectly circular on, like, say, a smooth surface, and that it has some size to it that would indicate that it's coming from just gravity forming it. If it's tiny, then, and I see it in terms of other, maybe in terms of other spatter stains in that area, I'm going to presume it's coming from or classify it as something coming from a mechanism that's a spatter producing mechanism as opposed to just a single passive drop. So sometimes we can't tell. I mean, we just have to look for those features and hope that if the target surface allows for it, we can classify it.
And in the absence of concrete information, is it appropriate to default toward
Objection leading.
Sustains to leading.
In the absence of additional information you want, how does one resolve that?
You go back to the higher classification. So if we start at blood stain, and then we might go to a spatter producing mechanism of some sort, and then we can classify that either to cast off or impact or expirated blood. If we don't have the features to meet those on each level of that, we revert back to the level that's higher.
So
and
then
so
you
in this
can't
case, I just
classify
said, these are blood stains, and I described them. They were irregularly shaped, somewhat three-dimensional on the arm.
Thank you. I have no further questions.
All right, cross-examination.
I mean, he kind of gave up asking about his ultimate question as well. And what we got from the direct examination of this expert is I disagree with the prosecution's expert that the bloodstains on victim Joseph Ryan's arm are from dripping, and that the dripping on the arm necessarily indicates that he was on the ground when that happened. But the prosecution's expert didn't just rely on the arm. It seems that the defense really narrowed the question more than the prosecution's expert did, because the prosecution's expert talked about quite a few other things, not just the arm. So I don't know if that's helpful for the defense at all, because there's more information there. Okay. We're going to get to cross-examination. I thought I had, what is it? I keep telling it to go and then it keeps stopping. It's like, no.
Good afternoon. Hi.
The feed
So
objected.
to stay with where we just left off.
Okay.
You're keeping it at the classification level that's up here because you don't have enough information to go and.
The prosecutor is going much faster than the defense was. I'm going to slow this down just a little bit until the prosecutor slows down a little. Maybe she won't, but that was fast.
Next step, is that correct?
Yes.
But that doesn't inherently mean that that next step isn't a possibility, right?
Well, I don't consider the possibilities, because if I can't go beyond the classification, then I didn't go beyond the classification is the reason I stopped.
Sure.
So I wouldn't.
But because you stopped, that then leaves all of the options still available. None have been excluded, correct?
You mean every possible mechanism
Correct.
that could possibly produce a blood stain?
Yes.
Yes, I guess. Yes.
Yes, including drops from above.
Yes.
Okay, thank you.
So if it can't be included,
Going back for just a moment,
it also can't be excluded.
You testified regarding the DLI lab, and you stated that the test sample was the pull from the genes avoiding.
I regret everything immediately. Her first question was very fast, and now we're going back to not. Emily, just leave it be.
Staining, is that correct?
I'm sorry, say that again. I
You
didn't hear that.
testified about the DLI DNA lab.
You should have just left it alone.
Specifically that the sample was a swab or a portion of Joseph Ryan's genes avoiding staining. Is that correct?
Avoiding staining. Yes,
Okay,
I'm sorry.
but did you also read in the report that that sample was positive for blood?
Yeah, so it didn't say it was positive for blood. It said that blood was indicated in the sample. And so what that means is that they did a presumptive test. So that's a test that,
The prosecution's like, ma'am, no, I don't need you to explain all that. Like, I don't need you to explain all that.
We heard about that from our DNA experts.
so we didn't, the blood wasn't identified
covered this.
in that sample. It was an indication that there was blood there. And I think to clarify that the testing that is used in that instance,
Ma'am, they covered that.
is a very sensitive test that can pick up blood that
Judge,
you
I'm going
can't
to
see.
object. I don't think she's presented any foundation for knowledge of how the testing was conducted. And that wasn't my question.
All right, we're going to ask your question again. Let's go that way.
So non-responsive, because the expert was off and running, and counsel's like, excuse me, no, ma'am.
The laboratory result said that blood was indicated. Yes or no?
Yes, that's not what you asked me though. You said it was found. The test only said that blood was indicated.
Okay.
And yes.
Thank you. That's all I have, Judge.
Okay, any redirect? Is this witness subject to recall?
That's the entire cross? So blood was indicated? Okay.
Yes.
All right, so since you're subject to recall, just don't discuss your testimony with anybody, all right?
Okay, thank you.
Thank you.
Your Honor, if I can consult with counsel for just a moment.
I'm sorry.
The witness is not subject to recall.
Okay, you are not subject to recall, ma'am, so you're free to go if you wish. All right, thank you. All right, your next witness?
Yes, thank you, Your Honor. Brendan Miller.
Okay, we're on to the defense's next witness, witness number 4. I'm going to zoom while they take the stand. Brendan Miller. Yes, I'm zooming. No, we still haven't asked this witness for his name.
Could you please state your name and spell your name for
That took a minute.
the court reporter?
Yes, my name is Brendan Miller, BrendanMiller.
And where do you currently work?
Fairfax County Police Department.
And what capacity do you work in the Fairfax County Police Department?
I'm a detective in the child exploitation section.
Okay. During your, were you involved in this case?
Sir, are you the guy that he was talking about this morning? Are you the one that did the forensics? Weren't we talking about Miller this morning and Miller's report and Miller finding that Christine never gave up control of the devices? Is that you? Because I think that's you. The defense was talking about you this morning. Oh, I'm very interested to see what Miller has to say. I'm very curious.
Case as an investigator at any point?
Yes.
Okay, and what was your capacity as investigator?
I was the digital forensics examiner for this case.
And
oh
when
boy,
did that change?
I bet the jury's interested now.
About a year ago.
Sorry, almost there.
That's almost I'm trying, Your Honor, but we're not there. Almost there is not I'm trying, Your Honor. It's close. You were the forensic examiner on this case up until a year ago. At this point, the jury's got to be like, ooh, finally.
Yes, ma'am.
Counsel, what were you doing over lunch? Because what you weren't doing is getting this ready, and I'm at 1.25, and we're still sitting here with you beep booping through whatever, Mr. I'm the tech guy now.
Wednesday. Okay, gotcha.
Huh.
Thank you. In child exploitation, do you utilize
boy.
the same skills that you had when you were at digital forensics?
I do.
Okay. And so when you left digital forensics, did you leave of your own volition?
I did not.
And was the transfer to child exploitation?
Yes, the transfer was to child exploitation.
Okay. How long had you been in digital forensics prior to being transferred?
Since roughly 2019, so about 5 years.
Okay. And how many cases had you handled in digital forensics prior to that transfer?
I don't recall the exact number.
Oh,
Okay.
boy.
But were you the person who did the digital forensics in the Fairfax County Police?
One of them.
How many others are there?
There were 6 at the time, I believe.
Oh, that's
now,
a lot.
When you were transferred out, this was in the middle of the investigation of this case, correct?
I don't know if I would classify it as the middle or where it was.
It was during the pendency of this case.
Yes, this case was still going on.
Okay. And
He is
in
quiet.
your capacity as digital forensics examiner, I'm going to ask you to look at a document. Okay, do you see anything on the screen?
Just your screensaver.
Okay.
What's his screensaver? Because I'm curious. Because now I want to know. Wow. We're just not ready.
Why is no one ready?
My apologies, Judge.
That's all right.
Stop telling him it's all right, Judge A. You told him before lunch to get his shit together, and we are after lunch, and the shit is most definitely not together. This attorney has called a witness to the stand and said 3 things and sniffled. That's it.
Okay, and what is that?
That is an executive summary.
Apparently now the executive summary is on the thing that the witness can see.
And this is an executive summary that you wrote as digital forensic examiner for the Fairfax County Police?
Yes.
Did you want to mark that as a?
Yes, Your Honor. 85, please. Defense
85 for the
85.
record? Just thank you.
Oh, boy.
And sir, this is your personal digital forensics
He said
executive
that.
summary, is that right?
I created this document, yes.
Okay. And now, in arriving at these conclusions, this is related.
Yeah, he has not covered this officer's background, training, and experience. Nothing. You wrote this? Great, let's write it. You wrote the executive summary? Great.
Related to your work as a digital forensic examiner, correct?
Yes.
Okay. Your Honor, I move this in as Defense Exhibit 85.
Any objection?
Yes, Judge, at this point.
Reports don't go in. There's no foundation for it. There's no foundation for the conclusions in it. Reports are not evidence. His testimony can be. So I'm not surprised that Commonwealth's objecting.
This in as Defense Exhibit 85.
Any objection?
Yes, Judge, at this point in time, I think this would qualify as an expert report. This witness has not been qualified as an expert, nor has any foundation been laid for the report.
Okay, so foundation is the objection, so I'll sustain that objection if you want to lay.
I can do that.
Sure.
So, sir, tell me about your experience in digital forensics.
In what regard?
From the moment you got into digital forensics, what kind of training did you have?
Oh, boy.
I've received training in a variety of forensic tools and training specific to computer systems,
Celebrate.
specifically the International Association of Computer Investigative Specialists, IASIS. I've also been trained with Cellbrite, and I'm current in both of those certifications, and training with Magnet and X-Ways and various other forensics platforms.
Okay. And did you receive additional training beyond that within the Fairfax County Police?
I'm also certified for BERLA, which is the vehicle forensics. Various other trainings at different times.
Have you ever been qualified as a witness in the courts of Fairfax County?
I bet he has.
Judge, I have to object to the question.
Qualified as an expert, I'm sorry.
Yes, I have.
Okay. How many times?
2 that come to mind.
Okay. And
What?
Was that in your capacity when you?
What? Wait. You were the one of 6 digital forensic examiners, and you've only qualified in court twice in 5 years? That's it? I have a lot of questions. Also, did you notice how clunky his background, training, and experience was? He was like, I have some certifications. Okay.
You're a digital forensic investigator?
Yes.
Okay. Your Honor, I move Detective Miller in as an expert in digital forensics.
Any objection?
No objection.
All right, so moved.
Now, sir, is this report the report that you created?
Interesting.
Yes, I wrote this.
And when was this report created?
I don't recall the exact date.
Okay. Was it prior to October 25th, 2024?
Is the date not on your report?
I don't recall exactly, but that sounds about the right time frame.
Okay. And that's a significant date because that was if I can remind you, the first recant for Juliana Perez Magalhaes. Does that give you a better idea of when this would have been done?
Is he saying recant to mean interviews? So the defense is just using the first time Juliana said that she was involved? Because he keeps saying recant. I don't know if the jury knows what he means, but it seems that he's trying to say a recanted statement where she's like, no, that's not what it is. It's this, but it's an odd way to use it. And he's trying to ask if this digital forensic report was done before Juliana gave her interview to police saying that she was involved.
If memory serves, this was done prior to that.
Okay. That's all we can rely on is your memory. And Your Honor, I don't have any further questions.
All right. You have cross-examination.
My goat scream won't even...
Judge, I would note that. No, I have no questions at this time.
All right.
Those are all the questions, Judge.
Is this witness subject to recall?
Yes.
Okay, so if you just subject to recall, you cannot discuss your testimony with anybody. You do not.
So you brought him in for the foundation of his report, and then you don't ask him any questions about his conclusion, his forensic examination, his work. You weren't even prepared to ask him about foundation. Like, you weren't even ready to ask him about foundation. Okay. So, subject to recall?
Is this witness subject to recall?
Yes.
Okay, so since you're subject to recall, you cannot discuss your testimony with anybody. You do not need to stay here today, but just be on call for that, okay? And you're still subject to the rule of witnesses, okay?
Yes, Your Honor.
All right, thank you. All right, your next witness?
Harry Lidsky.
Okay. Dude, if I was a juror, I'd be fucking pissed. I'd be so fucking pissed. I'm fucking pissed. I'd be so fucking pissed. Okay, we have nothing further. I'm sorry. Digital forensics. And he didn't even try to bring the report back up. No, he qualified him as an expert, kind of. Okay, next witness.
Thank you.
I don't know. I have no idea.
Please state your name and spell it for the court reporter.
I don't.
Harry Lidsky, Harry, LID as in David, SKY.
Hi, Harry.
Currently employed.
I'm currently a private investigator and digital forensic examiner, self-employed at my company, 4DIS.
Okay. And
okay, so witness number 5 is another digital forensic examiner. Okay.
What's your background in terms of digital investigations and investigations?
Prior to starting my own company, 4DIS, I retired after 20 years in federal law enforcement, 7 years with the DEA, the Drug Enforcement Administration, the remaining 13 years with the U.S. Department of Justice, Office of the Inspector General. For the last 11 of those 13, I was in the Cyber Investigations Office, where I progressed as a senior special agent to the assistant special agent in charge and retired as the special agent in charge of that office. The Cyber Investigations Office handles, as the name would imply, digital forensic examinations. We're responsible for supporting the entire agency nationwide with mobile and computer forensics, basically anything with an on-off button, anything that was electronic in nature.
I like that description.
Is where we came, our services were brought to bear. On top of that, we ran our own investigations, those specifically which were digital forensics centric.
And
I like you, Harry. Anything with an on-off button.
Issues. Have you ever heard of catfishing?
Yes, I have.
Have you worked with
Harry? Is it Henry? It's Harry.
Investigations where it's alleged?
So on to the catfishing. Okay.
Alleged or it's found to be catfishing?
Yes, I have.
So do you understand the elements necessary for catfishing?
What do you mean elements?
Describe for the ladies and gentlemen of the jury what that exactly is.
It's a form of misattribution in terms of who's performing what activity. So at its core, it's somebody pretending to be somebody else, usually.
You're telling me that the defense had the access to this expert who is saying that one of the key components, which is what we all knew, the key components of catfishing is misattribution, pretending to be somebody else. And for that to be identity theft, there's a lot of specific elements for it to be against the law, et cetera. But to describe it as such, and then for the defense to come in their opening and get this so wrong is wild. Okay. Talk to your experts. Somebody pretending to be somebody else. Thank you. We've been trying so hard to get there.
Designed to lure somebody else to do something. So it can be employed in a scheme to defraud. It can be employed to get somebody to show up, to get them in trouble, to get somebody to show up to an event they had not intended to show up at, to misdirect somebody to show up for something. A case that I worked, it was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike
This case? Are you talking about this case? Right. Luring someone to do something. Oh, look, not unlike this case. Luring someone to show up thinking it was a consensual sexual encounter. Like this.
like this particular case.
So you're agreeing that's what happened in this case? Or are you just agreeing that that's what happened in this case? I'm going to let him answer.
It was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike this particular case.
So you agree then? You agree that that's what happened here? Okay.
And in fact, they were there to serve a different purpose, to be set up as a victim, as a utility or a tool in that particular investigation.
So,
like this case? Like this case, where they were set up as a utility or a tool or a victim, like in this case? So you just agree then? Okay.
in that particular investigation, was that from the prosecution side or the defense side?
That's when I was a criminal investigator, a federal agent for the Department of Justice.
Okay. Now, in terms of your investigative experience, even beyond digital forensics, can you tell the ladies and gentlemen of the jury what kind of experience and what kind of responsibility you had while being a federal investigator?
Well, in addition to the digital forensics, again, 7 years with the DEA.
So you
it was
agree
drug
with
law enforcement.
the prosecution theory?
Pretty straightforward. What you think, what you'd expect, I guess, between the street level version of it, domestically, always working our way up towards the source, back to the cartel sources, and usually overseas. But through that, I gained experience with interviewing witnesses, interrogation of subjects, obviously arrest tactics and things along those lines. But there was also a strong money laundering component involved with that. There was surveillance skills were heavily employed during my time with DEA. I did a lot of undercover work with DEA. At the DOJ OIG, the Department of Justice's Office of the Inspector General, we were the watchdog for the Department of Justice. So we investigated both administrative and criminal waste, fraud, abuse type misconduct that occurred within the Department of Justice, that is, employees of the Department of Justice, or also from external actors affecting the business of the Department of Justice. And through that, we did a fair amount of investigations to the extent that makes sense. There was a number of high-profile investigations.
Have you heard of Karen Reed? Sir, have you heard of Karen Reed? We investigated a lot of investigations. I've got questions. Sir, I have questions.
Fast and Furious might be one of those where our investigation was aimed at the investigation or the operation conducted by the ATF in that particular instance. And we would often find we would make assessments, recommendations, and even punishment recommendations for employees that acted either out of malice, ignored or abused policy, whether they engaged in misconduct inadvertently or maliciously.
What do you think?
Those were the type of findings we would have. So if we found that an investigator failed to adhere to policy, we might have a finding. If we find an investigator lied to us or in an investigation, somebody would. Sir,
do you know Brian Higgins? Sir, I thought he was ATF. I have questions.
Within the purview lied to us, we would find they lacked candor. So we, our reports, our investigations resulted in terminations of employees. Sometimes they were.
Judge, I'm at this point in time, I think we've launched into a narrative that is not responsive to the question, nor is it relevant.
All right, if you want to ask the next question.
Excuse me, Madam Prosecutor? Shh. We want to know if he knows Brian Higgins. We have tea that must be discussed. But no, his background investigating other employees doesn't really seem to square here, but the investigations is quite interesting.
Well,
continue on that.
It was a question about your investigative background, so please continue.
Yeah, so that was the gist of what we did. So it's pretty broad spectrum of.
Really? The defense's next question is, go on.
Of investigative experience, that added component from the OIG of having the investigative oversight and being the watchdog to include over investigations and other police officers, other federal agents, other prosecutors, was a nuanced twist, I suppose, in my experience there. In addition, there was the more traditional, straightforward investigations we conducted to include everything from white collar bribery catfishing, international money laundering, conspiracies, and the normal type of white collar crime.
And in terms of your investigating the investigation, you were actually dealing with law enforcement people who came.
Objection, leading.
All right.
Explain.
Objection. His gun's banging into the seat. I'm teasing. It was just the sound that he made bumping into the microphone. Objection leading. The prosecution's really not going to let up on the gas with that, but most attorneys, when they're talking about background, leave a little room.
What you did in terms of the investigation of the investigations.
Sure.
I have no idea if the court ruled on that objection, but he just kept on going.
DOJ is huge, the biggest law firm in the world, as we like to say. DOJ includes the FBI, the DEA, the ATF, U.S. Marshal Service, Bureau of Prisons, U.S. Attorney's Offices, Interpol, and about 40 other smaller components, tax division, civil rights division. So we're a massive agency far and wide. So we were made up of federal agents, FBI, DEA, ATF, and Marshals. But we were also made up of attorneys. We were made up of auditors. We were made up of all sorts of employees. We had IT employees
We get it. You worked for the federal government. You worked for the federal government. There's a lot of feds. We get it.
Engaged in inappropriate network activity where they were reading other employees' emails improperly and illegally. So,
kind of like in South Carolina with Courthouse Becky, right? I got some questions. This man would be fascinating to chat with. Why did it start snowing again? Why is it snowing again? Rude. Okay. That's rude. But sir, you work for yourself now. Can we move on?
So whenever somebody was accused of misconduct, whenever an allegation of misconduct came our way, we would take that on. So it can take all forms.
Now, going back to the digital forensics investigations, you indicated you were there for 11 years. Why are you here today?
Yes, sir.
Okay. And during that period of time, were you ever qualified as an expert in the court of law?
Yes, I have been.
Okay. How many times?
I say 3 or 4 at the federal level, and once since retirement here in the Commonwealth.
Oh, you didn't testify a lot at all.
Mr. Lidsky is an expert in the fields of digital forensics and general investigation.
All right.
Judge, I'm not familiar with general investigation as a...
Excuse me, Your Honor. General investigation is not a form of expertise. Didn't testify a lot at all, truly, but it probably wasn't one of his main roles because especially if he became a supervisor, he wouldn't be going to court. He would be reviewing people who are going to court.
And general investigation.
All right.
Judge, I'm not familiar with general investigation as an expert field, but certainly digital forensics we would accept.
I'll move in this for digital forensics expert.
Yes.
Okay.
Sir, you became involved with the Banfield case. What was the first thing that you did when you started reviewing evidence?
The first part of my evidentiary review focused on the digital forensics. I was provided with a rather large volume-wise hard drive, 8 terabytes, I believe.
And the digital forensics, and I guess, Your Honor, I would just state that the digital forensics that are the foundation have all been stipulated to in the stipulation document in terms of...
In terms of a report of a digital...
In terms of the data that was taken from the devices.
Yes, Your Honor. We have stipulated that the raw data pulled from the devices does not need to have a chain of custody or foundation.
So he can talk about the raw data from the devices. Okay.
Yes.
I appreciate that the prosecution was not being petty. All of what just happened means that the discovery, the prosecution didn't bring in any digital forensics, but they are not saying the defense needs to lay the foundation for the digital forensics. The prosecution turned it over to them in discovery and is saying we stipulated to the foundation of the discovery we turned over to the defense, and we stipulate that raw information was pulled from, the proper chain of custody, et cetera. Fair?
And so, sir, what's the first step in your analysis of digital forensics when you get involved in the case?
Well, in this particular case, it was atypical because I didn't have to perform any of the acquisition phase of it. Detective Miller had already performed all of the digital forensic acquisition. So what I was provided was generally the derivative elements of his work, which allowed me to just jump right in and review the various artifacts.
Derivative, you say? Was it derivative or was it the raw data?
When I'm performing a digital forensic exam that's derivative of somebody else's work, I make it a point not to review their findings. The reason being, digital forensics is somewhat analogous to solving a big math problem. So to perform it accurately, or at least the way I like to perform it accurately, I like to do the work myself, see what answer I come up with before I see the answers of somebody else's work. Digital forensics is a science such that we're all trained similarly. We all take the same training. We all operate the same way. If we perform our actions as we should under the guise of best practices, we should do the same thing, each one of us, and come up with the same results. Digital forensics is repeatable. Digital forensics, it should be, it's binary. The data is the data. It's not.
I have some questions about some Google searches, not related to this case.
It's not subject to interpretation. It's not subjective. So what you see is what you get. There are nuances in understanding it and what it means. Assigning attribution is a different phase of it, but and we'll eventually get past this boring stuff and see some of it. It does reveal what's going on behind the screen, typically on either a phone or a computer.
Now, in terms of the digital forensics.
Right. It doesn't reveal who's behind the screen. Right.
In this case, how do you arrive at certain conclusions?
So digital forensics, like most of the forensics, and we've heard a fair amount here so far in this trial, it's supportive. It can be informative. You can draw certain conclusions, but they're based upon the results of the digital forensic analysis and its impact on other items of evidence or other items of investigative nature. And what I mean by that is, for example, if somebody says, if we're investigating a crime that took place in Boston, and somebody says, I have an alibi, I was in Miami.
Why Boston? Why'd you pick Boston? Yo, guy, why did you pick Boston? Why did you pick Boston? Why? Why was that the I have questions. Boston, you say? Why is Boston top of mind, sir? What is happening? Oh, sitting in court in Virginia, and yet we cannot escape Boston.
And I look at their phone, and there are artifacts that reveal location information in Miami. That is an informative piece that says this individual, based on their phone, might have been in Miami at the time. Now, phones can travel without, are traveling with them. So was the phone there? Was the person there with the phone? So that's a lead. That's a pointer. The follow-up to that would be, okay, do we have airline records? Do we have video surveillance from an airport? Do we have video surveillance from a hotel in Miami? Do we have credit card transactions from a restaurant in Miami? Other indicia of
Could
location.
somebody say, welcome to
digital forensics
Miami?
Is informative. I guess if there's enough digital forensic pointers that can, I think pass a test, then it can be conclusory as well. And we can draw conclusions from it.
And in your example of something in Miami, when you arrive at a certain number of artifacts that say the person's in Miami, is that it?
It can be. That's probably a bad example in terms of being conclusory. If somebody says, there's no pictures of a red sports car on my phone, and I find 100 pictures of Ferraris that are red, that's conclusory to say that the witness information or the interview subject information that they provided to the investigator, whether it was me or somebody else, is clearly wrong. Now, that doesn't get to whether they misremembered, whether those photos are old, whether they were taken by somebody else. So there's still an attribution aspect, but it can be conclusory or informative in that regard.
Okay. Now, in the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at after things had developed. The theory had already been assigned. Catfishing was already had been Mr. Banfield had been charged already, and indicted under catfishing theory when I was brought in.
So you were brought in after Banfield had been arrested and charged. That's helpful to know, because I'm assuming that he was in fact brought in as a defense expert, not someone that the prosecution worked with and then the defense is calling.
And so that was my immediate focus. So confirm or refute that theory. As as an investigator, whether I'm in my law enforcement capacity or now my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So
Like
for
you're saying
me,
they're
just because
not
I'm
fuckery.
hired or asked to investigate one particular theory, it doesn't mean
Facts are facts.
I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
I think the prosecution wants to get to objection narrative. You're not allowed to just like wind up your witness and let them go. It's like, so tell us everything you did in this case. Go. You have to ask questions. But non-responsive is what she's using, and the court's not giving her a hard time about it.
Next question.
Sir, in terms of what you did when you started this investigation into Christine Banfield's
He has asked this witness, what did you do when you started the investigation? Like 6 times, it feels like.
devices, what did you do?
So I started evaluating the devices, but at the same time, I reviewed other evidence that was available to me provided in the discovery. That would include witness interviews. That would include subject or co-defendant interviews. That would include
well, why didn't you just review the digital first?
social media type event like email, Instagram, Facebook, things of that, WhatsApp. So it's not all a device centric. It can be evidence provided by a service provider like Google or Apple.
So the whole case file.
I reviewed all the photos from the crime scenes, the autopsies, the digital, the forensic science, and Office of Medical Examiner. I reviewed all of the facts available to me. The best way to perform what I do is through all source
Judge,
analysis.
objection, non-responsive.
I thought you said that you wanted to just not start with the conclusions and just start with the digital. Didn't he say that? I spilled popcorn on myself. Didn't he say that?
I sustain the objection.
Okay. So in terms of the items that you were just telling the jury that you review, did there come a time where you were reviewing and were able to arrive at conclusions?
Yes, I was.
Okay. And specifically, what date range or what period of time were you looking at?
So the window of time was from January 9th, 2023, specifically with regard to the catfishing, was from January 9th, 2023, obviously through the time of the event on February 24th, 2023. It did extend back a little bit further. For example, the discussion about the windows, that dated back prior to January 9th. There was witness testimony or subject interview.
Yes, chat. We have now completed the circuit from the windows to the walls. We have now gotten there.
Transcript information about planning that predated January 9th. So I don't just look at a time for digital forensics. It's important to look backwards for a certain relevant period to ensure that
Objection, non-responsive.
Sustain the objection.
Why would you look backward in a digital forensic analysis?
To the windows,
a single artifact, as we refer to them in digital forensics, it may not be informative, right? A single text message on this day may lack the context, but the 50 prior exchanges might help that context, right? That's relatable, and the
So for
communication
context?
after that might also help inform.
So
it's
for
important to look
context?
backwards. It's also important to look forwards in digital forensics. And when we're talking about, in this case, the allegation of a conspiracy that lasted a period of months, I find from an investigative perspective that it's important to look at everything. Digital forensics, like any, I think, informative piece of evidence,
Objection, non-responsive.
Sustain the
In
objection.
the context of certain behaviors.
We're in 1.25 speed. I'm just wondering if the prosecutor has like a 30-second timer on her Apple Watch and is just like 30 seconds, and then I'm saying non-responsive. Like, he keeps wandering pretty far afield of his answers. He really just wants to chat.
That come up through the investigative process, like, for example, when someone may have had their phone and their laptop and when someone would have been away from
Pattern
that.
of life.
Are
You're
those
asking about
things that
pattern
you
of
look at?
life.
especially for events like that. What was happening immediately before the event is vital in determining attribution or who might have been
So yes?
performing what activity on a device.
Or in saying it in another way, would there be?
No.
Objection, leading.
I haven't heard the question yet.
What would you do if there was a pattern of time that needed to be analyzed, or a time of day, or a certain day? How would you go about doing that?
Well, with the digital forensic tools that we have, the software that we have, we're able to visualize things in a timeline fashion. So I'm able to look at, or folks in my profession are able to look at what happened, both what the user was doing and what the system was registering, the computer system. So we're able to generally create a granular timeline that helps inform a decision or conclusion about whether a device might have been removed, from one person and used by another.
Okay. Now, can you see the document that's on your screen?
I see Detective Miller's executive summary.
Yes.
Yes.
Have you had an
Okay.
opportunity to review that?
I have.
Can that be published to the jury?
It was not admitted into evidence.
Okay. I'd move it into evidence. as
Objection,
Exhibit
Judge. It's a
85.
hearsay document at this time.
Oh, shit. Did he forget that he didn't move it into evidence when he excused Detective Miller from the witness stand? Because you can't publish it to the jury until it's admitted into evidence. And it was marked for evidence, but he didn't admit it. He took Miller off the stand. He qualified him as an expert, and then he was gone. Oh my God. Oh my God. Oh my God. I'm fascinated to see where this is going to go. It doesn't mean this expert's not allowed to review the document. He reviewed it. The jury's just not going to get to see it. Yikes.
Was not admitted into evidence.
Okay. I'd move it into evidence. as
Objection,
Exhibit
Judge. It's a
85.
hearsay document at this time.
I'll sustain the objection at this time.
Detective Miller testified to it.
If you want to approach.
No, you did not admit it into evidence. And they're approaching. Oh, boy.
Mr. Lidsky, I'm going to
Oh, boy.
go to,
You're going to move on, aren't you?
sorry.
Boy. Oh, boy. Oh, boy. This is so awkward. This is so awkward. Oh, my. Oh, my. And we're at 1.25 and it's awkward.
Can you see something on your screen there, sir?
I can.
Okay. There's evidence in this case regarding window replacement that was communicated by Juliana Perez Magalhaes. Do you remember that?
I do.
Did you do a digital examination? Did you do a digital examination as to the allegations that she made with regard to window replacement?
What?
I performed searches relating to that particular topic. I'm able to perform keyword searches as one of the search criteria. So I did perform searches related to that particular part of testimony, yes.
Okay. And was this part of the information that you'd received from our discovery and the data that came from the devices?
Yes, it is.
Okay. I'm going to have you look at the document that's on your screen. Can you, Your Honor, I'd identify this as Exhibit 86.
All right.
Well,
Can
at
you
least we
look at
identified
Defense
it.
Exhibit 86 and explain what we're looking at here.
Judge, I'm going to object to any statements regarding what's contained in the document.
Are you moving it into evidence, Mr. Carroll?
Yes, Your Honor.
Any objection?
Yes, I would object to foundation. We have not been given any information about this
And as
document.
to foundation, if you want to lay foundation.
Sir, how did you find these documents and what processes did you
Oh,
use in
boy.
order to find this information?
This is this is going to be long, isn't it? Wow.
Based on the derivative evidence provided to me in discovery on this case, I analyzed This particular one, this came from Miss Banfield's cell phone.
Judge, I'm going to object to that conclusion. Again, there's been no foundation laid, and we can approach and I can explain further.
There you want to approach.
The witness is just like, just.
Sir.
The prosecution said that they had no foundational objections as to the raw data. If these are derivative reports that are not his derivative reports from the raw data, it's going to be a problem.
What was the raw data that you used in order to get this, and what system did you use to arrive at this?
He might not have.
This was from an Axiom portable case created by Detective Miller. An Axiom portable case is a derivative product from Magnet Axiom for digital forensic software, which performs mobile and computer device review, or facilitates mobile and computer device review and cloud review and all things digital. So the software is baked in. It's an executable program that comes from the
Baked in with the
main
extraction?
Magnet program. So Magnet permits digital forensic examiners, in this case Detective Miller, to create a derivative subset of his work that is able to be open on any Windows computer.
But if Miller created a subset, that's not the raw data. That's Miller's data, not your data. And that could be a problem.
So you don't need to have a software platform. It is a software platform.
And if you can tell the ladies and gentlemen of the juror, or Your Honor, we move that in as comes.
Same objection. If we could approach, please.
That's the problem. If he had the raw data, but he's relying on Miller's reports, if Miller ran limiting reports in Axiom, that's not in evidence yet. So if he didn't run the reports himself from the raw extractions, we're going to have a big old problem. I think we're seeing the problem unfold. So it begs the question, why put Miller on the stand to be like, hi, my name is, and then kick him off the stand? Why didn't they just do the rest of this with Miller? Unless this dude's like, I'm flying back home. Well, they're in Virginia. I'm driving back home. I'm going to zoom while they're at sidebar. Did counsel just totally fuck it with not asking Miller to get his information in? Because this is a mess. And just the objection is sustained. I just want to hear the court say it just for Schadenfreude at this point.
All right. So the objection is sustained.
It feels like, and I'm just going with vibes, we're going to keep watching, but it seems like counsel fundamentally did not understand his expert, and that his expert was not just relying on the raw data, but was also relying on Miller's running of reports through that data, which means he didn't understand his expert well enough to know how to lay the foundation to call his expert. What a mess. And yes, Chad, I agree with all of you that are just yes queening at Deputy Queen in the courtroom. Last name Queen, Deputy Queen sitting behind the defendant. I get it.
Sir, did you work with the raw data that was provided by the Fairfax County Police through search warrants and other providers, things like that?
For search provider, for service providers?
Oh, that pause is not helpful for the defense either. Did you work with the raw data? He's like, I bet he didn't work with all of it.
Yes. The records I had were responsive from Google, Apple, Facebook, and Instagram, FetLife, and others, Discord. For the computer and mobile devices, I was not provided the raw data. I was provided the derivative work, the portable cases, the Celebrate readers, which to my understanding is the complete device. Nothing is filtered out. but I wouldn't characterize it as raw data.
The derivative work. It's the derivative work, which is why the prosecution was so specific when the prosecution said, yes, we do not object to foundation as to the raw data that was provided. Because again, if the Discord data came from Discord pursuant to a subpoena, fine, turn it over. But the defense seems to fundamentally not understand his expert because his expert is not relying on the raw data from the extractions. He said he was not provided it. He is relying on the derivative data. So Miller did the extraction. Miller ran stuff through the programs. He got the programs, not the extractions. So it's based on Miller's work as to the devices. Good thing Miller's subject to recall, but I bet he's not still in the courthouse. This is wild.
Your Honor, may I
have 5 minutes to figure out what the fuck to
request
do?
10-minute recess?
We want to do our afternoon recess? We can do that.
Yes.
Okay, let's go ahead and take our afternoon recess for 15 minutes.
Chad, I have not watched this day in court. I have not watched this age in court. I have not watched this day in court. But the way that counsel took a deep breath and asked for a 10-minute recess is telling.
Just request 10-minute recess.
Listen to him take a breath after that answer.
Your Honor, may I just request 10-minute recess?
We want to do our afternoon recess? We can do that.
Yes.
Okay, let's go ahead and take our afternoon recess.
The full
for
weight of
15 minutes,
defendant's
ladies and
error has
gentlemen.
now hit him in the face.
And we will get right back to you. Again, don't do any outside research and don't talk to anybody. Okay.
The defense is now the defense is now confronted with the full thrust of their error. Well, we are at the afternoon recess of day 5. The defense has asked for a Hail Mary 10-minute recess to try to grasp with both hands the error that they have made in court this afternoon because they called Detective Miller. They qualified Detective Miller as an expert. They asked Detective Miller about their report. They marked it for identification. They did not move it into evidence. And then they dismissed Detective Miller subject to recall, which shocked me how quickly the defense was just like, okay, we're done with this witness. They then called what seems to be their privately hired digital forensic expert, who's a former Fed. We got through lots of background and training. The prosecution did not object to the foundation for the raw data that was provided in discovery. And it would have been pretty shitty if they hadn't stipulated to that, because if they sent a subpoena to Discord telling the defense they have to bring in the Discord person when they subpoenaed it from Discord and it was turned over is inappropriate. The prosecution got it. They turned it over to the defense in discovery and they said, no, we have no problem with the raw data. We have foundation for that. And then the defense has started trying to get into their expert opinions evaluation. And their expert's evaluation was of the derivative data of Miller as to the devices. Anything with an on button, the computer, the phones, etc. And they have hit a tremendous roadblock as the prosecution says no foundation. And the defense is like, Detective Miller's report, and the prosecution's like, it's not in evidence. And the court's like, it's not in evidence. So the defense doesn't seem to understand what their expert evaluated and how he made his reports. And oh boy, what a mess. Because now the jury is back out. Nothing has been learned other than how much the digital forensic examiner, A, loves what he does, which love to see it, is a talker, and evaluated the derivative reports from Detective Miller that aren't in evidence. Huh. What a day for the defense. Their first day, and it's not going well. So we're gonna zoom past the afternoon break. All of you are asking what I'm snacking on. I actually made popcorn. Look, we started watching Stranger Things with the entire family, and Griffin was like, I need popcorn. And now popcorn has become the only acceptable snack. Some of you will be like, I understand what you mean. Once there is one snack, it is that snack until it's no longer that snack. So right now it is the snack. It was in no way commentary on the court day I hadn't seen. It's just the only acceptable snack at the moment. But God, it was accurate. The popcorn was needed. I've never seen anything quite like this. This is a big old mess. Look, also, I am not sure who the jurist this portrait is, but this portrait is a fucking serve. I'm here for it. Look, they took down the portraits of Murdaugh's like granddaddy or whatever out of their courtroom. I worked in California. We didn't have portraits in courtrooms. I'm here for it. I'm loving this one. This portrait is just fucking iconic, and I love it. I'm going to have to review. Anyone in the background who's listening, just come look. I'm going to have to review to figure out which esteemed jurist this is a portrait of, but I fucking love it. Chat's like, it's His Honor, Wesley Snipes. It's just so good. All right, let's see what else is going on in court. I had to pause because this was just a fucking 10 out of 10. I love the glasses, just everything about it is so fucking good. God, I love it. All right. Now let's get back to wait, who said His Honor Blade? Anthony. Yes. It's just a 10 out of 10. The bow tie. God, I love it so much. All right. Emily, we're clinging to the small bright lights where we can. Yes. Yes, we are, because I'm concerned for this defense attorney. I am. I'm very concerned for this defense attorney. Oh, looky here. We're back from the break to sidebar. Judge A's eyebrows are basically in her hairline, and they are up at sidebar again. Judge A's face is giving counsel respectfully. What are you doing? Counsel, what are you doing? Counsel, what is happening? Counsel, what the fuck? Judge A would never say counsel respectfully, what the fuck? But she's just like, but you had the witness. What is happening? Oh my God, the body language is body languaging. Yeah, it is. Oh boy.
All right, we ready for the jury?
Yes, ma'am.
Okay.
And the jury's coming back. The defendant also looks like respectfully, what the fuck? The jury is back in, or is coming back in. Counsel's having a real bad day at work. Sir, you are not prepared. You're just not prepared. This is on you. You knew this trial was coming. You are not prepared. You were just not prepared.
Judge, I don't have any further questions for Mr. Lidsky.
All right.
I would ask.
What? I don't have any further questions. Okay, so we went on the break. No further questions.
We're
okay.
Can we call him at a later time?
Okay, well, cross-examination?
Not at this time, Your Honor. No, thank you.
Okay, all right. Sir, since you are subject to recall.
No further questions. We will recall him at a later time. Okay.
Do not discuss your testimony with anybody, and you may be recalled, okay? But you can have a seat. Thank you.
All right, call Detective Miller.
Detective Miller. Okay. He was just sworn. Yeah, okay. Yeah, he just, perfect.
I don't even know. I don't even know what witness number it is. We're recalling Miller.
He's already been sworn.
We're just gonna have to go with recall Detective Miller.
Right. Detective, just a reminder, you're still under oath, okay,
Number
sir?
4.
All right, thank you.
Holy shit. And the jury's got to be sitting there going, what is happening?
Can you see the document that you had created?
Okay.
Digital forensic summary. And when you obtained the data in doing your forensic analysis, describe for the ladies and gentlemen of the jury what you do.
Make sure the green button's on there.
Witness your mic.
Okay, I think it's on now. In obtaining data from a device, the first thing we do is stabilize it, and that method depends on whether it's a mobile device or a computer, whether the device is on or off. So an example of a computer, what I would do is...
I had to put this back at 1.25. We're going to lay the foundation now, chat and replay crew. Could this have been done before? Yes. Yes, it could have. Why wasn't it done before? I have no fucking clue. I have no idea why it wasn't done before, but holy shit. Here we are.
The device, if it's already come to me and powered off state, I would remove the hard drive, connect it to a forensic machine with a write blocker. A write blocker is a device that prevents writing to that evidence device. Therefore, no bits are changed. So no zeros, no ones, nothing gets altered. And then I take what's called a forensic image of that and create an evidence file from that, which is then loaded into another forensic tool that will parse that data and create it into a readable format for me as the examiner or anybody else to read down the road.
And would you draw your conclusions that are the conclusions that are on this digital forensics executive summary after doing that through different artifacts?
That's not nearly enough foundation. Counsel. I think you're going to want to explore that a bit more.
Yes, I would draw any conclusions off of data that had been obtained from a device.
Okay, and what you just described to the jury is what went into this document, the digital forensic executive summary.
Everything that was used to compile that came from data that had been extracted from the digital devices.
Okay, and
thank you, chat. Sorry, I had mug duds. I thought we had a minute, but yes, the feed did jump and kill our closed captioning. I'm putting it on now.
Specifically relating, and I'm referencing this document, January 9th, that was an important day in terms of who was using devices.
Objection, counsel's testifying.
All right.
What's the significance of January?
Go ahead.
Yes,
So
what's
leading?
the significance of January 9th, 2023 in this investigation?
That was a date that a Gmail account was created.
Okay, and in your investigation, were you able to determine who created that account?
Who in particular? No.
Yes. Were you able to investigate using your tools to determine artifacts such as such as other lifestyle type matters as to who was home, who could have been there, things like that?
Judge, objection is to form.
He just said he can't tell you who created it, but it sounds like a new Gmail account was created. So a new Gmail account, and that would have been the account I imagine they used to create the FetLife account, right?
If you want to state that question again.
What are the things that, so when you're honing in on who was using a device, what things do you look at?
I would look at a variety of things. Pattern of life would be a term that would be used, but you would explore all that the data has to offer and see if there's enough artifacts there to support or provided enough information as to who may have been using that device, but barring external corroboration, it's impossible to put somebody behind a screen.
Now, in terms of...
Does your report try to do that? Barring external corroboration, it's impossible to put someone behind a screen. Accurate.
Well, but in terms of reaching conclusions in digital forensics, you have to make determinations based on a number of factors, correct?
Yes.
Okay. What, if anything, did you do to arrive at the conclusion that...
Objection leading?
On January 9th.
Sir, sustained as to leading.
What, if anything, did you take into consideration in arriving at your conclusion on January 9th, 2023?
For that particular date?
Yes.
I took into account all the information I had at that time as to what was the more likely scenario based on what I had at the time.
Okay. And what was your determination based on this particular executive summary?
That based on what I had at the time, it indicated that the device owner was using the device.
Okay. Now, you've put in this summary January 17th. Is that a significant date?
Yes.
Okay. What's the significance of that?
So that's the conclusion the defense wanted him to get to, right? It was more likely that the device owner was using the device. That's what he wants to get to. All right.
That date.
That was another date that an account was created.
And was that the FetLife account?
Yes.
Okay. And
I thought that
the relationship.
My bad. I thought the FetLife account was created on the 9th. The email address was created on the 9th. He's saying the FetLife account was created on the 17th. Okay.
If any, between the Gmail account that was created on January 9th and the FetLife account that was created on January 17th.
The Gmail account that had been created on January 9th was the email account that was used in the creation of the FetLife account.
Okay. And were you able to determine through your expertise who had control of the device, Christine's devices on that day?
I was able to determine that it was her phone involved in creating that device. I was able to determine that it was her phone used in the creation of that account.
You can't determine who's using her phone, though.
Based on a variety of returns.
And did you make any conclusions at that time that she had not given up her devices?
I had nothing indicating loss of dominion and control at that time.
Okay, and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Her phone wasn't stolen. Her spouse was jumping on her phone when she wasn't around it, if we believe the story that's being told. She did not lose her phone. She did not lose dominion and control of her phone. Her spouse grabbed her phone per the other testimony, but no, it wasn't lost. It was still her phone. No, she hadn't lost her phone. Okay.
Okay, and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Yes.
When did that change?
The co-defendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
No, the zeros and ones did not change.
Okay, so, and zeros and ones.
So you're telling me that you, counsel, decided to call this expert who is now saying that his report is essentially wrong or that his evaluation has changed because he believes what the co-defendant said? Has your opinion changed? Yes. Why? Based on the co-defendant's statements. Oh, so you believe the co-defendant. You believe the co-defendant enough that you've changed your analysis. Oh boy. Oh, I want to see that one more time. Oh boy. So your first, let me just, defense. Your first witness said that They previously investigated a catfishing case where somebody was lured to believe that a sexual encounter was consensual, like in this case. And now your second digital examiner is saying that his report is wrong, or he changed his opinion since the writing of that report based on the co-defendant's statements. Okay. A couple of you in the chat are saying, so he watched the co-defendant's testimony. No, that's not what this indicates to me. It doesn't indicate to me he watched co-defendant's testimony. It indicates to me that he had the proffers when co-defendant decided to take a deal. And that the proffers created the problems with him getting transferred, because the proffer, oh boy, oh boy, oh boy, oh boy.
And did you make any conclusions at that time that she had not given up her devices?
I had nothing indicating loss of dominion and control at that time.
Okay, and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Yes.
When did that change?
The co-defendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
Wow.
No, the zeros and ones did not change.
Okay, so, and zeros and ones, that's binary, right?
Yes.
So your conclusions based on zeros and ones are still the same?
Counsel, you're not going to walk that back to be any better in front of the jury. Because zeros and ones are never going to tell the whole story, especially in a household with multiple other adults. A household with multiple other people. I mean, hell, there's probably a scenario where somebody's like, but I didn't move my phone. And they're like, your phone moved. It's like, right, I have cats. Like, it, counsel, there's other things in the home that you have to account for. Oh boy.
Yes.
The only additional factor is the co-defendant
admitted it,
adopted a different story.
I was provided additional information that had to be taken into account, yes.
Okay. Meaning she told the story that she told the other day here?
Yes.
Okay. Were there any other conclusive digital artifacts that were different in the creation of this report other than the co-defendant testifying differently?
I'm sorry, can you ask the question again?
It wasn't a very artfully worded question.
Are any of them?
There any, so we were just talking about digital analysis, the ones and zeros, right? And that's the thing that you oftentimes work with, correct?
Yes.
And what your testimony was is that the co-defendant's testimony was the thing that changed relating to the January 17th that we were just talking about.
Yes, context is important.
Okay. And was there something other than her accepting, other than her telling the story that she told that day, was there anything about the traditional digital forensics that you had analyzed that had changed?
Not that I recall.
Okay. And that was January 17th, correct? Or was it the entire report?
I was speaking to it as an aggregate.
Okay. And
Counsel, we're at 1.2 device speed still, chat. Counsel, it's really bad. It's really bad for you. Because this expert is having to walk back his report. So if you, defense, if on this witness you thought you were going to like serve something to the prosecution and look at the jury and be like, do you see what the prosecution is hiding from you? This witness turning around being like, well, once there was more information, I changed my opinion. Does it feel like the prosecution is hiding something, or does it feel like the prosecution is just saving everybody's time? Because I don't know how you argue. See, the prosecution's hiding from you. Okay. This is not an officer Dever situation. Oh boy.
Did you have an opportunity to be part of the questioning of Juliana Perez Magalhaes?
No, I was not part of that.
Okay. Were there items within that interview that was in conflict of your findings in digital forensics?
Objection, Foundation.
Are you only a foundation?
Okay. You heard the testimony, correct?
Yes.
I'm speaking of the first time she told the story on October 25th, 2024. You heard those interviews.
Her interviews. Did he watch her testimony? Because it's starting to sound like he might have. Chad, I withdraw my former statement that he didn't watch her testimony, because now I'm not so sure that he didn't watch her testimony, which would be a whole other issue.
Is correct?
Yes.
And so my question is, did you see
I got
conflict?
questions.
What, if any, conflict did you see with your digital forensics findings and her statements on that day?
Nothing is immediately coming to mind.
Okay. Would you have seen her video where she's talking about where Eric Klingen is asking if anybody was on FetLife on a certain day?
Yes, I've seen that.
And your knowledge of digital forensics, you knew why he was asking that.
Objection, leading.
All right, I'll sustain as the leading.
Did you have any idea why he asked that question?
I can't speak to why people choose to ask the questions they do in an interview.
In terms of your digital forensics findings, though, did it make sense why he asked that question?
Oh boy.
I think it would be relevant information.
Okay. And she didn't answer it correctly, correct?
Objection, leading.
Sustain as the leading.
What, if anything, did she...
Juliana didn't remember the dates, did she? Nope. Anyone shocked? Anyone shocked? Is anyone's view of this case shook that Juliana didn't know what dates stuff was happening on? Anyone shocked?
I'll strike that question.
I am not surprised over here, counsel.
After you heard that she had recanted and told this story, did you see an opportunity to be involved in the questioning of her?
I think I know what you mean by that. I would have liked to have been involved, but I was not involved in questioning her at all.
Okay. Looking back on the interview, if you had been involved, could you have assisted them?
I believe so.
Okay. And who were the people that were in the interview room?
Objection, Foundation.
I mean, he said he watched it.
Have a foundation if he knows.
When she was interviewed, there were a number of detectives in there, correct?
I believe so.
Do you know any of the detectives that were in there?
Yes.
Okay. And did you have an opportunity to talk to them about your ability to assist them in her story?
Prior to that?
Yes.
No, I did not have an
Were
opportunity.
you aware that she was doing that?
No, I was not aware until after it had already taken place.
Okay. So they didn't utilize, and were you the digital expert for this case at that time?
Yes.
Okay. So what, if anything, did they do to get information from you to make it a more accurate
Calls for speculation.
questioning of Juliana Perez Magalhaes?
Nothing.
I wasn't able to provide them anything because I didn't know what was happening.
Okay.
Right.
And no one told you that?
Correct.
Okay.
Right. Because they wanted to see what Juliana knows. They weren't like giving her the forensic report and saying, is this right?
The digital forensics. No, so you were transferred, correct?
Yes.
When did that occur?
Roughly a year ago.
Okay. Okay. And what you're doing now is a different form of digital forensics?
Objection, asked and answered.
Overruled. All that makes sense.
I'm using the same skill sets, yes.
Okay. But you don't get involved in cases like this anymore in
So you're not doing digital forensics anymore?
digital forensics?
No.
Okay. When you were still within digital forensics, were you ever asked to change your executive summary that we've looked at?
To change it?
Yes.
I was asked to review it in light of the proffer.
Okay. Were you ever asked to go line by line and fix the conclusions?
Objection leading.
What, if anything, were you ever asked regarding your...
This is kind of painful, but I do want to know if the supervisors one time and were like, do you change your report now? I'm curious about that too.
digital forensics executive summary?
To review it in light of the proffer and ensure I could explain what I had put in that executive summary.
And did you do that?
I reviewed it.
Okay. Was there a change in this document based upon that review?
Like I said, the zeros and ones did not change.
Okay. Is that why you were transferred?
I can't speak to the...
But did you change your executive summary? That's the question. And he did not answer that question. You were asked to go back and check your work, and he's like, the ones and zeros didn't change. Did you change your summary though?
Exact motives behind a transfer.
Bruh.
So, okay. So you were never told why you were transferred?
There was a discussion about the transfer, yes.
Was it related to your executive summary?
It was related to my work in the Banfield case.
Okay, and your work in the Banfield case,
Interesting.
Is it fair to say that it was...
Objection leading.
He hasn't finished the question
yet. Was there any other
yet.
work in the Banfield case other than digital forensics for you?
For me, no.
Okay. So
it was because of this case, and it was because of the digital forensics in this case.
So let's go through that document if we can.
This witness looks pained.
Can you still see it?
Yes, sir.
Okay.
Counsel, do you have a question? We're at 1.25, my guy.
February 18th to until
Lord.
February 23rd, discussions in your report. Do you stand by those same conclusions in those bullet points?
As far as the activity of the devices, yes.
Okay. And the ones and the zeros?
Yes.
And so the only thing that changes that section, and I can keep scrolling if you need to see it, is the fact that...
Judge, I'm sorry, can counsel explain where specifically in the document he's referencing?
The section of January 18th until February 23rd, 2023. Should be on the screen. I scrolled up to it.
Judge, I see a section titled 1219 to 224.
At the very top of the screen, he has the dates.
I see. Thank you.
Okay.
I was just trying to include that whole
That's
section.
fine, too. I think she was just looking on her laptop too.
Okay. Is there anything of the ones and zeros, the binary language, that's changed in that portion of the summary?
No, the data extractions remain the same.
Okay. So the only change is
Your conclusions?
that the co-defendant gave a different story.
Additional evidence came to light, yes.
Is that the additional evidence?
Yes.
Okay.
Oh boy. Chat, I need to know what you think. Let me know. And it's going to be harder for those of you that have seen this trial ahead of where I am watching it. Does it sound to you like he believes the co-defendant? Because the defense question was, so the only thing that changed was that the co-defendant changed her story. And what he said was additional evidence came to light. Not that the co-defendant changed her story. Additional evidence came to light. So the digital forensic examiner for the Commonwealth seems to think that additional evidence came to light. The defense is like, she changed her story. No, sir. It's evidence. Okay.
Do you see the section that says February 18th, 2023?
Yes.
It says starting at 22:44 hours, Christine utilized her
Judge, I'm going to
CV?
object to reading from the document. He can question the witness.
All right, I'll sustain the objection.
Okay, do you, that statement that I was just starting to read, is that still the same?
As far as what the device was doing or the account was doing, yes.
Okay. And the only change that would change that would be that Juliana Perez Magalhaes changed her story.
Yes.
Okay. Let's look at February 19th, 2023.
Oh boy.
Have you read those three?
If I was the prosecution, I might have let him read it because it sounds like what he's reading in is that he was saying Christine was doing things on the devices, which is not appropriate in a forensic evaluation. But that's what that's what counsel was starting to say. Oh boy.
Bullet points?
And again, this is so vague for the jury.
And same question.
The defense is trying to say, okay, so the only thing that changed is the co-defendant changed her story. The co-defendant changed her story. The co-defendant changed her story. Okay, is the prosecution going to get up here and say, okay, so did you believe the co-defendant and that changed your opinions? I mean, what in the world is this?
Is there anything that has changed regarding the ones and zeros, as we talked about, in that section?
No, the data remains the same.
Data remains the same. And have you ever heard the term digital forensics don't lie, people lie?
I've heard it.
Have you ever heard it?
Yes.
Okay. Now, talking about February 19th, the only thing that's changed is Juliana Perez Magalhaes has changed her story, correct?
Yes, the data remains the same.
Data remains the same.
Who's on the phone matters, counsel. He thinks he's doing something. Defense counsel seems to think he's doing something. And I think defense counsel's strategy on this is going to be, ladies and gentlemen, what the phone's doing doesn't change. The co-defendant changed her story. Okay. But the phone created a Gmail account. And the phone created a FetLife account. And it makes no fucking sense that the victim was doing that. So how are we going to connect that the victim was the one doing these things? Okay. This witness looks pained.
219 to 2023, February 19th, until February 24th, 2023. This references Telegram communications. Do those items remain the same?
Yes, the data did not change.
Okay, so I don't want to put words in your mouth, but pretty much everything is the data hasn't changed, correct?
Correct, context did.
Context, and the context is in the form of recantation of Juliana Perez Magalhaes.
Yes.
I don't think she recanted. But okay. The defense keeps saying that Juliana recanted because the defense is trying to say that her first story is the truth and she recanted the truth and then lied. But I don't know if the jury will even...
Same thing?
Yes, sir, the data still hasn't changed.
That.
Okay, and that hasn't changed except for the recant of Juliana Perez Magalhaes.
Yes.
Is that correct?
Yes.
Counsel, I think that context,
So you were
context
asked
matters.
by the person that transferred you to go line by line and change your...
Objection calls for hearsay.
Well, it also misstates what he said previously. He didn't say he was asked to go line by line and change it. He was asked to double check. But okay.
I'll sustain the objection if you want to rephrase.
Who were you asked to change your executive summary by?
Again, I don't believe I was asked to change it. I was asked to review it in light of the proffer.
Okay. And so when you reviewed it in light of the proffer, was there ever another executive summary created after that?
No, I did not create another document.
Okay. So you just reviewed it as you were asked to do?
Correct.
But there's no actual executive summary like you did in this situation?
Correct. I did not create another document.
Did you write another report? Counsel, are you writing your direct examination while staring at the page, hoping that inspiration is going to strike you? What is happening? We're still on 1.25, by the way, chat. We are still on 1.25.
Other than listening to the interviews that Juliana Perez Magalhães gave, did you ever deal with her directly?
No, I had only when I got her phone from her when she was arrested.
Okay. So is it fair to say that you were never in a position to challenge any of the things she said?
I conducted no interviews with her. That's correct.
Were you able to observe whether she was ever challenged on any of the things she said?
Only with the interviews that have been recorded.
Okay. And do you believe that she was challenged on what she was said?
Objection. I'm not sure that that is relevant. His belief.
Calls for speculation.
Rule is relevance.
It also calls for speculation. It also calls for
I'm sorry,
speculation.
could you ask the question again?
Do you believe she was challenged in those interviews?
I think that's a relative term. I can't speak to what the person asking the questions was thinking at the time.
Let me see if I can get us to
It feels that way because it's calling for speculation. It calls for speculation. Correct.
a point where we're understanding each other. As an investigator, if you think that something may not be right, whether it's based on digital forensics or anything, you challenge them, correct?
Yes.
Okay. And that's what you would do if you were in a situation where you were interviewing based upon your work, correct?
My questions would have likely been different, but I don't.
You kind of want to let them tell the story first, though, counsel. You might challenge them later, but you don't want to give them information. Imagine if the interview had gone, Juliana, on this day, this information from this phone, right? Then what defense would come in and say is, well, Juliana made this whole story up from the information that y'all told her. So she doesn't remember it. She's just regurgitating what y'all said. So it goes both ways, right? It's either she made it all up because she had the discovery, or she was never challenged. Just sure.
I can't speak to why somebody would ask what they would ask in an interview they're conducting.
So if somebody says something, generally, if somebody says something that's wrong, you don't challenge them?
I think I would.
Okay. In watching those interviews, were they ever challenged? Was she ever challenged?
Judge, objection calls for speculation. Again, he's testified already that he doesn't know what was in their mind.
And it calls for hearsay. He wasn't there
when they're asking questions.
Speculation.
Well, I'm asking him about his review of the videos. It's not, it's essentially, it's his.
I'll overrule objection. Go ahead. If you can answer.
Yeah. Re-ask the question, sir, please.
Watching the interviews of her recant, you weren't there, correctly? Correct?
Yes, I was not there.
Did you think that she was challenged when she gave the story that she gave?
It appeared to be more of a free-form interview. I did not see direct confrontation on things in that interview.
Okay. And when you say free form, you mean she was just able to tell what she wanted to?
Well, they were going through the details.
Okay. So she was asked about a detail and then she was able to give a story?
Pretty much it was a question and answer format.
You know what?
Okay.
Counsel has been very consistent on calling Juliana's statements a story and a recantation. He has been incredibly consistent on saying it's all just a big story. We have reached some consistency with that. Sure.
And I guess my question is, I use the term challenge. Were there people questioning what she was saying?
In light of
Any of the topics?
You mean the questions in the interview? Were they
I
asking your
don't remember
questions?
anything specifically.
Okay.
Okay. Hold on. Chad, if you are doing all the things you need to do because we're all, snowed in and whatever, and you're working in the background, getting dinner ready or playing, Midas Merge, come on back real quick because somebody hands the defense attorney a couple Post-it notes to bail him out, and the defendant staring at his counsel is quite a look. It's just quite a look. He gets his Post-it notes handed to him from the person helping him, and the defendant is just like, what is happening? Accurate. But no, for those of you asking, does counsel have help? Yes, he is being handed Post-it notes. There is a whole other person sitting behind the table he's at working with him.
What were your conclusions in your executive summary that you wrote before her recant?
That based on the digital evidence I had at the time and the facts known at the time, it indicated that the device owner was responsible for the activity on the device.
And that device owner?
Christine Banfield.
I'm surprised counsel didn't ask this sooner, honestly. The question was, what was your conclusion at the time? His conclusion at the time was that Christine Banfield was doing all the things on her devices. Counsel, okay. So you called the digital forensic examiner in this case, whose original conclusion was that everything done on the devices were Christine Banfield's devices and that she was the one doing it on the devices. And he has said that he has now changed his mind and that it wasn't her doing that. So originally, he agreed with you, and now he agrees with the prosecution's theory of the case. And yet, here we are. Okay.
I have a question.
Cross-examination.
Oh boy.
Put this down.
I am very interested to see what cross-examination is of the digital forensic examiner that the prosecution didn't call. Chat, you're correct. I still have not heard him move the report into evidence. You are correct.
Where do you need it? Take it away. Or just put it down. It's fine. Good afternoon, Detective Miller.
Afternoon.
All right. So you stated, barring external corroboration, it's impossible to put someone behind a screen. Isn't that correct?
That's what he said.
There needs to be corroboration of some sort, yes.
All right. And in this case, when you dug into Christine's phone, Christine's laptop, the information that you received from the external sources, Google, Apple, were you able to put someone concretely behind the screen?
At times, yes.
But throughout the context of all of the conversations that you saw occurring, the activity that you saw occurring on Christine's phone, could you conclusively opine as to who was behind the screen?
No.
Okay. And when you wrote...
She just came in guns blazing, using his words against him. You started this with saying it's impossible to put somebody behind the screen, didn't you? And yet your report seems to say that it was Christine Banfield doing these things on her devices.
This report that Mr. Carroll has referenced, you used the phrasing, Christine did this, Christine did that. Is that correct?
Yes.
Okay. And after additional information and further investigation, you would have changed that to Christine's phone or Christine's laptop. Is that correct?
Correct.
Because again, you can't put someone behind the screen in this case, can you?
Not for everything, correct.
Okay. The evidence itself did not change, correct?
Correct. The data did not change.
You did not change the evidence, correct?
No, I did not change the evidence.
You reviewed how many terabytes of data in this case?
A lot.
A lot. Okay. And in all.
It is so basic that you cannot say, if all you have is a device, you cannot conclusively say who was doing what with the device. You can say the user, and most of the reports say the user. You can't say who the user is. So him writing an entire report saying Christine did this, Christine did that is not appropriate. And it's kind of wild that he did. Maybe this is why he's only testified twice and is no longer in digital forensics. But you can't say who did what. You can say what was done. Oh my God, Lyndon said the IMEI spoke to me. Yes, the crime scene spoke to me. Oh boy. So he changed his conclusions to say, the phone did what the phone did. We can't say who did it. Okay. I don't know if this helps the defense. It's been an interesting day, but I don't know if this helps the defense.
All of that, there was no ability to reach a conclusion that one person was always operating on FetLife, was always operating on Christine's phone when interacting with the Google account that was created to manipulate the FetLife account. Is that correct?
Correct.
All right. There are no artifacts contrary to Juliana Perez Magalhaes' statements regarding the creation of the account, are there?
Not that are coming to mind, no.
No, they could say it is her phone. I agree. Julie B. 6081, Emily, wouldn't that say that based on it's her personal phone though? No, because someone else can access your personal phone. He can say it's Christine's phone. He can say it indicates that it's her device. He can say that the user used a passcode to access the phone, but he can't say that she was using the phone. You don't know if her husband knows her passcode to her phone. You don't know if, she has a 4-year-old, but you don't know if she made her phone passcode like 1111 so her 4-year-old could go watch like Cocomelon on her phone. You don't have any way to know. And even if it's using biometrics, then you would have to establish a lot more to say the phone was unlocked with Face ID. We saw that in the Karen Reed case when they were talking about John O'Keefe's phone being unlocked. They didn't say John O'Keefe unlocked his phone. They said that the phone was unlocked using Face ID. That was it. And then the jury can make their conclusions from there. So you just don't know because you cannot say definitively.
And the only changes that you would have made here is, again, to clarify that there are points at which you cannot tell who is operating the device.
Yes, I would have clarified. It's very difficult to speak about devices constantly saying this person's device, that person's device. I did it with Joseph Ryan's devices, Brenda Banfield's devices, Juliana's devices all throughout. I just called it the person who owned the device using.
All right, so in this case, louder. The digital forensics may not lie, but they didn't provide us with any conclusive evidence of who was operating Christine's phone when the Google account used in conjunction with the FetLife account was created.
Correct.
Okay. You were also asked about your review of Juliana Perez Magalhaes' original proffer that occurred on October 25th. Is that correct?
Yes.
Okay. Were you aware that there was another interview with Juliana that occurred in February?
Yes.
Okay. And did you receive information from Watch?
Yeah, it's wild that he referred to all the devices as the user. Like Joe Ryan did this. This is not good. That might be why he was reassigned, because that is a very imprecise and improper way to write the reports. User of device, last 4 digits, own, whatever. But that's not good. Okay. Well, how would you feel, chat, if you're a juror And the prosecution called this witness and we're like, so all your conclusions were wrong because you don't know who was using the phone, but the devices did what the devices did. Why would you even mess with this witness? I can understand why the prosecution didn't call him. He's a mess to call for the prosecution. He's a much better witness. The defense calls him and is like, you said Christine was using her device. And then he has to walk it back and said, actually, I don't know. And then when I got the additional information from the co-defendant, I changed my mind. This witness is stronger for the prosecution than for the defense. Okay.
The October proffer about what was going on in the room between the detectives and the attorneys that were present. Did anyone show you the notes that were passed? Have you had the opportunity to talk to those individuals about what they might have whispered about when they stepped out of the room?
I did not discuss that with anybody.
Okay, so you have no idea what, if anything, went into the questions that she was asked and whether or not there was effort made.
That's a proper what, if anything. That one. That is a proper what, if anything. You do not know what went into this. We'll allow it. We'll allow that one.
To confirm that her story had additional corroboration. Do you?
Correct.
Okay. Judge, I don't believe I have any other questions.
Right.
Thank you so much.
Redirect.
Sir, do you know why you as the
Wait till you get to the microphone, please.
do you know why you as the expert in digital forensics was not called in the Commonwealth's case?
That's your question? Do you know why you weren't called in the Commonwealth's case? Isn't it obvious? It also calls for speculation. What world do you think that question's proper in, counsel? How is this your question? All right. We're on redirect. And we're out of the gate with, what the fuck is this?
You as the expert in digital forensics was not called in the Commonwealth's case?
I don't.
Were you ever told anything about that?
Objection calls for hearsay.
Overruled.
I just know that they were not advertising it, that they were having the proffer at that time. I found out afterwards it had already taken place.
No, I'm talking about for the trial, for this trial.
I'm sorry, ask your question again then.
So it started with, do you know why you weren't called when you were the expert in digital forensics for this case?
That's where the objection goes, counsel. Calls for speculation.
I can't speak to somebody's motivation for not including me.
Okay.
It's a fair answer.
It's not a hard question to say when you're...
Counsel, you cannot pull the words out of your mouth with your fingers. It's just not going to work. And if you keep touching your mouth, you are going to get everyone in this courtroom sick. Stop touching things. And we're at 1.25, everybody. How long was he standing there with his fingers in his mouth? Oh, boy.
Not watching someone on a device to say digital forensics can't conclusively determine who it is behind the device, correct?
Can you ask it again, please, sir?
Sure. It's not a hard question to ask someone like yourself. You don't know 100% who's behind that device. Isn't that correct?
Objection leading.
I'll sustain as to leading if you want.
Objection, fingers in mouth, fingers on podium microphone stand. Objection. Where's the Purell?
Yes.
What is the likelihood of being able to say someone is using their device with 100% certainty without seeing the person?
Well, that's difficult to do.
Okay. And that's one of the reasons why digital forensics is a valuable tool, correct?
Objection, counsel's testifying.
Would that be leading then?
Yes.
And it's because of, well, the factors that you've described for the ladies and gentlemen of the jury. That's how you arrive at conclusions, correct?
Yes.
But they're not,
Counsel, I see where you're going. I appreciate what you're trying to do. However, he said he's changed his conclusion. You are trying to get him to stick to his previous conclusion. He said he changed his mind. I don't think this is a good idea.
how many times that you've arrived at successful conclusions where you were 100% certain the person who was behind the device?
Never.
I would say only in circumstances where somebody admitted that they were using the device.
Okay. Or you had a camera on them or something like that.
Counsel, how often are you 100% certain someone's using the device? Only when they tell us they're using the device.
Correct. Some kind of corroborative factor.
Okay. Do you have any idea why you were excluded from any of these meetings regarding Juliana's recant?
I can't speak to people's motives to not including me.
Okay. Was there anyone else who was covering the digital forensics arena in your stead?
In general or for a meeting in particular?
For this case.
Did I slip back into normal
No, I was
speed?
pretty much the one who did the analysis.
No, I didn't.
So you were the expert?
Yes.
And who would rely upon your expertise in the ongoing investigation?
The lead detectives.
Okay. And are you talking about Detective Bryant?
Yes.
And Detective Goodell?
Yes.
Okay. And what was the flow of information as you found digital forensics?
We're getting outside the scope of cross, but whatever.
Yes, everything that I processed was ultimately provided directly to Kyle Bryant and other detectives involved in the case.
And did you ever, so I'm asking in the context of like a math equation, did you ever show your work or did you just show your conclusions?
I went through the artifacts with the detectives.
Okay, and that
So
would
yes.
be Kyle Bryant?
Yes.
Not the worst analogy.
Tom Goodell?
Yes.
Any other detectives?
There were a lot of people in meetings.
Okay,
about
so they
this
were,
case.
okay, so you're talking about meetings, but did you ever go in and just talk to them in a granular level as to why you arrived at the conclusions you
He
arrived
said
at?
he showed them the artifacts
Yes.
that he relied on.
And how often would that happen?
There were multiple occasions that I got to a granular level.
Okay. What about the command staff? Did you ever do the
That was
granular
me,
level
sorry.
with the command staff on the digital forensics?
There were multiple meetings where command staff was present and I outlined why I came to the conclusions I came to. But as far as sitting down and going over every artifact, no.
Okay. And would you have been invited to do?
I wanted to make sure I didn't forget to feed my Snorlax some Pokemon sleep to the text information that school is basically going to be closed the rest of the week for us. Oh, I'm not surprised. All right. So anyone who lives in Wilco with me, they canceled school for Wednesday and Thursday already. Travis is going to be thrilled. All right. Continuing on, but yeah, this is something. Karen, don't ask for spoilers. Karen, no spoilers. We got to wait and see.
Do that by the command staff?
Objection calls for speculation.
Sustain that.
Were you ever invited to come in and give the granular details, no matter who they were?
I don't recall providing granular details to command staff.
Okay. And granular, we're talking about to the nitty gritty, right? Just so we're using the same terms.
Judge, objection is to form. I'm not sure how nitty gritty is different from granular.
I'll sustain that objection.
Objection, Your Honor, pish posh.
How would you describe
Oh
granular
my
in the way
God.
we're talking about it?
Painstaking detail, like getting into why that artifact is the way it is, how it came to be there, going through that way. So some of them were down to that level, but not the entirety of the case, no.
Okay. And when you say some of, you're speaking to the people when you say some of them?
Yeah, there were different times throughout this investigation where I would sit down with various different people, and depending on what was desired, I would go through exactly how I arrived where I was. Some people wanted overview, some people wanted to see down to the detail.
Okay.
To the granular level or the nitty gritty, as it were?
All right, is this subject to recall again, or?
Sure, why not?
Okay, so you're still subject to recall.
Are you subject to recall again? Sure.
Detective, so just discuss your testimony with anybody and you're still subject to the rule of witnesses, okay?
Thank you, Ron.
All right, thank you. You're free for today though, I think, now.
Is anyone going to ask him if he moves that into evidence? Is anyone going to ask? Is the court going to ask? Or no?
Yes, sure. He's free for today though, right? Yes. Okay, thank you.
They're approaching. Let's see how that goes. Can we hear what's happening at sidebar? No, but does Judge A's face speak to us? Yes, it sure does. Counsel? My guy? What are we doing? What are we doing? I have no idea what that noise was. Oh, that was George. That scared me. George jumped with the weight of like 1,000 hippos. George, that was so loud. Absolutely scared me. But Judge A's face is facing, which I'm not surprised by. Wow, I'm also not surprised George has left. You now can really no longer see the birds outside nearly as well, but Judge A has much to say to defense counsel, and I'm interested where this goes. You guys heard it too, right? It was loud. It was like, how? I still don't know if this report's in or not. Just what is going on? What a wild day. What a wild day for this case. Clunky doesn't even begin to define how bad this day of trial was. It's just absolutely painful. I'm still curious what we're doing at this prolonged sidebar. And I'm very, very curious. And it looks like the judge was looking at the clock for the day. Deputy Queen is sitting there like, girl, are we done yet? Girl, what are we doing? Are we done? Oh,
because
hold on, I'm going to back up.
To get everything.
Oh, they're done for the day. Oh, that's just it. Okay.
All right, ladies and gentlemen, we try the best intentions to get everything lined up as we can, but it appears that the defense at this point doesn't have any other witnesses that are available today.
The defense's expert was still sitting in the audience. Other dude was still sitting in the audience. Why can't you just call other dude back to the stand now? Other dude was still sitting there. Oh my God. The defense ran out of witnesses. The other expert's literally still sitting there.
All right. So what I want to do with you is if tomorrow we can start at 9:30 and possibly go to 5:30 because I got to make up this hour.
Oh,
shit. I'm chasing a snowstorm. Okay. So
this was in court Wednesday, so it sounds like Thursday is going to be a long day.
9:30 to 5:30 tomorrow. If that's available for everybody, can we do that tomorrow, 9:30 to 5:30? And I know we talked about no Fridays. Attorneys wanted me to float with you if you were available for this Friday. If you're not, that's fine because I told you no Fridays. But if you get back there and you can let the deputy know if all of you are available for Friday, we could do testimony on Friday. Just this snowstorm is just, I'm trying to chase it. I really am. And I want to get as much in as I can.
She did. She really did try. She really did try. And they did not make it. And court is closed. They did do court Friday, but court is closed Monday, Tuesday. We'll see if court's still closed Wednesday, but we're going to be back tomorrow with the next day of trial. So
could before that occurs on Saturday night. So allegedly. So we will see, but you never know around here, but I just a little concerned about it. So if you could just let the deputy know, you don't know tonight or you'll know by tomorrow whether or not Friday is an option, just let her know. And if it's not, I understand because we had told you no Fridays, okay? So anyway, but you're done for tonight.
Do you risk the following week after February 6th?
No, we don't risk it. We are definitely ahead of schedule. We will have this case to you next week, depending on the snow. That's what I'm worried about is if we get 12 inches of snow in this area, we might be out for 3 days next week and we might not be back till Thursday or something like that.
How much snow did y'all get? Fairfax, how much snow did y'all get?
Hopefully not. Hopefully we can get the roads cleared and get you in here as quick as possible. It's my decision whether to close the courthouse. So believe me, I will be trying to get it done as we can. Okay. But I just want to keep that in the ballpark. That's why I'm trying to get the Fridays done just in case, because I just don't know about next week. Okay. But even if we come in Thursday next week, we will still be done by February 6th. I'm pretty confident in that. Okay.
Okay.
All right. So have a good night. Don't talk to anybody about the case and don't do any outside research, please. All right. Thank you. Have a good night.
All right. Thank you, Fairfax, California, for checking in. Jessica's like, Fairfax, California, 0. Fair enough. I want to see if she says anything to the lawyers at the end of Wednesday. Tomorrow we'll go to Thursday.
Jury instructions, are we getting those done?
Yes, ma'am.
Okay, so maybe even if they can't come in on Friday, maybe we can do jury instructions on Friday. Okay?
Well, Your Honor, you did tell them to be prepared for jury instructions on Friday, and yeah, they just weren't though.
Figure it out. All right, thank you. We'll see you tomorrow at 9:30.
All right.
Judge A got off the bench so fucking quick. Look at how fast she's off. Look at how fast she's getting off the bench. She's like, yeah.
We'll see you tomorrow at 9.
Figure it out.
Maybe we can do jury instructions on Friday. Okay, figure it out. All right, thank you. We'll see you tomorrow at 9:30.
All right.
Judge A is off the bench with a swiftness. Oh my. Oh my. Well, at the end of the world as we know. Law nerds, at the end of day 5, I don't know if I can tell you what the defense accomplished other than a full day of court without making much headway. The jury watched body cam footage that they hadn't seen before of the defendant reacting to being told that his wife had died at the hospital. They brought up a very chatty digital forensic examiner, but they hadn't admitted the documents that they needed for their digital forensic examiner to make their conclusions. And so they admitted his background and training and experience and him generally talking about digital forensics and talking about the fact that, digital forensics can't really put the person behind the screen. And then they were just starting to get into the evaluations that expert did and hit the roadblock that they hadn't established the foundation with Detective Miller, who was on the stand for 7 seconds and then was off the stand. And then the digital forensic examiner was off the stand with no questions and no cross-examination. And then Detective Miller was back on the stand. And Detective Miller was on the stand to testify that he did the digital forensic extractions of the devices, though we don't know what devices, because he never said what devices. He said of the devices, but he never specified which devices. He said that he wrote the executive summary with his conclusions, and from all the questioning, it sounds like when Detective Miller wrote his summary that he said that the device owner, Christine Banfield, was the one on her devices and was the one interacting with her devices, and that she was the one using her devices. And then said that when he heard the information from Juliana, which the defense tried to characterize multiple times as recanting or a recant, Detective Miller said new evidence came to light, there was more context because Juliana said she was the one doing it. So the device did what the device did, but I can't say that Christine Banfield was doing those things. And that was a very long, slow, painful slog to get to. In my report, I said it was Christine Banfield doing these things. And then I saw that there was more context. And then I changed my mind. And I can't say that it was Christine Banfield doing these things. It was Christine Banfield's phone. It was Christine Banfield's laptop. But I can't say she was the one using it. And that's where we're at the end of day 5, is that it seems that the digital forensic expert that the defense called agreed that this was a catfishing case. That was my only takeaway from his testimony. And that Detective Miller seems to believe Juliana when she said she was the one using the devices. Well, that was a very full day of court. I just don't know how productive it was. So tomorrow, it looks like Fairfax County will still be closed due to snow, as is where I live. Hopefully where you live is starting to open up again, but where I live is still going to be closed. So we're just going to be here tomorrow. And we're going to look at day 6, and we'll see if Fairfax County is going to be back in court on Wednesday or not. But that's really some of the worst day of trial I think I've ever seen. And I think I need to include like moot court and trial advocacy classes in that, because I think if a trial advocacy law student did that, they might actually get defenestrated out a window. They might actually just be hurled from a building. Like I don't even know how you have that day of trial. It was well, since I'm out of words, I'm just going to quote Ryan Hall, y'all, because that's who I've been watching most of the weekend. That was plumb wild, y'all. I'm interested to see what day 6 brings, and I'm beginning to feel, though it's not accurate, that y'all knew this was coming. Because when the law nerds were like, you've got to cover this case. And I'm like, all right, we'll have plenty of Zoom room. We'll do it. And you guys are like, it's Judge A. And I'm like, you're right. It is Judge A. And you're like, we got to do this case. It was before any of this happened. And y'all were just like, you have to see what's happening. I think y'all just didn't want to be outraged by yourselves. You're like, You know, like when you are playing Bean Boozled or whatever, and you're like, oh my God, this is disgusting. You have to taste it. I feel like that's where we're at. I feel like all of you are like, oh my God, that's horrendous. You have to smell this. I feel like that's where we're at. We're just going to embrace the suck together, because this is painful and it's real frustrating. But I've got popcorn, and I guess that it was a improper expectation of me to believe that all the cases we would watch, we would see some great lawyering, because that's not always going to be the case. And this has been frustrating to watch. I want lawyers to do their jobs well. I think it's pretty clear that I do not have warm feelings for this defendant. But everyone deserves a good defense. And at the end of day 5, I am frustrated for the defendant, who has to be sitting there. He is on trial for his life, watching his attorney do this. That has to be incredibly frustrating. I don't know if a better lawyer would change the outcome of this case, but this lawyer is not having good days in court, and the lack of organization is appalling and incredibly frustrating to watch. And I expect people to come into court and do better. This is a murder trial. I expect you to wear a suit. I expect you to try your case. I expect you to be organized. Not everything's going to go perfectly. Even great attorneys have rocky days in court. But the lack of preparedness is avoidable, and the lack of organization is apparent. And I am frustrated. I am really frustrated for this judge. I am really frustrated for the jurors, and I'm really frustrated on behalf of the defendant's family and all the victims' family. Can you imagine how frustrating it must be for all of them? Oh boy. Well, I imagine day 6 is going to be, I imagine it's going to be more of this, but I guess now I'm just going to wait and see when the defense is going to call back their expert, because at the end of day 5, the defense, it seemed like, had an hour left of court time. We know how Judge A feels about using court time. Had about an hour left of court time, and the defense expert that had been dismissed was still there. Why not just call him back? And I still don't think, unless they did it at sidebar, I still don't think that the defense admitted the report from Detective Miller, because we never heard him say that he's moving it into evidence. I will say, on a positive note, the defense attorney has consistently referred to Juliana's testimony as a recant or a story. That's been consistent. And we have not seen a case where a defendant has tried to argue heat of passion. And that will be something that will be new for us if the defendant takes the stand and tries to say this was heat of passion or self-defense, defense of others. That will be new. And either way, we're together watching trial. And really, isn't that the point? Because, at least we can just come watch trial and disassociate from everything else for a while. It's easier to channel the rage at the defense attorney. We'll just put it on him for now. We'll just be like, what are you doing? Counsel, just be organized. Court is just a controlled environment. We would just like a controlled environment where things go the way that they're supposed to, please. That would be nice. Oh, law nerds, what a why, just. I just don't even know what to do with this. We're going to answer some questions. You've got questions. I've got questions. We're going to do some questions, and then we're going to roll, because it is a snow day. I'm going to go hang out with the kiddos because it's a snow day. But I do love seeing Judge A. Which makes me very happy. Jammy Mama said, I have a very snuggly 3.5-year-old watching and still hope for Law Nerds Kids merch. We have it in mind. It is not going to be in this next merch drop. It is much harder to accommodate for all of the sizes with kiddos, but it is on my mind. It is not something we have forgotten about. It's just trying to make all the merch things work. Fluffy Buddy 12 and everyone who gifted memberships, thank you all for the gifted memberships. You guys are incredibly generous, and you are so, so kind. Thank you. X Only Jojo. Hi, EDB mods in chat. Finally able to join you guys. Good to see you. Good to see you in the chat, Jojo. And good to see everybody. Terry Needs Coffee. Did you lose power at all? My brother lives between Murfreesboro and Franklin. He lost power and recently got it back. We did not lose power. Lots and lots and lots of people did. We also have a generator. We have a permanent generator because of doing this. So we also have that. But we did not lose power, though. I've learned lots about how TVA processes power to different parts of Tennessee. In the last 2 days, I've learned quite a lot. So we have power, but I did see more than one Waffle House in our area closed, one in Murfreesboro and a few others. Yep. Andy said, catching up on popular opinion, not unpopular. I think Judge A may indeed say respectfully, what the fuck? She is a Marine. She may even toss a well-placed foobar in chambers. I definitely think Judge A would curse in chambers. I don't think she would curse at the attorneys. Judge A's courtroom demeanor has been steadfast and polite. Do I think she would curse the attorneys out behind their back? Probably. The lack of organization, because even when Elaine Bredehoft was frustrated, there were times that it was not her fault. There were times that Elaine's frustration was with her client, and you could see it. When Elaine's like, I'm trying, Your Honor, part of it was her client. And I have a lot of empathy for that. But Elaine did not seem like a trial attorney that was in trial all the time. And so she was operating like she was in a deposition, not in a trial. And there were times that was very frustrating. But they were organized for the most part. This is not. Mildred said 18 inches and counting came into work today. You must have all of the snow tires. I don't know if anyone around here even has snow tires. I didn't know people change their tires out seasonally. I wasn't aware, but here we are. Casp asked, everybody wants to get to this lawyer's ineffective assistance of counsel. When I tell you that the bar for that is incredibly low, incredibly high. Getting to ineffective assistance is almost an insurmountable bar. Like, the attorney's behavior has to be basically that you fell asleep the entire trial and drooled, and that's all you did. This attorney has objected, called witnesses. These strategic choices are not going to be IAC. These are strategic choices. The choices might not pan out well, but this attorney is calling witnesses, making choices, making motions, making objections. IAC is really where counsel either does not participate at all in the case or fundamentally misses something like not making a motion to dismiss at the end of the prosecution's case. It is very hard to get there. Clunky and the rest of it is not going to come even close, even though it's painful to watch. It's tough. We have definitely hit code facepalm in this case. It's been a lot, but you guys have a lot of questions about IAC. It's not there. The cases on IAC are the actions of counsel are so bad. This is not. 130 Sarah M in the chat said, can you claim IAC if you defend yourself? No. Daryl Brooks can't get up there and argue ineffective assistance of counsel because he was his own counsel. No, you can't. You can't. I know Kate's the Great said, question, do you know a guy named Brian from Massachusetts? I know the fact that we never got to ask that expert FBI guy about Massachusetts more was wild. It's Rob Dog says, one of my most favorite streams ever. Thanks, EDB. Today was frustrating. Heartless Soul said, dairy farmer in Ohio, 16 inches and went to work at 3 a.m. I mean, the thing about farm life is it seems like you don't really get a day off for farm life regardless of weather. Thank you for what you do. And I'm so sorry. That must have been very cold and incredibly snowy, because that is a lot. That is a lot. Melody asked this earlier today. Melody, certified sleepy law nerd. Isn't it normal to list more witnesses than what is actually called on both sides? Yes. Yes. Cat Johns, will the defendant testify in this case? I think they have done everything they can to position the defendant to testify. Then again, the defendant might change his mind, but if he changes his mind, the jury instructions regarding heat of passion and those things will not be available to him. He would have to testify. Different than other cases we've seen, this defendant is in a position where if the jury does not believe Juliana, and if he testifies, look, this encounter was set up and Joseph Ryan stabbed Christine and I came in and broke it up and shot him, could the jury reduce his punishment for shooting Joseph Ryan and find him not guilty of shooting Christine Banfield if they believe him? That's possible. Having an alternate explanation is different than like an Alec Murdaugh getting up and being like, I don't know who did it. I didn't do it. I came home and this is what I found. Brian Walsh would have been in the same position. I don't know. She left in an Uber that she never left in. And then she was dead, and there's all these buckets. I don't know. By the way, I can't look at a Lowe's bucket, a Home Depot bucket. There was some movie chain that was doing a bring a bucket popcorn day, and people are like in the commercial with like a Lowe's bucket. I'm like, nope. Nope. Can't look at it the same. Nope. Can't look at it. Don't want to see it. Nope. But what's Banfield going to testify to? She left for the airport and I don't know what happened. Not Banfield, Walsh. Banfield has actually an alternative version of events and can make the jury look at whether they believe Juliana or whether they believe him. He has more like Sarah Boone, where Sarah Boone very much thought she had an explanation that the jury would believe. Sarah Boone had an alternate version of the events. And that's why we saw her testify. What do you think? Is Banfield more like Sarah Boone? Or more like, I don't know, Donna Adelson and Brian Walsh? So I think we're probably going to get more like Sarah Boone. So I think that's where we're going to end up with this defendant. I think he might testify. He has more reason to testify than some of the others. Chat saying it was Cinemark. I got my bucket of popcorn on Monday. Look, it's a great idea. I think the idea is fantastic. But when I saw like Lowe's buckets of popcorns, I was like, I can't. I just can't. So we will see. Yankee Law Nerd said here, since Depp, the best channel for Trial Watch. I mean, we are the number one trial channel. Yes, we are. I appreciate it because the Law Nerds are the most fun. So we'll see. We'll see if we get there, but I will keep you posted. A reminder, get the Law Nerd app at lawnerdapp.com. We're going to be catching up with trial as best we can. And we'll just play it day by day with the weather. And we'll do our best to catch up in real time. If we need to condense Friday, we will condense Friday. I'm sure we're going to zoom as much as we can tomorrow. It's going to be longer. It was a longer court day. And we'll see when court's back in. We know there's no live court tomorrow. We'll see if court's in on Wednesday. If court's in on Wednesday, we might just jump to live court. We'll see. And maybe just try to condense Friday another time or do half and half. It's just going to depend on the day. So, Law Nerds, it's just going to depend. Glittery Pickle, I did not hear there was supposed to be more snow this week, and that would not bode well for me. So hopefully not. But with that, Mods and Team Baker, thank you for agreeing to ride on a Monday. I appreciate it. I know that that is challenging. I'm going to talk to the family and see what time I can start tomorrow. I will let you know in the Law Nerd app. I will message that out tonight once I decide what time we're streaming tomorrow. I will try to be a little bit earlier tomorrow than today. I had meetings this morning, and we're going to go from there. So Law Nerds, buckle up, stay warm. I hope you have power, and we will see you in court tomorrow for whatever that brings. We're gonna just do that together and see what happens. Because I really don't know. I have concerns, but we'll see you for day 6. All right, Law Nerds, take care. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.